I sentence you to life in confinement without parole.
That's f***ing horse shit. You do whatever the f*** you want.
Stop shutting my mic off, please.
Your Honor.
Why are they shutting my mic off?
Because he's talking.
I'm the federal witness of the United States federal government. I demand some goddamn respect, you. All I did was trespass on property.
Ma'am, you got to create the community that you want to live in.
Bond court is a free service, but it takes several hours of my time every day. Less than 10% of Bond court viewers hit the like button, and less than 1% leave a comment. If you want Bond court to continue to be available on YouTube for free, then please hit the like button and leave a comment on all of my videos.
And let me swear you in real quick, Mr. Pham. Would you raise your right hand for me, please?
Yes, sir.
Do you swear affirm to the best of your knowledge, skill, and training that you would translate these proceedings here today?
I do, Your Honor.
Thank you. You can put your hand down, Mr. Bo.
Anh Tài bỏ tay xuống đi.
Mr. Bo, can you hear and understand the interpreter?
Anh Tài, anh có nghe, anh có hiểu tôi nói không?
Anh nói tiếng Việt thì tôi hiểu, nói tiếng Anh tôi không hiểu.
Ok, tôi nói tiếng Việt anh hiểu không?
Hiểu.
Yes, sir, I do.
Mr. Bo, this is your first appearance proceeding before the Magistrate Court of Clayton County.
Anh Tài, đây là cái đầu tiên, cái lần đầu tiên anh ra trước mặt tòa của Clayton, ok?
I am Brad Gardner, and I'm the Magistrate Court Judge here today.
Tên tôi là Brad Gardner, tôi là chủ tọa của cái phiên tòa này.
I'm here to tell you that you've been charged with one count of battery.
Nay để tôi nói cho anh biết là anh bị công tố về cái tội mà ấu đả, anh đánh người ta.
Tôi có nói lại được không? Tôi nói lại
nếu hôm nay là chúng tôi phạt anh về công tố về cái tội là ấu đả, cái tội mà đánh lộn.
Mày tôi nói nghe là tại tôi là cha, thằng kia nó con, nó nghe là tôi nó lấy đồ nó liền hết, nó là chủ nhà, nó có quyền nó làm hỏi anh nói gì rồi tôi thoải mái được, rồi tôi ấy nó sầu nó làm tôi bấy tay chân nó làm tùm lum la, cho nhiều khi nó dốc cho cảnh sát để cảnh sát bắt tôi.
Your Honor, he's trying to explain what's going on. Can I ask him to stop that?
Yes, I was gonna. I don't even want to hear the translation for what he just said.
Right.
Would you please tell him that these proceedings are being recorded, and I'm here just to give him some basic information.
Anh Tài, hôm nay á, là những cái chi tiết mà anh đánh lộn đó là chúng tôi không có muốn nghe, không phải hôm nay là để nghe những cái vụ đó, chi tiết đó sẽ tính sau những cái vụ tòa sau. Hôm nay á, là tôi chỉ là giải thích cho anh những cái quyền lợi của anh và trong tòa cái thủ tục trong tòa là làm sao nha.
I will allow him to ask questions at the end if he have any, but I would not discuss the facts of his case.
Bây giờ đó là anh sẽ được hỏi khi mà tôi giải thích những cái điều khoản trong tòa cho anh xong, rồi anh hỏi, nhưng mà anh không, trong lúc mà tôi giải thích đó, là anh nghe cho tới khi nào mà tôi trình bày xong rồi anh mới được hỏi, ok? Yes.
Your bond will be set at $5,000.
Cái tiền mà tài ngoại hầu cha của anh đó là 5.000 đồng.
You may post that bond by cash, commercial, or property.
Thì cái tiền đó là anh có thể là đóng bằng tiền mặt hoặc là bằng nhà cửa, tài sản của anh nếu anh có, hoặc là mướn cái người mà người ta cái công ty mà bond đó.
You can pay the entire amount of the bond in cash to the sheriff, who will hold it until your case is over.
Rồi cái số tiền 5.000 đồng đó là anh có thể đưa cho cái sheriff sẽ giữ cái tiền đó cho anh cho tới khi mà cái kê của anh xong.
When your case is over, the sheriff will return the money to you.
Khi mà anh ra tòa giải quyết cái kê của anh xong á, cái 5.000 đồng đó là trả lại cho anh.
You can also post bond by commercial, which commonly is known as using a bonding company.
Rồi anh có thể, ngoài nếu anh không có 5.000 đó thì là anh có thể nhờ những cái công ty mà nó là bonding, người ta sẽ ứng cái tiền đó cho anh.
Bonding company will charge you a fee to post your bond.
Nhưng mà khi mà nhờ những cái công ty mà để mà post cái bond cho anh đó, người ta sẽ trả cái tiền fee.
The fee is normally between 10 and 12% of the bond amount.
Cái tiền fee đó thường là khoảng 10 tới 12% cái tiền bond của anh.
The fee that you pay to the bonding company is non-refundable.
Thì cái tiền fee đó là mình không có lấy lại được.
You can also use property to post a bond.
Ngoài ra nếu mà trường hợp mà anh mà có tài sản, anh có dùng tài sản của anh thì anh có thể dùng nó để mà thế cho cái tiền bond.
The property will need to have a net equity at least 3 times the bond amount.
Thì cái tài sản của anh đó là giá trị là phải bằng là từ 15.000 trở lên thì anh mới được dùng, tức là gấp 3 lần cái tiền bond.
The sheriff's company will place a lien on the property.
Rồi khi mà anh đặt cái tài sản anh lên đó thì cái sheriff đó là họ sẽ để cái tiền bond đó là trong cái để một cái lien đó ở trong căn nhà của anh.
And when your case is over, they will remove the lien.
Rồi cho tới khi mà cái kê của anh ra tòa mà giải quyết xong xuôi đó thì là người ta sẽ bỏ cái lien đó ra.
You will have a special condition on your bond to stay away from son, Tony vote.
Nhưng mà trong lúc mà anh tại ngoại hầu cha đó thì là bắt buộc là anh phải xa lánh cái người mà tên con trai của anh là son Tony Vũ, anh không có được gần nó.
If you were to violate this bond condition, you could face additional felony charges.
Thì nếu mà trường hợp trong lúc tại ngoại hầu cha mà anh mà vi phạm cái đó là anh sẽ bị phạt và về cái tội hình sự nữa đó.
Your bond could be revoked and you could remain in jail until the end of
Thì
your
lúc
case.
đó là cái số tiền mà bond đó là tôi sẽ lấy lại và tôi sẽ hủy bỏ cái điều khoản đó và anh sẽ bị vô tù lại đó.
Do you understand the stay away provision?
Đó, anh có hiểu chưa?
Hỏi anh được không?
Can I ask the question chứ?
Yes.
Rồi hỏi đi.
Tôi nói anh ấy, bây giờ tôi kể cái chuyện con á, ví dụ tôi bệnh hoạn, tôi không đi bác sĩ hay là đi nhà thương á, đáng lẽ nó làm con nó phải chở, nó thích kè tôi, cái ngày nó không thích kè tôi phải nhờ chị tôi chở tôi đi. Hỏi anh cái đó làm gì đúng không mà nó làm đủ chuyện như vậy?
Just he didn't ask the question. He just try to tell you what's going on. I mean, like he was saying, I have a son and I'm sick, and he's supposed to help me out, and then
Hold on.
that's what he.
No, I understand. I just don't want to hear the facts. Just remind him this is not the time to hear the facts of his case.
Là những cái chi tiết đó là tôi chưa có nghe được đâu. Tôi chỉ những cái điều đó anh giữ lại để những cái kỳ tòa sau thì anh mới nói nha. Hôm nay chúng tôi không có nghe những cái nội vụ của anh với lại con anh. Ok.
Ask if he would like for me to appoint a lawyer for him.
Ok, bây giờ anh có muốn tôi giúp đỡ anh cung cấp cho anh một cái luật sư công không?
Cái đó mà có tốn tiền tôi đâu có đi làm đâu. Tôi bệnh tôi đâu có làm.
Thì cái luật I don't have money to pay him your because I'm sick. I don't have money.
I can provide a lawyer for free.
Cái luật sư mà tôi cử cho anh đó là không có tốn tiền nha. Yes sir.
I'm going to appoint a lawyer to represent you.
Ok, vậy tôi sẽ cho một luật sư để mà giúp anh, mà anh không có cần phải trả đồng nào hết. Ok.
You will have a preliminary hearing date set for May 10th at 8:30 in the morning.
Rồi cái lần tòa tới của anh đó là 10 tây tháng 5. You say 8:30 in the morning, John? Sao?
Yes, sir. Yes, sir.
8 giờ 30 sáng, ok. 8 giờ 30 sáng ngày 10 tháng 5, ok.
That date will get waived upon your bonding out and you will receive a new court date in the mail.
Rồi nếu mà trường hợp mà anh được tại ngoại hầu tra đó thì người ta sẽ cho anh một cái phiên tòa khác, ok.
Finally, I have to advise you of certain rights.
Đó thì tôi đã cung cấp cho anh biết về cái điều khoản những cái quyền lợi của anh đó.
Chứ họ hỏi là cái đó là 10 giờ sáng thứ năm hả?
I want to ask you, is that May 10, 8:30?
Yes, sir. Yes, sir.
Đúng rồi, ngày 10 tây tháng 5 nghe, nhưng anh nghe nha, 10 tây tháng 5 lúc 8 giờ rưỡi. Yes, sir.
8 rưỡi hả?
You have the following rights to the presumption of innocence.
Thì ở trong cái lúc mà đi ra tòa đó là anh được có quyền là anh không có tội gì hết.
That's why we don't discuss the facts of your case.
Nó thành thử là mình không có bàn về vấn đề cái kê của anh bữa nay.
You have the right to an indictment by a grand jury for most felonies or by accusation for misdemeanors.
Rồi anh được quyền là những cái phiên tòa đó người ta có thể công tố anh bằng cái bồi thẩm đoàn hoặc là người ta làm như vậy.
You have the right to a speedy and public trial by jury.
Rồi anh được quyền là đi ra tòa nhanh chóng để giải quyết cái vấn đề của anh bằng bồi thẩm đoàn. Anh nghe nè.
I'm not done yet.
Tôi chưa xong, anh nghe nè.
To see, hear and question witnesses who are called to testify against you.
Rồi lúc mà đi ra tòa đó là anh được quyền là chất vấn những cái nhân chứng nó công tố anh.
To compel the attendance of witnesses to testify on your behalf.
Rồi anh được quyền yêu cầu những người đi ra tòa để mà làm nhân chứng giúp đỡ anh.
To testify on your own behalf or offer evidence in your own defense.
Rồi cái lúc đó là anh có thể ra đó, anh có thể ra nói cái án của anh, lúc đó là cái cơ hội để anh sẽ trình bày cho tòa biết.
Mr. Pham, you were buffering for a second. Would you just repeat that?
Khi mà đi ra tòa đó là anh được quyền, có thể là anh được quyền chống án, dùng những cái nhân chứng và bằng chứng để giúp đỡ anh.
Finally, you have the right to an attorney and I've appointed one to represent you.
Và cuối cùng là anh được quyền có một luật sư và tôi đã cung cấp cho anh một luật sư công, không có tốn tiền.
Now, Mr. Vo, this is a time to ask me questions as long as you're not discussing the facts of your case.
Ok, bây giờ đó tôi nói xong rồi, anh được quyền hỏi, nhưng mà tôi không muốn nghe những cái chi tiết về anh có thắc mắc gì anh hỏi, nhưng mà tôi không có muốn nghe những cái chi tiết về cái kê của anh.
Muốn hỏi là ví dụ bây giờ bữa nay tôi có về được không? Tôi về rồi tôi ở đâu hay sao?
Anh hỏi sao? Anh hỏi là bây giờ anh có về được không hả?
Tôi về rồi tôi ở đâu?
I want to ask you a question. Can I get out of jail? And when I get out of jail, where do I live? Where do I stay?
So the stay away provision is not located, scratch that. The stay away provision is regarding staying away from your son. It doesn't prevent you from staying at any location where your son is not staying.
anh về đó thì cái luật là anh về là anh ở đâu ở đâu cũng được, miễn là anh không cần con trai anh thôi.
Nhưng mà hỏi nữa, ổng ví dụ tôi về tôi lấy đồ tôi đem đi được không?
Can I get my personal belonging so I can move out?
Yes, as you're bonding out, make arrangements with the sheriff's department so that you can obtain your things.
Rồi được, cái khi mà anh mà tại ngoại hầu tra đó thì anh nói với lại cái người sheriff đó là anh nói nhờ người ta thì người ta sẽ dẫn anh tới cái nhà đó, anh lấy đồ của anh ra.
Chừng nào tôi có hầu tra?
When can I bail out?
This information will be provided to the sheriff's department today by me, but I have to wait until I'm done with this hearing.
Yeah. Những cái chi tiết á, là người cảnh sát ở trong tù á, người ta sẽ cung cấp cho anh. Tôi sẽ cung cấp cho cảnh sát biết, rồi cảnh sát sẽ thông báo cho anh biết sau. Ok?
Bây giờ tôi sao chuyện nào biết? Tôi đại hả sao?
Anh nói sao?
Nói bây giờ chừng nào tôi mới về cảnh sát chở lấy đồ.
I wanted to know when can I get out of the jail, so can I go back to get my belonging?
I will repeat, as you're bonding out, make an appointment through the sheriff's department so that a police officer can be present
Đó,
and
thì
you can obtain your things.
khi mà anh được tại ngoại hầu tra, anh dùng tiền anh đóng hoặc anh nhờ người tới để bail anh ra, thì cái lúc đó đó là người ta sẽ thả anh ra và anh sẽ nhờ cảnh sát tới nhà anh, dẫn anh tới để lấy đồ anh ra. Anh nghe không?
Cảnh sát thì nghĩa là tòa cảnh sát đưa sao tôi đâu có biết anh tôi cậu cảnh sát.
I don't know how to talk to the sheriff.
Honestly, I don't know their procedures as it relates to a person that speaks Vietnamese.
Tôi cũng không biết cách nào hết, thì tôi cũng không có thể nào mà giúp đỡ anh ngoài trừ là những cái lời mà tôi giải thích cho anh thôi.
Cái cảnh sát là cảnh sát để tôi giờ có ai giúp đỡ tôi cái vụ đó? Bây giờ kêu cảnh sát đó, cảnh sát kêu cảnh sát gì?
So what kind of police or what kind of sheriff who can help me?
You have to discuss that with the sheriff's department.
Chút vô trong cái trong tòa, anh gặp những cái người cảnh sát đó, anh nói chuyện với người cảnh sát đó, người cảnh sát đó sẽ giúp anh.
Rồi bây giờ tôi đợi tôi chờ ra tòa hay sao?
So from now on, I'm waiting for my next court date.
Once you bond out, you will receive a new court date in the mail.
Khi mà anh bail out đó, khi anh được tại ngoại hầu tra đó, thì người ta sẽ gửi một cái ngày khác, một cái ngày khác để anh đi hầu tòa. Ok.
Bây giờ là sao? Bây giờ là tôi về tôi nhờ ai gọi dùng cái chỗ cái số điện thoại điện qua, nó nói là cái một dãy số điện thoại đó gọi điện tổng, người ta nói tôi biết là bữa nay tòa kêu tôi mà đeo cả 5.000 vậy. Rồi bây giờ lấy cái số điện thoại đó gọi cái người đó, người đó cho tôi biết sao là hôm qua nói sao tôi hiểu rồi cái chỗ nó cho tôi biết là tôi đóng bao nhiêu rồi tôi có không, phải không?
So when I don't know what, I have the phone number to call and find out how much do I pay to get out. So let me know that when somebody help me?
Yes, but that's more on the sheriff's side, because he's there. They're the ones that can assist him in doing what he have to do to bond out.
Khi anh đi vô, bây giờ anh đi vô trở lại tù đi, thì những cái người cảnh sát ở trong đó người ta sẽ giúp đỡ anh.
Mình không biết anh này sao mà người ta giúp đỡ mình đâu biết nói gì đâu mà người ta giúp đỡ.
So I don't know how to talk to them. So how can they help me?
The same way that we're speaking here, we had to get an interpreter.
Thì khi mà vô trong đó thì có thể là những cái người ở trong tòa, những cái người cảnh sát đó sẽ giúp anh bằng một cái người thông dịch viên.
Rồi vậy bây giờ sao? Bây giờ biết là chừng nào tôi go out, chừng nào tôi về được.
Just he asking the same question. When can I go out?
Okay, Mr. Vo, I have answered your questions. I have other people I have to get to. The longer we sit here and talk, the longer you're going to sit in jail.
Anh Võ, tôi còn nhiều người sau anh lắm. Thành thử là anh đi vô trong đó đi, rồi những cái người ở trong đó người ta sẽ giúp đỡ anh. Tôi đã trả lời câu hỏi anh rồi, nhưng mà anh cứ hỏi lại được cũng cái câu hỏi như vậy thì tôi không biết nó làm sao. Thành thử bây giờ anh đi vô lại tù đi nha.
Bởi tôi đi vô cảnh sát này hỏi nè.
So I'm going to the jail now.
You're in the jail.
Anh đang ở trong tù đó. Bây giờ anh vô đi.
Tôi hỏi cảnh sát phải không?
So I can ask the sheriff here, right?
Deputy Requena, are you still there?
Yes, Your Honor.
Can you explain to the people in bonding or whomever the need to have a translator for Mr. Vo?
Trước nói với lại cái ông cảnh sát đó là khi mà sẽ có người thông dịch đó nói chuyện với anh để giải thích cho anh cái cách làm sao để cho anh ra. Ok, anh về đi.
Okay, thank you. Thank you, Mr. Pham.
You're welcome, Judge.
You have a good day, sir.
Same to you, sir.
Ms. Bermudez, how are you doing today?
Good morning, Judge. I'm well. How are you?
I'm doing well. We got a backup. Deputy Requena, would you bring up Mr. Aguilar, Mr. Martinez, and Mr. Sanchez?
I'm
sorry.
I only have Mr. Sanchez, Judge.
Okay, hold on one second. I'll because there's Mr. Martinez, we may not even need to address him, but Mr. Aguilar and Mr. Martinez were continued from yesterday.
Okay.
So you probably don't see it if you have just a regular sheet, because there's a special sheet that they're on.
Yes, sir.
Yeah,
I guess that's the reason.
I'm sorry, Deja. Good morning.
Good morning.
I have Mr. Martinez was going to be continued, but I was on the call with Judge Knight, and we did Mr. Martinez.
That's what Deputy Requena said. But he wrote on the bond sheet, the bond order, he still has continued on it or continue on it.
Well, that's because we were going to continue him, and Requena, correct me if I'm wrong, but I think Martinez wanted to be heard.
That's correct.
No, I understand all of that. The reason I think we have it is because the bond order that I have from yesterday says continue on it.
Yeah,
it was never changed. It was never changed.
Yeah, he should have, because we did do him, but I guess you can do him again.
No, I just wanted to, because it said continued on it and I got it, I just wanted to make certain. Deputy Requena told me, but I didn't want this to be a situation where it just falls through the cracks. Because
no, I have written down that he had a $5,000 bond. His preliminary hearing is May 10th at 8:30.
No, Ms. Mayor, I have all of that. All I'm saying is that on the bond order that I have from yesterday, on the front of the bond order, it says continue.
Okay.
You know how Judge Knight writes on it, continue? Like Aguilar says continue to 4/18/2022. Martinez has just continued on it.
Okay,
So I'll take that representation. Mr. Martinez can go back, but I guess his bond order is not in the system since it came back. Okay, so we'll just deal with Mr. Sanchez and Mr. Aguilar. Mr. Aguilar, Ms. Bermudez is charged with the offense of battery. His warrant number is 2022 WA 06631.
Your Honor, Aguilar's gonna be on the female side.
Oh, okay. Can we bring up Aguilar on the female side?
She's present, Your Honor.
Okay. And we have Sanchez.
Yes.
Mr. Sanchez and Miss Aguilar. First with Mr. Sanchez. Can you hear and understand the interpreter?
Señor Sánchez y señorita Aguilar. Primero con el señor Sánchez. Señor Sánchez, ¿puede usted escuchar y entender a la intérprete?
Sí.
Yes.
Miss Aguilar, can you hear and understand the interpreter?
Señorita Aguilar, ¿puede usted escuchar y entender a la intérprete? Yes.
Miss Aguilar, you're charged with 1 count of battery.
Señorita Aguilar, a usted se le acusa de un cargo de agresión corporal.
You're going to have a $5,000 bond.
Usted va a tener una fianza de $5,000.
You're going to have a preliminary hearing date set for May 10th at 8:30 in the morning.
Usted va a tener una audiencia preliminar programada para el día 10 de mayo a las 8:30 de la mañana.
Mr. Sanchez, you're charged with 1 count of DUI.
Señor Sánchez, a usted se le acusa de un cargo de manejar bajo estado de embriaguez.
Your bond is going to be set at $5,000 for that offense.
Su fianza por este delito va a ser de $5,000.
You have 1 count of driving a vehicle without a license.
Usted tiene un cargo de manejar un vehículo sin licencia de conducir.
Bond is going to be set at $1,000 for that offense.
Por ese delito su fianza va a ser de $1,000.
You're charged with 1 count of an open container violation.
Usted tiene un cargo de tener un envase alcohólico abierto.
Bond is set at $500.
Su fianza va a ser de $500.
You're charged with 1 count of following too close.
Tiene un cargo de seguir otro vehículo muy de cerca.
Bond is set at $500 also.
Y su fianza también va a ser de $500.
Your total bond is going to be $7,000.
Su fianza total va a ser de $7,000.
Your preliminary hearing date is also going to be set for May 10th at 8:30 in the morning.
Su audiencia preliminar también va a estar fija para el día 10 de mayo a las 8:30 de la mañana
In courtroom 201.
en la sala 201.
Mr. Sanchez, do you want me to see if you qualify for the appointment of a lawyer?
Señor Sánchez, ¿quiere usted que yo vea si usted califica para nombrarle un abogado de oficio?
Está bien, yo quería pagar. ¿Cómo se pagaría?
That's fine. I would like to pay. How can I pay?
Okay. Do you want me to appoint a lawyer to represent you? Yes or no?
Ok. ¿Quiere usted que yo le nombre un abogado para que lo represente? ¿Sí o no?
Sí.
Yes.
Are you currently working?
Actualmente, ¿está usted trabajando?
Sí.
Yes.
Approximately how much do you make per hour?
Aproximadamente, ¿cuánto gana usted por hora?
$20.
$20.
I'm going to find that you qualify. I'm going to appoint a lawyer to represent you.
Yo voy a encontrar que usted sí califica y le voy a nombrar un abogado para que lo represente.
Ms. Aguilar, would you like for me to see if you qualify for the appointment of a lawyer?
Señorita Aguilar, ¿quiere usted que yo vea si usted califica para que se le nombre un abogado de oficio?
Sí.
Yes.
Are you currently working, ma'am?
Actualmente, ¿está usted trabajando, señorita?
No.
No.
I'm going to find that you qualify. I'm going to appoint a lawyer to represent you.
Yo voy a encontrar que usted sí califica y le voy a nombrar un abogado para que la represente.
Now, I need the both of you to listen And I will allow either one of you, if you have questions at the end, to ask a question, okay?
Ok, ahora yo necesito que ustedes dos escuchen y yo les voy a permitir a ustedes dos que si tienen alguna pregunta la hagan al final. ¿Está bien?
Sí.
Yes.
This is your first appearance hearing before the Magistrate Court of Clayton County.
Esta es su comparecencia inicial ante el Tribunal de Primera Instancia del Condado de Clayton.
My name is Brad Gardner, and I'm a judge in this court.
Mi nombre es Brad Gardner y yo soy un juez en este tribunal.
I'm not here to have a trial of your case or to have you enter a guilty plea in this case.
Yo no estoy acá para tener un juicio en su caso o para aceptar una declaración de culpabilidad en este caso.
In addition to the information I just gave you, I also have to inform you of certain rights.
Adicionalmente a la información que yo le acabo de dar, yo también tengo que informarles de cuáles son sus derechos.
You both have the right to the presumption of innocence,
Ustedes dos tienen el derecho a la presunción de inocencia,
to indictment or accusation for misdemeanors,
a que se le formule una acusación por delitos menores,
to a speedy and public trial by jury,
de tener un juicio público rápido y por jurado,
to see, hear, and question witnesses who are called to testify against you,
de ver, escuchar y contrainterrogar a los testigos que sean citados a testificar en su contra,
to compel the attendance of witnesses to testify on your behalf,
de exigir la asistencia de testigos para que testifiquen a su favor,
to testify on your own behalf or offer evidence in your own defense,
de testificar a su favor o presentar pruebas para ser usadas en su defensa,
to have an attorney represent you,
de tener un abogado para que lo represente,
and I have appointed an attorney to represent for each of you to have an attorney.
y yo le he nombrado un abogado a cada uno de ustedes para que lo represente.
Ms. Aguilera, you're going to have a special condition on your bond.
Señorita Aguilera, usted va a tener una condición especial en su fianza.
You're going to be ordered to stay away from Salgado, Honduras.
A usted se le va a ordenar que se mantenga alejada de Salgado, Honduras.
You're going to also be ordered to stay away from 7944 Kendrick Estates Court.
También se le va a ordenar que se mantenga alejada de la 7944 Kendrick. Did you say Kendrick State Court, Judge?
Kendrick Estates Court.
Kendrick Estates Court.
If you violate these stay away provisions, you could face additional felony charges.
Si usted infringe la orden de alejamiento, a usted se le podría imputar cargos adicionales por delitos graves.
You could also have your bond revoked and remain in jail until your trial.
Y también se le podría revocar su fianza y usted tendría que permanecer encarcelada hasta que su caso vaya a juicio.
Do you understand this stay away provision?
¿Entiende usted la orden de alejamiento?
Sí.
Yes.
Now, Ms. Aguilera, I thought I saw you raise your hand. Do you have a question?
Señorita Aguilera, yo vi que usted levantó su mano. ¿Tiene usted alguna pregunta?
Sí.
Yes.
What's your question?
¿Cuál es su pregunta?
Quisiera saber si para poder salir cuánto tengo que pagar.
I would like to know, for me to be able to get out, how much do I need to pay?
Your bond is set at $5,000.
Su fianza está fija a $5,000.
If you go through a bonding company, the bonding company normally charges a fee.
Si usted usa una compañía de fianzas, la compañía de fianzas normalmente le cobra una tarifa.
And the fee is generally between 10 and 12% of the bond amount.
Y la tarifa es generalmente entre el 10 y el 12% de la cantidad de su fianza.
But you would have to discuss that with the bonding companies to learn exactly how much they will charge you.
Pero usted tendría que hablar directamente con la compañía de fianzas para ver cuánto ellos le cobran.
Any other questions?
¿Alguna otra pregunta?
Mientras no pague ese dinero no puedo salir.
And if I don't pay those monies, I'm not going to be able to get out.
No.
No.
Mr. Sanchez, I saw you raise your hand. What's your question?
Señor Sánchez, yo vi que usted levantó su mano. ¿Cuál es su pregunta?
¿Cuándo puedo pagar esa fianza para salir?
When can I pay the bond to be able to get out?
You will be able to get out today.
Usted va a poder salir en el día de hoy.
Okay, está bien.
Okay, that's fine.
Okay, the two of you can go back if there's no other questions.
Si no tiene ninguna otra pregunta, los dos se pueden retirar. The interpreter didn't get that, Judge.
No, he was buffering. Mr. Sanchez, would you repeat that?
Señor Sánchez, ¿podría usted repetir?
¿Cuándo sería la última corte? ¿El 10 de mayo?
Repitan de nuevo.
¿La corte va a ser el 10 de mayo?
When is my next court date going to be? On May the 10th?
No, if you bond out, you will receive a new court date.
No, si usted sale bajo fianza, usted recibiría un nuevo citatorio.
Your case will be transferred to a new judge.
Porque su caso sería transferido a un nuevo juez.
Okay, está bien.
Okay, that's fine.
Okay, the two of you can be excused.
Okay, los dos se pueden retirar.
Thank you, Ms. Bermudez. Have a good day.
You're welcome, Judge. You do as well.
All right. Okay, let's get started with everyone else.
Do you see my note?
I'm sending you a response.
Okay.
Ooh, it's almost noon. Okay, good morning, everyone. This is your first appearance hearing before the Magistrate Court of Clayton County. My name is Brad Gardner, and I'm a judge in this court. I'm here to inform you of the charges that have been filed against you, to advise you of certain rights, to set bail on those offenses that I'm authorized to set bail, to schedule a preliminary hearing, and to determine whether you require the assistance of an attorney. You have the right to remain silent and say nothing, but should you give up this right, anything you say during this proceeding may be used against you. So please don't discuss the facts of your case. During this and all other proceedings, you have the following rights: to the presumption of innocence, to indictment by a grand jury for most felonies or by accusation for misdemeanors, to a speedy and public trial by jury, to see, hear, and question witnesses who are called to testify against you, to compel the attendance of witnesses to testify on your own behalf, to testify on your own behalf or offer evidence in your own defense, and to have an attorney represent you. If you cannot afford an attorney, one can be appointed to represent you if you qualify. Some of you will be allowed to post unrestricted bonds for your release from jail. These bonds may be posted by cash, commercial, or property. Some of you will have special conditions on your bond that prohibit you from contacting certain people or going to certain places. You will also be prohibited from contacting the victim while you are in jail. If you violate the court's order, your bond will be revoked and you can remain in jail until your trial. You could also receive additional felony charges. It is important to note that if someone is listed as a victim in your case, that person will not be allowed to post your bond. Some of you are charged with offenses for which this court is not authorized by law to set bail. In this event, a bond hearing will be scheduled before a judge of the Superior Court of Clayton County, and you will be informed of that date. If you are currently on active probation, this court is not authorized to set bond at this time. Where the bond is appropriate in your case will be reconsidered after your probation officer has had an opportunity to consider this new arrest. The purpose of a preliminary hearing is to determine whether there is sufficient evidence to support the allegations against you. The standard at this stage is very low. A judge determining whether a charge goes forward at this stage only has to determine that it is possible that the crime occurred. Everyone has the ability to waive their right to a preliminary hearing. However, you should speak to a lawyer first if you are unsure about whether it is appropriate to waive your preliminary hearing. If you post bond, your preliminary hearing is automatically waived. You will receive notice at the address you give of your next court date. Finally, would everyone please raise your right hand for me, please? Do you swear or affirm any statements you make during this proceeding shall be the truth, the whole truth, so help you God?
Yes.
Okay, let's start on the ladies' side with Ms. Coakley.
Yeah, you're gonna be last. I'm sorry.
Ms. Coakley, ma'am, you're charged with several driving-related offenses. You're charged with 1 count of stopping or failing to yield at a stop sign. The bond is going to be set at $500 for that offense. 1 count of driving on a suspended license. Bond is going to be set at $1,500. 1 count of driving a vehicle with no insurance. Bond is going to be set at $1,000. And 1 count of driving on an expired or invalid tag. Bond is going to be set at $500. So you're going to have a total bond set at $3,500. Your preliminary hearing date is going to be set for May 10th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer? I'm going to find that you qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, not right. Do we have a bond? No signature bond? No. No, not at this time.
Okay, you're free to go back, ma'am. Ms. Cook.
You free to go?
Ms. Cook, I see that you said that you have a lawyer. Were you planning on your lawyer being here today?
No.
Okay. Ma'am, you're charged 1 count of driving under the influence of alcohol. Bond is going to be set at $5,000 for that offense. And 1 count of improper lane change. Bond is going to be set at $500. So your total bond is going to be $5,500. You're going to have a preliminary hearing date set for May 10th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you have any questions for me, ma'am?
No.
Okay, you're free to go back. Ms. Foster. Ms. Foster, you're charged with 1 count of criminal trespass. I am dismissing this charge. But you should learn to govern yourself in a better manner.
Okay.
Okay. Once the jail get this paperwork, you will be released.
Okay, thank you.
You're welcome. Miss Jackson. Miss Jackson, ma'am, you're charged with 1 count of cruelty to children in the 3rd degree. I have dismissed that charge. You're charged with 1 count of disorderly conduct. Bond is going to be set at $1,500 for that offense. I am placing a stay away provision on your bond to stay away from a Dontavius Williams. He's going to have the same stay away condition placed on his bond. Your preliminary hearing date is going to be set for May 10th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like me to see if you qualify for the appointment of a lawyer?
Mm-hmm.
You do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, ma'am, you're free to go back.
Okay, thank you.
Miss Joasson?
He's saying Miss Joanne.
Oh, y'all, she's out of line, y'all.
Okay, thank you. Miss Thomas. Ms. Thomas, ma'am, you're charged with 3 driving-related offenses and 2 drug-related offenses. You're charged with 1 count of driving a vehicle on expired or invalid tag. Bond is going to be set at $500 for that offense. 1 count of driving a vehicle with no insurance. Bond is going to be set at $1,000. 1 count of driving on a learner's permit or in violation of a learner's permit. Bond is going to be set at $500. 1 count of possession of marijuana less than an ounce is a misdemeanor. Bond is going to be set at $1,500. And 1 count of use or possession of drug-related objects. Bond is also going to be set at $1,500. So your total bond is going to be set at $5,000. Your preliminary hearing date is going to be set for May 15th. Jesus, I'm getting all it wrong. May 10th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like me to see if you qualify for the appointment of a lawyer?
Yes.
You do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Yeah, I had just bought that truck on the 15th, and the lady that we got it from, we called when I got arrested. She says she's willing to do anything that she can to get me out and state that she had every right to sell that truck. And she said the reason why it's saying for insurance is coming invalid is because she just took that off, her insurance off the truck. And I have on my phone where I have insurance in my name on the truck.
Okay.
And then as far as my license goes, that.
Oh, ma'am. You are presumed innocent here. I've appointed a lawyer to represent you. I don't want you to discuss the facts of the case to the extent that you may say something that the lawyer could possibly get everything dismissed, but you say something that could count as an admission. So at this stage, I would do my best to go ahead and get myself out of jail, get the information that you need. Did you have that? Well, I'm not going to ask. Generally, it's a good idea when you purchase a vehicle to keep a bill of sale or whatever until you get all of your new stuff. Okay. Any other questions? Okay, you're free to go back now. Miss Walker. Ma'am, you're charged with 3 driving related offenses. The first is a red light violation. Bond is set at $500 for that offense. The second is driving on an expired license plate or decal. Bond is also set at $500. And finally, driving a vehicle without a valid license. Bond is set at $1,000. So you're going to have a total bond set at $2,000. Your preliminary hearing date is going to be set for May 10th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
It says that you are working. How much do you make per hour?
I recently just started my job. I was going to work last night. When I was $15.50.
Okay. You do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any other questions for me?
Yes, sir.
Okay.
Why am I being charged for the red light? Because it was green, even though it was green.
Okay.
And then
So, ma'am, You asked a question. Do you want the answer? Yes or no? Okay. According to the warrant, it says that you were driving a 2011 black Honda Civic on Anvil Block Road and that you ran the red light at Anvil Block Road and Grant Road. It says you crossed the solid white line at the intersection while the light was red and continued eastbound on Anvil Block towards South Park Boulevard. After running the tag on GCIC, I learned that the tag was expired as of 4/12/22. I then asked the driver for her driver's license, and she said that she did not have it on her. I then ran her name and date of birth on GCIC and learned that she was unlicensed. The driver admitted to not having a valid driver's license. She said that she just has an ID card out of Mississippi. The following offenses occurred in Clayton County, Georgia. So that's why you're charged with what you're charged with. Doesn't mean you're guilty, but that's why you're charged. Any other questions?
No, sir.
Thank you. Okay, Miss Burton.
Good morning, Your Honor.
Good morning, Ms. Burton. You're here on a slightly different issue.
Yeah.
All of the same rights and privileges apply that I discussed earlier. But your specific condition is that you're alleged to be a fugitive out of the state of Maryland. It says Baltimore City Police Department says they have warrants for you for burglary in the first degree and burglary in the third degree, and that they have indicated that they will seek your extradition. So, first of all, has anybody explained this process to you?
Kind of, but I was like woken up out of my sleep. So
Okay. So, the state of Georgia and Clayton County in particular has no interest in your charges, whether you're guilty or innocent. We're just holding you because a warrant, you're showing to have a warrant for your arrest. And when they were contacted in Baltimore City, they said they were going to come and get you. So once that happened, we have a duty to hold you for at least 30 days, possibly 60 days. And that 30 to 60 day window can either start today or it can start after what's called a habeas hearing or extradition hearing. The habeas or extradition hearing is a hearing that if you believe you're not the person named in the warrant, or you believe that these warrants are invalid, you have a right to challenge it. And if you say, look, I want to challenge that, sometime between now and the next 90 days, there'll be a hearing to determine whether you are the person named in the warrant and whether the warrants are valid. We don't discuss the facts of your case. We don't even touch the facts of your case. The only thing that we're trying to make certain is that there is a warrant for your arrest and you are the person named in the warrant. That's all that hearing determines. If at the end of that hearing, the judge determines that you are the person named and that the warrant exists, that 30 to 60 day window that I discussed then begins to run after that fact. Okay. Now, if you believe that you are the person named in the warrant and you believe that the warrant may be valid, you can waive that first hearing. If you waive that first hearing, the 30 to 60 day clock will begin running today. Is that making sense to you?
yeah, I'm the person that would like to do that.
I'm sorry, you said you
I said, yes, I'm the person. I don't want to go to court and go against it. I'm who they want.
Okay. So the deputy should have what are called waiver documents, and all you're doing is waiving that hearing. You're not admitting to guilt or anything. You signed, I think it'll be 7 copies. You sign those copies, they send it to me, I sign it, and then that clock begins to run today. If Baltimore City, for some other reason, decides that they're not going to come and get you, the sheriff's department at the end of that 30-day period will contact them. And if they say, well, hey, we don't want her, or we're not going to come and get her, you will be released out the front door. but the warrants would still be valid. So
Right.
you can get stopped 5 minutes after being released from the court. I mean, from the jail, and you encounter a law enforcement officer, and that clock starts to run all over again. So in any event, I encourage you to hire a lawyer up in Baltimore City to deal with this. And that lawyer, the sooner you hire a lawyer, because of traveling and that kind of stuff, I've seen a lot of jurisdictions where if your lawyer is able to speak to the people up there, they may decide that they're going to waive it. Or they may say, we've been looking for her for 10 years and we're not waiving nothing. So I don't know, but it's worth to have a lawyer look into it, okay? All right, ma'am. Once she signs the waiver documents, she'll be free to go back. That's all I have for the females. Did I miss anybody? Yes, ma'am. Yes, ma'am.
In the paperwork, the fugitive guy last night, he said that the home detention unit, do you see that in your paperwork that they wanted me? Because I was confused. Like, I don't know what time he woke me up, but I remember him saying.
So it says Baltimore City Police Department. The date of the warrant, it looks like it was issued March 6th of 2017.
Yeah.
So that's all it says. But the fugitive person would have more information.
Got you.
Okay.
Thank you.
You're welcome. Let's switch over to the male side. Let's begin with Mr. Brown.
Oh, all right, nothing yet.
Mr. Brown, sir, you're charged with aggravated assault with a deadly weapon. Bond is going to be denied on that offense. You're also charged with criminal damage to property. That's a misdemeanor. Bond is going to be set at $3,000. You're charged with battery. Bond is going to be set at $5,000. And you're also charged with criminal trespass. Bond is going to be set at $3,000. There's going to be a stay away provision on this bond to stay away from a Joanne Saint Juste, J-U-S-T-E. Do you understand the stay away provision, sir?
Yeah.
Your preliminary hearing date is going to be set for May 9th at 8:30 in the morning, courtroom 201. You're going to also have a bond hearing date set for May 13th at 8:30 in the morning.
I didn't get that. Could you try again?
Sorry, that's Siri's talking to me. Would you like for me to see if you qualify for the appointment of a lawyer?
Yeah, but I have a question too.
All right, we'll get to that. I'm going to find that you qualify. I'm going to appoint a lawyer to represent you. What's your question, sir?
All right. So if the officer of the case or whatever, if he passed away, how do I go about the?
You need to speak to your lawyer about that.
And then the Joanne girl, like, we don't try to go to the courthouse together and get the charges dropped, but they said that the officer had died. So we've been trying to handle this little warrant and everything. So I'm trying to figure out how I can go ahead and get this over with.
Okay. So you have, just so you know, and I'm sure you know, but you're charged with criminal trespass on April 17th involving the same victim.
It's always,
sir.
Sorry, I apologize. Go ahead.
These other warrants were issued, let's see, on, what's that, February 19th of 2022. I don't know the state of their evidence, okay? That's why you need to talk to your lawyer about this, because your lawyer is supposed to know. There are sometimes hearsay exceptions. So, or they may be able to prove it in a different way. There may be body cam. I have no idea.
You said I have criminal damage too?
Yes.
And that was for yesterday?
Yes.
With my property, it was the 6071.
Sir, when the criminal trespass allegation is that you and your girlfriend got into an argument, that during the argument you pushed the door in and broke the door frame, and that the door frame will cost less than $500 to fix. That says you admitted to damaging the door frame to get access into the alleged victim's bedroom.
She didn't stay there. It wasn't her bedroom.
Sir, don't talk about the facts of your case.
All right.
This is being recorded. I'm trying to help you. This is being recorded.
Yeah.
Okay. Don't just talk to your lawyer.
Just trying to figure it out. You right. I'll talk to my lawyer.
Thank you. You're free to go back.
All right, thank you.
You're welcome. Mr. Rodriguez Brown. Sir, you're charged with 1 count of driving on a suspended license. This is a misdemeanor offense. Bond is going to be set at $1,500. You're going to have a preliminary hearing date set for May 10th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes.
About how much do you make per hour?
About 15.
Okay, you do qualify, sir. Going to appoint a lawyer to represent you. Do you have any questions of me?
No.
Okay, you're free to go back.
All right.
Burroughs, come on up.
But I'm sorry, somebody call me. Can you tell me what Rodriguez Brown bond once again, please?
$1,500.
Misdemeanor?
Yes, ma'am.
Okay, thank you. Sorry about that.
No problem. Mr. Burroughs, do you know what you're charged with, sir? I'm sorry?
No.
You're charged with 1 count of malice murder. Bond is going to be denied because I can't set bond for that here. You're charged with 1 count of aggravated assault. Bond is also going to be denied. 1 count of possession of firearm during the commission of a crime. Bond is going to be denied on that offense. And 1 count of possession of firearm by a convicted felon. Bond is also going to be denied. You're going to have a preliminary hearing date set for May 9th at 8:30 in the morning, courtroom 201. Your bond hearing is going to have to be heard before one of the sitting Superior Court judges. So that date will be forwarded to you. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay. You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, you're free to go back.
Ellis.
Mr. Ellis, sir, you're charged with 1 count of terroristic threats or acts, and it is being charged as a misdemeanor. Bond is going to be set at $3,000. You're going to have a preliminary hearing date set for May 10th at 8:30 in the morning, courtroom 201. I cannot put a stay away provision on this because they did not name your girlfriend. However, the allegation is that these threats occurred within the officer's presence.
Right.
Hold on 1 second. Hold on. Would you like for me to see if you qualify for the appointment of a lawyer?
Sure.
All right, you do qualify, sir. I'm going to appoint a lawyer to represent you. Now, what was your question?
My question was, I was trying to get an understanding exactly what that kind of charge meant. And I mean, I guess you just already explained it. And you're right. To the
Hold on. I can take one question at a time.
Okay.
Believe me, you'll get to ask whatever question. All right. So the allegation is that there was a verbal dispute between you and your live-in girlfriend. Somehow the police were called. And while the police were there, it said that in somehow they believe that you were upset because your girlfriend wasn't going to get arrested, and that you were saying to her that first it says that you said when they leave, you're going to beat her ass. And then it says you continue to make threats to beat her ass and to fuck her up in front of law enforcement. So terroristic threat is a threat to do some kind of harm to someone. It could also, and that's a misdemeanor. If you threaten to kill someone, that could be a felony.
Understood.
Okay. Any other questions?
No, sir.
Okay, you're free to go back.
All right.
Mr. Gates. Mr. Gates, sir, you're charged with 1 count of criminal trespass. Bond is going to be set at $1,000. Do you believe you can post that bond?
Yes.
Your preliminary hearing date is going to be set for May 10th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like me to see if you qualify for the appointment of a lawyer?
Yes.
You do qualify. Going to appoint a lawyer to represent you. Do you have any questions for me, sir?
Yeah, I didn't even know I had a criminal trespass. I mean, I've been here ever since 4 years ago, but I ain't never, officer never cited me no citation for it. That's what I don't understand.
Well, see, the thing you have to realize is that they write this stuff down. So it says that you were told not to return back to that property, and you were told that on July 11th of 2018 by Officer Baker.
Yeah, then nobody, no, he didn't nobody tell me. He didn't tell me that though.
Okay, so speak to your lawyer, because the allegation that they have, and they will have a record of it, is that on July 11th of 2018, you were told not to return to that location by Officer Baker.
All right.
Okay, you're free to go back, sir.
Okay, thank you.
You're welcome, Mr. Howell. Good morning. Mr. Howell, sir, you're charged with 1 count of simple assault and 1 count of terroristic threats. These are both misdemeanor offenses. I'm going to set the bond at $2,500 for the simple assault and $2,500 for the terroristic threats, for a total bond of $5,000. There's going to be a stay away provision on this bond, a stay away from a Khalil Willis. Do you understand that?
Yes, sir, Your Honor.
Your preliminary hearing date is going to be set for May 10th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You say yes?
Yes, sir.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, you're free to go back. Mr. Jenkins. Good afternoon, Mr. Jenkins. Do you know what you're charged with, sir?
Yes, I do know the accusations.
I cannot set bond on these charges at this time. I'm actually not allowed to set bond for this offense. Your preliminary hearing date is going to be set for May 9th at 8:30 in the morning, courtroom 201. You're going to have a bond hearing date set for May 13th at 8:30 in the morning, courtroom 201. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, I do.
You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, I don't.
Okay, you're free to go back. Mr. Jones, sir, you're charged with 1 count of criminal trespass. This is a misdemeanor offense. Bond is going to be set at $1,000. You're going to have a preliminary hearing date set for May 10th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Are you currently working?
Yes, sir.
About how much do you make per hour?
What, how you say, at least, I think it's like $8 an hour, right? I tried working.
Mr. Jones, it's a simple process. You make $8 an hour, you do qualify.
Of course, yes. Yes, sir.
Do you have any questions of me?
Would I be can the judge help me get a job or whatever? I've been told before.
Speak to your lawyer about that, because I'm not an employment agency.
Okay, cool.
Okay. All right, you're free to go back, sir. I have Mr. Robinson. Now, Mr. Robinson. Okay.
Yes, sir.
My understanding is that you appeared yesterday. Is that true?
Yes, sir.
But there was a charge that was left off.
Oh, I don't know. I don't think so.
Okay. Give me 1 second. Well, actually, let's put Mr. Robinson at the end, because I didn't get a warrant from him, and I tried to look him up from yesterday's paperwork, and I didn't see him on yesterday's paperwork. So I'm going to have to do some digging, but I'm going to do it right in front of you, okay? So we can get this cleared up. Okay. Mr. Roney.
And which one is this, Judge, so I can help you look? Is Jeffrey Robinson?
Jeffrey Robinson, 2022 CW 50758.
50758. Okay. All right, I'll look too.
Okay, thank you. Mr. Roney, sir, you're charged with a number of driving related offenses. Failure to stop at a stop sign, bond is set at $500. Driving a vehicle with the tag concealed, or concealing the identity of the tag, bond is set at $500. Driving on a suspended license, bond is set at $1,500. Driving a vehicle with no insurance, bond is set at $1,000. Driving a vehicle, hold on 1 second. Okay, I'm sorry about that. It says driving a vehicle with an expired or invalid tag, bond is set at $500. Identity fraud with the claim that you gave them a driver's license with somebody else's name on it, that's a felony offense. Bond is going to be set at $3,000. Giving a false name, address, or date of birth, bond is set at $1,500. Use or possession of drug-related objects, bond is set at $1,500. And possession of marijuana less than an ounce, bond is set at $1,500. And I dismiss the obstructing an officer charge. So you're gonna have, looks like a total bond of 3, 6, 9, 10, 11, looks like $11,500. Your preliminary hearing date is going to be set for May 9th because of the felony offense at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. You did not fill a form out. Do you want me to see if, I'm sorry, that was Mr. Robinson. You refused to fill out the form, so you're going to hire your own lawyer?
Yes, sir.
Okay, do you have any questions of me, Mr. Roney?
No, sir. Thank you.
Okay, you're welcome. You're free to go back. Mr. Cersei?
How you doing, my brother?
I'm doing well. Mr. Cersei, you're charged with one count of driving on, one count of driving under the influence of alcohol. That's a misdemeanor. Bond is set at $500, and one count of making an improper left turn. Bond is set at $500. So your total bond is going to be $5,500. Both of these are misdemeanor offenses. So your preliminary hearing date is going to be set for May 10th at 8:30 in the morning, courtroom 201. And do you plan also on hiring your own lawyer?
Yes, I do. Yeah.
Okay, do you have any questions for me?
Nope.
Okay, sir, you're free to go back.
Appreciate it.
Mr. Stennis.
How you doing today, sir?
I'm doing well. Mr. Stennis, you're charged with one count of aggravated assault with a deadly weapon. I set the bond at $20,000 for that offense. One count of criminal damage to property in the first degree. That's also a felony offense. Bond is set at $5,000. And one count of cruelty to children in the third degree. Bond is set at $5,000. So that's going to be a total bond of $30,000. There's going to be a stay away provision on this bond, a stay away from a Nancy Stennis. Do you understand that?
Yes.
Your preliminary hearing date is going to be set for May 9th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
I want to make a statement, not involving the case, but I'm trying to, why is it so high? So like, I don't know if I can afford that. I live alone. I don't like it. If I get stuck in here, I'm gonna wind up jobless and homeless when this is all situated.
I came close to denying your bond. The allegation is that you took a grill with hot coals in it and poured it into your wife's car while she was sitting in the car.
Sir, but that's an allegation. That's not the truth.
That's why you have a bond set based on the allegation. Right? That's why you don't show up and I'd sentence you to 5 years in prison today, because you're presumed innocent. But I do have to look at the allegations, and I have to take the allegation as being, could be true. And if it's true, what's the appropriate bond for someone who would throw hot coals into a car where his wife is sitting? That's what I have to, how I have to think.
I understand, but how do I do that with a hot grill? How do I do that?
Sir, this person went to Judge West on March 16, 2022. Officer Evan Bowling of the Clayton County Police Department, and swore out that these facts are true to the best of his knowledge. So that's why we appoint lawyers, so that you can have these discussions with your lawyer. Okay. And your lawyer can come to court, and your lawyer can then advocate on your behalf.
Right. And when you say this person, you say the officer said that, or you saying referring to Nancy? You said this person.
The officer would have had to receive it from a complaining witness, which in my opinion, it would have been Ms. Stennis.
All right.
Okay. Any other questions?
I just need to repeat the bond number, the total number.
30,000.
All right.
Okay. Free to go back. Mr. Tonner. Sir, you're charged with one count of driving under the influence of alcohol. Bond is set at $5,000, and one count of an open container violation. Bond is set at $500. You're gonna have a total bond of $5,500. Your preliminary hearing date, because both of these are misdemeanors, is going to be set for May 10th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, Your Honor.
I'm going to find that you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, not at this time.
Okay, sir, you're free to go back.
Thank you.
Mr. Wallace? Mr. Wallace, so you're charged with 1 count of driving on a suspended license, bond is set at $1,500. 1 count of failing to stop or yield at a stop sign, bond is set at $500. And 1 count of not changing, looks like not changing the address on your license after 30 days, or living here in Georgia for more than 30 days without changing your license. That's also a misdemeanor, bond is set at $500. So your total bond is going to be set at $2,500. Your preliminary hearing date is going to be set for May 10th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
All right. Are you currently working, sir?
No, I'm a student.
You're a full-time student?
Sorry.
Where?
NC State University. I'm here. I'm not living here. I'm actually visiting my mother. I have a North Carolina driver's license. I didn't know it was suspended. So
Hold on. So it says here that you told the officer that you moved here from North Carolina 3 months ago.
No. I told him I was visiting.
Okay, so you need to speak to a lawyer. I'm going to appoint a lawyer to represent you. You need to speak to a lawyer. This is not the time for me to make the determination as to whether you're a resident or a student. But if you can show that you're currently enrolled, the license charge should go away. The driving or not changing your address. But based upon what the officer has written, he said that you told him you've been living here for 3 months. Any other questions?
No, sir.
Okay, you're free to go back. Mr. Washington. Mr. Washington, good morning or good afternoon. Sir, you're charged with 1 count of battery. Bond is going to be set at $5,000. 1 count of criminal trespass. Bond is going to be set at $3,000. And 1 count of cruelty to children in a 3rd degree. Bond is also going to be set at $3,000. That's a total bond of $8,000. There's going to be a stay away provision on this bond to stay away from a Nicole Torrance. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for May 10th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay. I'm going to find that you qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Yes, sir. I'm the only one here from Alabama. I have no family. I have no one actually to really come bond me out. If I don't have anyone else to reach out to contact, how could I let my family know, or is it any way that she can let them know for me? But most importantly, what do I do as far as my possessions if I do make bail, because that is my house?
Okay, so you'll have to make an arrangement with the sheriff's department in order for you to go and obtain the items that you need. Let me see, hold on one second. So, do you and Miss Torrance live together?
Yes, sir. Yes, sir. Yes,
okay. Sir. So as long as she is living there, you're going to have to make arrangements with the sheriff's department to remove your items that you need for daily living until this case is resolved. Okay?
Yes, sir.
Yes, sir.
I have, well, really just one more question. The two, if I'm not mistaken, you said my charges for aggravated assault, cruelty.
No. Battery, criminal trespass, and cruelty to children in the 3rd degree. These are all misdemeanor offenses.
The last two, sir, those the only two I have questions about.
The criminal trespass is based upon the allegation that you took her phone and broke her phone.
No, sir.
I said the allegation. I didn't say you did it, but that's where the criminal trespass charge comes from.
Yes, sir.
And the cruelty to children in 3rd degree is that they said that you punched her in the lip, causing her lip to bleed, and this act occurred in front of your child.
Don't
discuss the facts. These are the allegations. I've appointed a lawyer. Talk to your lawyer about the facts of your case.
Yes, sir.
Okay, you're free to go back. Mr. Dontravius Williams.
Dontavius.
Mr. Williams, sir, you're charged with cruelty to children in the 3rd degree, and just like I did with Ms. Jackson, I'm dismissing that charge.
Thank you.
You're also charged with disorderly conduct. Bond is going to be set at $1,500. That's a misdemeanor. There's going to be a stay away provision, just like I put on you to stay away from her. I put on this for her to stay away. I'm sorry, I said that backwards. For her to stay away from you, you're going to also have a stay away provision where you're to stay away from her. Do you understand that?
Yes, sir. I was supposed to be moving in my new spot today.
Okay. Your preliminary hearing date is going to be set for May 10th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, Mr. Williams. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir. I just need to use phone.
Okay. They will allow you to use the phone after this hearing.
Okay, thank you.
Okay, sir, you're free to go.
All right, thank you.
You're welcome. Mr. Stanton Williams?
Afternoon, Your Honor. It will be Stantuan Williams.
Antoine, thank you, sir. Mr. Williams, you have similar charges, but they're all on different dates, it would appear. So you're charged with criminal trespass and warrant number 2021 CW 50520. And the bond is going to be the same for all of these offenses. It's going to be $5,000 a piece. And this incident allegedly occurred on July 27th of 2021. There's going to be a stay away provision on these bonds, also to stay away from a Tremaine McCommons. Do you understand that?
Yes, sir.
So you're charged in warrant number 2021 CW 53821. This incident allegedly occurred on August 4th of 2021, again involving Ms. McCommons as a victim. Bond is going to be set at $5,000 for that offense. You're charged in warrant number 2021 CW 53564 with committing the offense of criminal trespass, damage to property. And that incident allegedly occurred on July 24th of 2021 also. And bond is set at $5,000. And finally, you're charged in warrant number 2022 CW 50088 with committing the offense of criminal trespass, damage to property. I'm sorry, this is written as a felony. And this incident allegedly occurred on January 6th of this year. So there's 3 different days. For the felony offense, you're going to have a preliminary hearing date set for May 9th at 8:30 in the morning, courtroom 201. For these misdemeanor offenses, you're going to have, and the felony offense is the criminal damage to property in the 1st degree. The misdemeanors are going to be set for preliminary hearing date set for May 10th at 8:30 in the morning, courtroom 203. Because these misdemeanors and felonies occurred on different days, the felony is going to be prosecuted in the district attorney's office, and the misdemeanor is going to be prosecuted by the solicitor. Would you like for me to see if you qualify for, looks like, let's see, would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
Yes, sir. How much would my bond come up to in total?
$20,000. Do you have any other questions?
No. Yes, sir.
Okay.
They said I was in violation of probation. Is that correct?
Were you on probation?
That's what I'm trying to figure out, sir. I didn't never know about it.
Let's see. I didn't see an indication that you were on probation.
Well, when I had my paperwork and intake, it was a VOP on there. I'm just trying to figure out what's going on, sir.
Well, okay, Mr. Williams, because it benefits you to know, you need to know if you're on probation or not. So I'm telling you, they don't always get placed on these criminal histories. If the jail tells you that you have a VOP, you have a VOP. Okay? Is there anything else?
No, sir.
All right, you're free to go back.
Thank you.
Mr. Percy Wilson. Sir, you're charged with 1 count of violation of Georgia Patrol Substance Act, possession with intent to distribute marijuana. I set the bond at $10,000. You're also charged with possession of a firearm during the commission of a crime. I set the bond at $10,000. And possession of a firearm by a convicted felon. I set the bond at $10,000. That's a total bond of $30,000. Your preliminary hearing date is going to be set for May 9th at 8:30 in the morning, courtroom 201. The date will get waived upon your bonding out, and you'll get a new court date in the mail. You plan on hiring your own lawyer?
Yes, sir.
Do you have any questions of me?
Only one. As far as the firearms go, by the convicted felon, those firearms wasn't on my person or retrieved off of my person.
I understand it says it was in a drawer.
No. The firearms was claimed by the person that was detained, another person that was detained at my house. I don't own firearms, sir.
Okay.
And that person did claim a firearm. It was in their possession, not mine.
Okay.
I wasn't even aware.
Okay. Do you need to speak to your lawyer about this? It says it was in the kitchen. It said it was a brown bag in the kitchen. It didn't say it was in a drawer. You need to speak to your lawyer about this. There will be body worn cameras and, that may assist you in getting that charge dropped.
Okay. Yeah.
Anything? Yes, sir.
I wasn't alerted or anything. I didn't even know until I actually got booked in that was the charge.
Okay. Anything else, Mr. Wilson?
No, sir. I just want to know about that charge.
Okay. You're free to go back, sir.
All right, thank you.
You're welcome. Mr. Stephen Wilson.
Good afternoon, sir.
Good afternoon, Mr. Wilson. You're charged with one misdemeanor offense of giving a false name, address, or date of birth to a law enforcement officer. Bond is going to be set at $2,000. I think I recall you may have 2 open warrants for your arrest. So you may get sent to wherever those warrants are pending upon posting bond. In any event, you're going to have a preliminary hearing date set for May 10th at 8:30 in the morning, courtroom 201. That date will be waived upon your posting bond here. You refuse to sign. Do you or fill the form out? You plan on hiring your own lawyer?
I actually want a court-appointed lawyer, sir.
Are you currently working?
Yes, I am.
About how much do you make per hour?
13.
Okay, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Yes, sir. You said they may come get me for those traffic charges?
Yes, I have no idea because I don't work for them, so I don't make decisions for them.
Okay. So when I bond out, never mind. Thank you, sir.
You're welcome.
Is that it?
That's it. You're free to go back.
Have a good day.
You're welcome. Miss Mary, did we find out about Mr. Robinson?
No, I sent a message to the jail, but they haven't responded.
Okay.
Robinson had first appearance, but this warrant was not on the paperwork he had yesterday.
Right.
So the question is this a new charge?
Well, sometimes the charge don't make it over. I don't have his warrant for this charge. So maybe that's why I didn't get.
What's the charge?
Violation of Georgia Controlled Substance Act, possession of a controlled substance, Schedule 1, which is a felony offense.
They had that. There was 2 counts of that already, wasn't there?
Hold on. So the way that we look at these is through warrant numbers, because you could commit the same offense allegedly 3 or 4 times. So the name of the offense in and of itself doesn't mean that it was resolved. We go by the warrants because that's the only way that you're going to be able to bond out. Because right now it's showing that there's no bond set on this warrant. So if you were to try to bond out, you couldn't. Does that make sense?
Yes, sir.
Okay.
All right, Judge, I'm gonna mute it and call the jail.
Okay. I'm looking back, Mr. Robinson, for your paperwork from yesterday. Yep, I see you. Hold on. Miss Mary, I see his warrant. He had the warrant yesterday. But it's not on your, hold on, let me print this warrant out.
So he had the warrant yesterday, Judge?
He had the warrant.
But it wasn't on the calendar.
No, he's on the calendar.
No, I mean, he's on the calendar for yesterday, but that warrant wasn't attached to it.
Okay.
Well, I don't think he got first, I don't think he got first appearance for that warrant ending in 075.
No. No, hold on. I'm gonna print it out from yesterday's thing. Let's see. And I'll explain to you in a second what's going on, Mr. Robinson.
Can you please make a note that I need to get in drug court?
Hold on, I couldn't hear you because of the
I said, would you please make a note that I need to get into drug court? I need a program.
Yeah, Judge, I think, and you can correct me if I'm wrong, Mr. Robertson, you said that yesterday as well, correct?
Yes, ma'am.
Yeah, he did.
okay.
Because Judge Knights was gonna write it down on his paperwork
Okay.
that he would like to get in drug court.
I need this.
Okay.
You have the warrant, right?
I do have the warrant. I just printed it out from yesterday's paperwork.
Okay, I just want to tell Morel he doesn't have to scan it over.
Okay. I tried to look this morning, Mr. Robinson.
Judge, I can't make bond.
So, Miss Mary, I'm looking at the orders for bond and it goes from from Parks to Stinson.
I'll send you a message on the chat.
Okay. Okay, so hold on, Mr. Robinson. There's some things that I have to do now. That I have to check. I would normally be doing this early in the morning, but somehow this fell through the cracks. So I'm gonna try to do it here.
While you're working on that, I'll look through the bond paperwork, Judge, to see if
Okay,
it's on there, okay?
okay. Oh, Mr. Robinson, you have a long criminal history.
Yes, sir. Well, I said I need a program. I've been to prison so many times and it's never done anything to rehabilitate me. And I want to stop this crazy cycle I'm in. And I think drug court would help me do that. It would give me some structure, some I don't know, some things to go by, you know?
Well, it might.
I'm 57 and I'm tired of this.
All right, Judge, so no, it is not listed on the bond paperwork from yesterday.
Okay. So with the criminal histories from yesterday, when it says part 3 of 3 or part 3, it stops midway with Mr. Robinson. It stops at cycle 38 and he has 60 cycles. And I don't see any other criminal history documents. Let's see. All right. What I'm going to do, Mr. Robinson, I'm going to deny bond on this charge. And what that is going to do is that is going to, believe it or not, bump your situation up so that, and see, I was looking, Miss Mary, to see if he was appointed a lawyer yesterday, but it's not in the paperwork, so we don't know.
Let me check. Give me 1 second.
I have his CAA.
Oh, okay.
I'm going to appoint you a lawyer, Mr. Robinson. I'm going to write those other warrant numbers down on this CAA form, and what that will tell the public defender's office is that you have these other cases, and they'll put these other cases all together. I know that they work extensively with trying to get people into programs that may assist them. But the one person that you need to understand that is most important in this process is you.
Yes, sir.
I mean,
That's why I'm begging for help. I know who's important. And I will succeed if somebody will help me get in.
well, Mr. Robinson, the way that I've heard it explained is that the way that people have gotten themselves off of drugs is that they understand that being a drug addict is who they are.
Mm-hmm.
So if you know that if you know you can't swim, you're not going to jump into the middle of the ocean.
Right.
But you say, well, I can swim, I can do it. I know I can do it. And then you go out and drown.
Mm-hmm.
So you're the person that's going to stop you from doing that. Nobody else.
Yes, sir.
And it's nobody else's responsibility. Because
Drug
you can kill yourself if you want to.
Right. Drug court gives me some accountability.
Well, hopefully that will work. So I've put the warrant numbers 2022 WA0643. Miss Mary, I think what I'm going to do is just go ahead and print these documents out from yesterday, because it doesn't appear as though it got sent over to the jail.
Okay.
And so what we're going to do is just act like yesterday never happened, Mr. Robinson. All of the information is going to be consolidated into today so that this will all stay together. And hopefully we get you on the right track.
Thank you.
Any questions for me?
No, sir. If there's any way you can help me with drug court, I would appreciate it.
So we don't do drug court out of magistrate court. Drug court goes to the next level. What your district attorney, or I'm not district attorney, your defense lawyer is going to speak with the district attorney. Based upon what you're saying, you most likely will get what they call a fast track waiver. That means you waive your preliminary hearing. In exchange for that, your case gets placed immediately into a drug court program. But your lawyer will explain all of that stuff to you.
Well, yes, sir. Just make a note that that's what I want to do.
So, Mr. Robinson, I'm going to tell you what you're doing right now. And this may be why you're having some of the issues you're having. Whose responsibility is it to get you in the drug court?
Mine, I guess.
It starts with you.
Yep.
So you have been assigned an attorney. What's the first thing you're going to talk to that attorney about?
Drug court.
See how easy this works? But when you say, Judge, just make sure you write it down, then you're going to say, well, I told the judge to write it down. And I'm telling you, I can't place you in drug court. Your lawyer can, but you have to request it.
Yes, sir.
Okay. All right. I'm going to do a bond order on these other offenses. I'm gonna give you a bond on the misdemeanor, the 2 misdemeanors of drug-related objects and giving a false name, address, or date of birth to law enforcement. It was a misdemeanor, so I have to set bond. So you're gonna have a $2,000 bond on that and a $1,500 bond on the possession of drug-related objects. I'm gonna deny bond on the possession of meth. That's a felony.
Yes, sir.
Okay?
Yes, sir.
Any other questions?
No, sir.
All right, you're free to go back.
Thank you.
Okay, by my count, that concludes today. It's a weird day. It's a good thing this happened on Monday and not Friday.
Yes, sir.
Thank you, Deputy Requena, for your assistance, and everyone else. Have a good day.
Bond court is a free service, but it takes several hours of my time every day. Less than 10% of bond court viewers hit the like button, and less than 1% leave a comment. If you want bond court to continue to be available on YouTube for free, then please hit the like button and leave a comment on all of my videos.
Okay. Good morning, everyone. This is your first appearance hearing before the Magistrate Court of Clayton County. My name is Brad Gardner, and I'm a judge in this court. I'm here to inform you of the charges that have been filed against you, to advise you of certain rights, to set bail on those offenses that I'm authorized to set bail, to schedule a preliminary hearing, and to determine whether you require the assistance of an attorney. You have the right to remain silent and say nothing, but should you give up this right, anything you say during this proceeding may be used against you. So please don't discuss the facts of your case. During this and all other proceedings, you have the following rights: to the presumption of innocence, to indictment by a grand jury for most felonies or by accusation for misdemeanors, to a speedy and public trial by jury, to see, hear, and question witnesses who are called to testify against you, to compel the attendance of witnesses to testify on your behalf, to testify on your own behalf or offer evidence in your own defense, and to have an attorney represent you. If you cannot afford an attorney, one can be appointed to represent you if you qualify. Some of you will be allowed to post unrestricted bonds for your release from jail. These bonds may be posted by cash, commercial, or property. Some of you will have special conditions on your bond that prohibit you from contacting certain people or going to certain places. You will also be prohibited from contacting the victim while you are in jail. If you violate the court's order, your bond will be revoked and you could remain in jail until your trial. You could also receive additional felony charges. It is important to note that if someone is listed as a victim in your case, that person would not be allowed to post your bond. Some of you are charged with offenses for which this court is not authorized by law to set bail. In this event, a bond hearing will be scheduled before a judge of the Superior Court of Clayton County, and you will be informed of that date. If you are currently on active probation, this court is not authorized to set bond at this time. Where the bond is appropriate in your case will be reconsidered after your probation officer has had an opportunity to consider this new arrest. And as an aside, I noticed that not a lot, but there's a sizable number of you that fit into this category today. The purpose of a preliminary hearing is to determine whether there is sufficient evidence to support the allegations against you. The standard at this stage is very low. A judge determining whether a charge goes forward at this stage only has to determine that it is possible that the crime occurred. Everyone has the ability to waive their right to a preliminary hearing. However, you should speak to a lawyer first if you are unsure about whether it is appropriate to waive your preliminary hearing. If you post bond, your preliminary hearing is automatically waived. You will receive notice at the address you give of your next court date. Lastly, could I have everyone raise your right hand for me, please? Do you swear or affirm that any statements you make during this proceeding shall be the truth, the whole truth, so help you God?
I do.
Okay, and just for planning purposes, we have an add-on, Mr. Collier. We're going to do Mr. Collier at the end before we do Mr. Chavez. And I think Mr. Chavez is the person that we need the services for the interpreter, and she's still doing preliminary hearings right now, but he's the fugitive, so they're normally at the end. Okay, let's start on the lady side.
Anderson. I'm sorry.
Arts.
Arts.
Artis? Yes.
Arts. Artis.
Good morning.
Good morning, ma'am. You're charged with 1 count of public drunkenness and 1 count of obstructing an officer. These are both misdemeanor offenses. I've set the bond at $1,000 for the public drunkenness and $1,000 for the obstructing of an officer. That's a total bond of $2,000. You're going to have a preliminary hearing date set for May 10th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, please.
It looks like you make a little too much, ma'am, to qualify.
Okay.
Do you have any questions of me?
Just a question concerning the May 10th. So if I were to bond out, then I'll just receive a new court date?
Yes, ma'am. You'll receive a court date at the address you give. And that's because once you bond out, your case moves to the final judge that will hear your case. And then you're going to be on that judge's schedule.
Thank you.
Okay. All right. You're free to go back.
Thanks.
Miss Cornell.
You guys tell me to bond him out again?
$1,000 each. Okay, ma'am, you're charged with a number of misdemeanor offenses and some felony offenses. You're charged and with failing to stop or yield at a stop sign. The bond is set at $500 for that. You're charged with improper lane change. The bond is set at $500 for that. You're charged with obstructing an officer. Bond is set at $2,000. You're charged with fleeing from an officer. Bond is also set at $2,000. You're charged with the felony VGCSA, which is violation of Georgia Controlled Substance Act. And that is for possession of methamphetamine. I cannot set bond for this offense at this stage, ma'am, because it's a felony offense and there's an indication that you are on either parole or probation. You're also charged with possession of methamphetamine with the intent to distribute. Also cannot set bond for that felony offense because of the same reason. You're charged with use or possession of drug-related objects. The bond is going to be set at $1,500. You're charged with reckless driving. Bond is going to be set at $1,500. And you're also charged with driving a vehicle on a suspended license. Bond is going to be set at $1,500. So there's $9,500 on the offenses that I was able to set bond, but you have 2 offenses that it appears that you're on probation or parole that I could not set bond. Your preliminary hearing date is going to be set for May 9th at 8:30 in the morning, courtroom 201. You're going to also have a bond hearing date set for May 13th at 8:30 in the morning, courtroom 201. Would you like for me to see if you qualify for the appointment of a lawyer? You do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions of me? Okay, you're free to go back. We have Miss Bermudez here. Let's bring up Mr. Chavez so that we're not wasting Miss Bermudez's time.
Morning, Judge.
Good morning. How are you?
I'm well. Thank you. How are you?
I am doing well.
Your Honor, Mr. Chavez doesn't need an assistant of interpreter.
Oh, okay. Well, it was great to see you anyway, Miss Bermudez.
Thank you, Judge. It was great to see you as well.
Have a good day.
You too.
So let's put Mr. Chavez back. We'll deal with him at the end. Let's switch back over to the ladies' side.
All right, let me get
Miss Lawrence.
logins are there.
Good morning.
Good morning, Miss Lawrence. You're charged with 1 count of aggravated assault with a deadly weapon. This is a felony offense. I've set a bond at $15,000 for that charge. You're also charged with 1 count of affray. I've set the bond at $1,000 for that charge. So you're going to have a total bond of $16,000. There's going to be a stay away provision on this bond to stay away from a Keosha Butler. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for May 9th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
You do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, you're free to go back.
Thank you.
Miss Loggins.
Good morning.
Good morning, Miss Loggins, ma'am. You're charged with 1 count of criminal trespass. Bond is going to be set at $3,000. There's going to be a stay away provision on this bond to stay away from a, nope, it was at a business. Your preliminary hearing date is going to be set for May 10th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
You do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, no, sir.
Okay, ma'am, you're free to go back.
Thank you.
Ms. Tyshandra Peoples.
Ty, just Ty.
I don't know between how they got it.
All right, so T.Y. Chandra.
Good morning, Your Honor.
Good morning. Let me ask you this question. Is there a Tyshandra T.Y.?
No, it's a Tyshana Peoples. It's my
Yeah,
twin sister.
Yeah, Sean, they're twins. Their names are similar.
Yeah.
So, which one? What's your early number? All right, John,
Okay.
this is Tyshandra.
Okay.
Like how that's how it's spelled on my calendar.
Yeah.
They spelled it wrong on the cover of the bond sheet. I'm correcting that now. So you are Tyshandra.
Yes.
Okay. Ma'am, you're charged with 1 count of trafficking marijuana. This is an offense that I cannot set bond for at this stage. So bond is going to be denied pursuant to Georgia Code 17-6-1. Any allegation of trafficking marijuana over 10 pounds, the first judge cannot set bond by law. You're going to have to either hire a lawyer and have a consent bond, or you're going to have to wait for a preliminary hearing. I'm sorry, bond hearing. Your preliminary hearing date is going to be set for May 9th at 8:30 in the morning, courtroom 201. Your bond hearing is going to be set for May 13th at 8:30 in the morning, courtroom 201. Now, do you want me to see if you qualify for an appointed attorney, or you're going to hire your own attorney?
Can you see if I qualify for one, please?
You do qualify, ma'am. I'm going to appoint an attorney to represent you. Do you have any questions of me?
With this being like a first time offense, all of this still applies?
Yes. So it's like, for example, if you were charged with murder and it's the first time that you're ever charged with murder, I couldn't set a bond. So there's certain offenses that I cannot set bond and that have to go through a formal hearing. And this is one of them. And ma'am, and I tell you, I see people like you at least 5 or 6 times a week. I don't know who's saying what to whom out in the West, but they should know by now that if you get caught, you ain't getting a bond. So if whomever didn't tell you that, I can't do anything about it.
All right.
Hey, ma'am, any questions? Any other questions?
No, I don't.
Okay, you're free to go back. Okay, Tyshana Peoples. So, ma'am, you're in the same boat as your sister. You're charged with trafficking marijuana. Bond is going to be denied at this point pursuant to Georgia statute OCGA 17-6-1. You're going to have a preliminary hearing date set for May 9th at 8:30 in the morning. You're going to also have a bond hearing date set for May 13th at 8:30 in the morning. Now, do you want me to see if you qualify for the appointment of a lawyer?
Yes.
Okay. I'm going to find that you qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No.
Okay, ma'am, you're free to go back.
Simmons. Twins.
Ms. Simmons, ma'am, you're charged with 4 counts of possession of a firearm by a convicted felon, and 1 count of violation of Georgia Controlled Substance Act. Looks like possession with intent to distribute. There's an indication that you're either on probation or parole. So I cannot set bond on these offenses. So on all of these offenses, bond is going to be denied pursuant to Georgia Code Section 17-10-1. You're going to have a preliminary hearing date set for May 9th at 8:30 in the morning, courtroom 201. You're going to also have a bond hearing date set for May 13th at 8:30 in the morning, courtroom 201. Do you want me to see if you qualify for the appointment of a lawyer?
Yes.
You do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Yes, I do. None of those items were mine. And
No details about
Right. So, ma'am, these are the accusations or allegations that have been made against you. This is why we appoint lawyers at the earliest stage. You need to speak to your lawyer about that. And your lawyer is the person that can present the proof to the district attorney's office, and maybe they'll dismiss the charges.
all right. And you said the first one was for preliminary hearing?
Yes, ma'am. It's also called a probable cause hearing. That's where the state has to bring witnesses in to establish by probable cause, meaning more likely than not that you committed the crime.
All right. And that was May 9th?
Yes, ma'am.
Okay. And then the second one, May 13th, was for what?
That's a bond hearing.
Okay, so there's no way that I can get like my probation officer to set bond for me?
No, your probation officer cannot set bond. If your probation officer communicates with the district attorney's office or your lawyer and say, hey, look, this person is fine with me, then they will consider it, but it's a decision that is totally within the district attorney's office right now until the next hearing. So theoretically, between now and May 9th, there could be a meeting of the minds, and this all could be changed or go away, but I don't know. That's where your lawyer comes in.
Okay.
Anything else?
That's it.
Okay, ma'am, you're free to go back.
All right, thank you, Your Honor.
You're welcome. Ms. Teasley.
Good morning, Your Honor.
Good morning, ma'am. You're charged with 1 count of battery. I've set the bond at $5,000. This is a misdemeanor offense. There's going to be a stay away provision on the bond to stay away from a Tanita Bab, and I know you may not know who that is, but that's the waitress at the Waffle House. You're also going to be ordered to stay away from 11152 Tara Boulevard. in Hampton, Georgia. Do you understand these two conditions, ma'am?
Yes, Your Honor.
Your preliminary hearing date is going to be set for May 10th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you will get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, please, Your Honor.
You do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
That's the lowest the bond can be for a first time?
Well, ma'am, that's what I set for a battery because I believe adults should know how to keep their hands to themselves.
Yes, sir. You're absolutely right, Your Honor.
Okay, ma'am, you're free to go back.
Thank you.
You're welcome. All right, does that complete the ladies' side?
Your Honor, I have the fugitive you continued from yesterday. She's also here. Would you like to do her with the other fugitive from the male side at the same time?
Okay, so I wasn't the judge yesterday. Is this Barrington?
Yes, sir.
Do you still? Okay.
I still have her waivers.
Okay, bring Miss Barrington up, and let's bring up Mr. Chavez.
So Ms. Barrington didn't understand the process, so I think you need to explain that to her.
Okay. Miss Barrington, give me 1 second. I need to pull up your warrant from yesterday. Okay, Mr. Chavez and Miss Barrington, the same rights and privileges as I discussed earlier, they still apply to you, but the two of you are in a slightly different situation. You're both are what's being called fugitives from justice. And what that simply means is that there is a warrant for your arrest from another state. And that state has indicated that they intend to extradite you, meaning come to Clayton County, pick you up, and take you back to the jurisdiction. For Ms. Barrington, there's a warrant for your arrest out of Leon County Sheriff's Office in Florida for battery on a peace officer. For Mr. Chavez, there's a warrant for your arrest out of Cook County, Illinois, and it says it's for a weapons offense. Now, because these are warrants from another state, the two of you have the right to say, I want to have a hearing on this. And generally, you say that because you believe that A, you're not the person named in the warrant, or B, you don't believe that the warrant states a valid charge. If you request that hearing sometime between now and the next 90 days, there will be a hearing to determine whether A, you are the person named in the warrant, and B, whether the charges are valid or true charges. If after that hearing, the judge makes a determination that you are the person named and these are valid charges, the judge will sign off on a governor's writ. And what that basically means is the judge will sign off on, okay, y'all can come get this person. From Illinois, you can come get Mr. Chavez, and from Florida, you can come and get Ms. Barrington. Once the judge signs that order, each jurisdiction has a minimum of 30 days to come and get you. That's a statutory amount. If they reach that 30 days and there's some kind of problem or issue, they can request an additional 30 days. So they'll have up to 60 days to come and get you. If they do not come and get you at the end of that process, you will be released out the front door, but the warrant does not go away. So you can be released out the front door. You encounter another police officer 5 minutes after being released from the front door. They run your history and see that there is a valid warrant, and this process starts all over again. If you believe that you are the person named in the warrant and that the warrant states a charge, you can waive that whole process today. And if you waive that process today, that 30-day up to 60-day period begins to run today. What I tell people that are going through this process is that in any event, the two of you need to hire a lawyer in Florida and a lawyer in Illinois to handle your situation up there. But I've seen where people have hired lawyers, and 2 days later, I get an order where the judge in that jurisdiction has said, hey, we're granting a bond for this person. And then you can bond out of here and go about your business. If you choose to wait, you'll wait until they come and get you, if not, and then you start that whole process. So, Mr. Chavez, do you have any questions?
Yes, sir. I was free of all charges in Illinois. I got paperwork proving that the charges got dismissed, but for some reason they never notified my lawyer. They never notified me. They never notified my family. And out of nowhere, basically I got locked up for like a traffic offense, and I'm barely finding out they got a hold on me.
Okay, do you have something to write with?
Yes, sir.
Looks like the warrant number is W22C1420.
All right, thank you.
So you understand that we can't do anything about that here.
Yes, ma'am. I mean, yes, sir.
That's fine. Do you know if you want to waive your preliminary hearing, or do you want to have your preliminary hearing? I mean, I'm sorry. Do you want to waive your hearing, or do you want to have your hearing?
I just want to get this over with. I just want to sign the paper.
Okay. So when Mr. Chavez signs the waiver form, he can be free to go back. They're going to send the forms over to me, and I sign it, and then that clock starts to run today.
So
but based upon what you said, I would try to contact your lawyer and give the lawyer that warrant number, because the lawyer may be able to work something out before you even have to go through the extradition process. Okay.
So can I get the warrant number just to make sure it's the right one?
W22C1420.
Thank you.
Ms. Barrington, do you have any questions about this process?
Yes.
Okay.
It says that I entered and stayed in the state of Georgia, knowing I had a warrant in Florida, but I've been residing in Georgia since 2017. And when I was on probation, my probation officer
She froze.
gave me a travel permit to live here because, hello?
Okay.
Hello?
So, Ms. Barrington.
Yes.
Just like Mr. Chavez, we don't look behind the charges. Okay. We see that, hold on. We see that there is a valid warrant. We contact them and they say, hold her, we're going to extradite her. That's all that we do. For the answers to these questions, you're going to have to contact the people in Florida.
Okay. Is this a new charge that I got a warrant for?
Okay. It says, I'm going to give you the warrant number. You ready?
Yes. Is this the Georgia warrant number or the Florida warrant number?
It's the Florida warrant number.
Okay.
W924 3924. It looks like 83.
W924392483.
Yes, ma'am.
Okay.
So do you have any other questions?
No.
Do you know if you want to sign the waiver or do you want to have the hearing?
I don't have a choice but to sign a waiver. I don't even know if this is new charges. I don't know what this is about. So
the charge is battery on a peace officer. Okay.
Do you know?
It does not list the date.
Right, that's what I'm confused on because I don't live in Florida. I live in Georgia. So how did this even happen and when?
So generally, this process is for something that happened in the past.
I had 3 counts of battery on a police officer. I was on probation for 2 years for it, and I'm not on probation for that anymore. So I'm not understanding what this is coming from.
So again, I don't know either.
That's
the
what
people
I'm
in Florida, the people in Florida know. I'm not supposed to know.
Right, and when I contacted Florida, they're telling me different things, and I still don't have a clarification on what's going on and why I'm here.
So the reason you're here is because this warrant number popped up on your criminal history. And let me tell you the process. You encounter a police officer runs your information, shows a valid warrant pending. They then contact that jurisdiction. Hey, we have this warrant number, blah, blah, blah. I have this person here. Do you want me to hold this person or you want me to let this person go? Because we're feeding and clothing you. We don't care about anything else. We're doing this on behalf of Florida. So they said, hold her. So the confusion is not on our part. Because I guarantee you, that officer did not want to deal with this. That officer probably would have loved for them to say, nah, we don't want her. And say, hey, you got a warrant, man. You need to take care of that. Is that making sense about how to solve this problem?
Not really, but I'm signing paper.
Okay, I'm gonna try one more time, and you can sign the paper because I really need you to understand that I hear what you're saying about there being some kind of confusion, but the confusion is coming out of Florida. It's not coming out of Georgia. So once Ms. Barrington signs the waivers, send them over, and then she can be free to go back. But I would contact my probation officer or someone that family member or anyone that could speak on your behalf to try to clear this up if it really is a problem that's been taken care of.
They don't really allow us to use the phones here.
You will get a lot. I know it's not the way it is in some places, but you will be allowed to use it. Okay, let's start with Mr. Anderson, Larry Anderson. Mr. Anderson, sir, you're charged with 1 count of criminal trespass. I'm gonna give you a bond of $1,000. You're gonna have a preliminary hearing date set for May 10th at 8:30 in the morning, courtroom 201.
Yes, sir.
That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Sir.
You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, you're free to go back.
All right.
Mr. Askew.
Yeah, in 5 minutes. Yeah, in 5 seconds.
Mr. Askew, sir, you're charged with 1 count of terroristic threats or acts as a felony offense. This bond is going to be set at $10,000. There's going to be a stay away provision on the bond, a stay away from a Shataria Askew. Do you understand that, sir?
No, I don't.
What do you not understand?
That's my wife, the Clayton County, police officers, they put the warrant out. My wife didn't put it out.
Okay. So you do understand that you're supposed to stay away from her, correct?
No, I didn't.
Listen.
I'm listening.
I know she's your wife.
Mhm.
All right. That's and that's part of the reason there's a stay away provision placed on this. So if you were to violate this stay away provision, you get charged with aggravated stalking, your bond will be revoked, and you'll sit in jail until your trial.
Understand?
Do you understand that?
Yeah.
Okay, just as long as you understand the consequences of violating this order.
Gotcha.
Your preliminary hearing date is going to be set for May 9th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yeah.
You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any other questions for me?
Nah.
Okay, sir, you're free to go back. Mr. Blair? Do we have Mr. Blair, or is he OTB?
He's coming up here, all right, yeah.
Okay. Mr. Blair, sir, you're charged with 1 count of theft by deception. This is a misdemeanor offense. Bond is going to be set at $2,000. There's going to be a preliminary hearing date set for May 10th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
I don't.
Okay, you're free to go back.
Wait, do you tell me if we have any hold or any of the warrants? If you don't tell us we don't have any?
No, the jail knows. If the jail told you you have a hold, you have a hold. Their information is more current than what I received through the criminal histories.
Okay.
All right, you're free to go back. Mr. Boyd? Mr. Boyd, sir, you're charged with 3 counts of possession of a firearm by a convicted felon.
I didn't get that. Could you try again?
I don't know why my watch decides to talk to me. You're also charged with 1 count of possession of a weapon during the commission of a crime and violation of Georgia Controlled Substance Act, possession with intent to distribute, or possession of over an ounce of marijuana. All of these are felony offenses, and bond is not going to be set on these because there's a pursuant to Georgia statute 17-10-1, because there's an indication that you're either on probation or parole, and I cannot set bond at this proceeding. You're going to have a preliminary hearing date set for May 9th at 8:30 in the morning, courtroom 201. You're going to also have a bond hearing date set for May 13th at 8:30 in the morning, courtroom 201. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, Mr. Boyd. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Yes, I want to know what procedures I can take to file, being that my rights wasn't read and I wasn't presented with a arrest warrant. And I'm quite sure, and I'm very rounded with the law, that possession is 9/10 of the law. So how can I be charged with something if I was never in possession of it?
There's actual and constructive possession.
That's the Georgia way.
Okay.
All
Is there
right.
anything else, sir?
No, sir.
All right, you're free to go back.
Thank you, sir. Never bless.
You're welcome. You too. Mr. Calloway? Good morning. Mr. Calloway, do you know what you're being charged with, sir?
Yes.
I cannot set bond for these offenses at this stage, but I'm going to set a preliminary hearing date for May 9th at 8:30 in the morning, courtroom 201. I'm going to also set a bond hearing for May 13th at 8:30 in the morning, courtroom 201. Do you want me to see if you qualify for the appointment of a lawyer?
Yes.
You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, you're free to go back. Mr. Cooper.
Yes, Your Honor.
Mr. Cooper, sir, you're charged with one count of violation of Georgia Controlled Substance Act, possession with intent to distribute marijuana. I cannot set bond for this offense at this stage because there's an indication that you're placed on probation on March 7th of this year. So your bond is going to be denied pursuant to Georgia Statute 17-10-1. I'm going to set a preliminary hearing date for May 9th at 8:30 in the morning, courtroom 201. I'm going to also set a bond hearing date for May 13th at 8:30 in the morning, courtroom 201. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, Your Honor.
You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, you're free to go back.
Your Honor, would you want to see an add on Ms. Collier? Or was you already seen?
We're gonna save him to the end.
Yes, sir.
Mr. Dudley,
Chuck, who was that before,
I'm sorry.
person before Mr. Dudley? Who was that?
That was Mr. Cooper.
Okay.
Do you have Mr. Collier on your calendar?
No, Your Honor.
You talking to me, Judge?
Yes, ma'am.
No, because I just added him, so I'm gonna write his information in at the end.
Okay, so that's why I was gonna save him to the end.
Yeah.
Okay, Mr. Dudley.
Yes, sir.
Sir, you're charged with one count of family violence battery. Bond is gonna be set at $4,000. There's gonna be a stay away provision on this bond to stay away from a Luisa Cortez. Do you understand that, sir?
Yes, sir.
Your preliminary hearing date is going to be set for May 10th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you'll get a new court date in the mail. Do you want me, well, you're going to hire your own lawyer? You didn't fill out the form.
You can set me one for now, sir.
Why did you refuse to fill out the form?
I was gonna have my own lawyer, but I just going to take an attorney. I'll take one.
Are you currently working, Mr. Dudley?
Yes, sir.
How much do you make per hour?
I made $25 an hour. So.
Okay, you're close to the edge, but I'm going to find that you qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir. Appreciate it, sir.
Okay, you're free to go back. Mr. Gray?
Green. Yes. Next, sir. He said gray.
Gray, Mr. Gray.
Your Honor,
Yes, sir.
in the midst of the chaos, we forgot to grab Mr. Gray from medical, so we're gonna grab him. Do you mind if he goes last?
Yeah, that's fine. And Miss Mary, just for your record keeping, Miss Mary, he has a $5,000 bond for each count, and his preliminary hearing date is going to be May 10th.
Okay, thank you.
You're welcome. Mr. Green.
Yes, sir.
Sir, you're charged with one count of aggravated assault, which is a felony offense, one count of cruelty to children in the first degree, which is also a felony offense, and one count of simple battery. I'm going to set a $30,000 bond on the aggravated assault charge, a $10,000 bond on the cruelty to children in the first degree, and a $4,000 bond on simple battery. So you're going to have a total bond set at $44,000. There's going to be a stay away provision on the bond to stay away from a Lawrence Green. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for May 9th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you'll get a new court date in the mail. Are you going to hire your own lawyer?
Yes.
Okay. Do you have any questions of me?
No, sir.
Okay, you're free to go back.
Hines.
Mr. Hines. Mr. Hines, sir, you're charged with 1 count of loitering or prowling. This is a misdemeanor offense. Bond is going to be set at $1,000. 1 count of disorderly conduct. It's also a misdemeanor offense. Bond is going to be set at $1,500. 1 count of pedestrian walking along the roadway. That's a misdemeanor offense. Bond is set at $500, and 1 count of use of possession of drug-related objects. Bond is going to be set at $1,500. So you're going to have a total bond set at $4,500. Your preliminary hearing date is going to be set for May 10th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, you're free to go back. Mr. Hunter.
Johnson.
Mr. Hunter, sir, you're charged with 1 count of simple battery, family violence. Bond is going to be set at $4,000. There's going to be a stay away provision on the bond to stay away from a Cluelisa George. Do you understand that? Your preliminary hearing date is going to be set for May 10th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out. You didn't fill out the form. Do you plan on hiring your own lawyer?
No, sir. I had to go do fingerprint, but
Okay.
I need to put it through.
Okay. Are you currently working, sir?
No, sir.
How much do you make per hour?
No, I said I'm not working right now.
Oh, you're not? Okay. Well, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, you're free to go back. Mr. Johnson. Mr. Johnson, you're charged with 1 count of improper lane change. Bond is going to be set at $500 for that. You're charged with 1 count of financial transaction card theft. That's a felony offense. I cannot set bond for that offense at this stage. On pursuant to statute 17-10-1. You're also charged with violation of Georgia Controlled Substance Act, a felony offense. I also cannot set bond on that offense pursuant to statute 17-10-1. You're charged with 1 count of use of possession of drug-related objects. Bond is going to be set at $1,500. That's a misdemeanor. 1 count of having a dangerous drug outside of the container. That's also a misdemeanor. Bond is going to be set at $2,000. And you're also charged with theft of lost or mislaid property. Bond is going to be set at $2,000. You're going to have a preliminary hearing date set for May 9th at 8:30 in the morning, courtroom 201, that date. And you're going to have a bond hearing date set for May 13th at 8:30 in the morning, courtroom 201. Now, would you unmute him, Deputy Requena?
So the financial credit, where did it come from?
Hold on, I'm gonna let you ask some questions, Mr. Johnson, but I gotta get through what I need to say, okay? You did not fill out the form. Is it your plan to hire your own attorney?
No, it's not. I got injuries, so I really been in and out. I've been like sleep. I went to the hospital yesterday. They really didn't even see me for what I was supposed to go for. I guess
okay.
They just wanted to, we were just gonna write them down as a drug user. And, like,
are you currently working, Mr. Johnson?
No, sir, I'm not.
Okay, I'm going to appoint a lawyer to represent you. Now, you had other questions. What were your other questions?
So where did the fight? Where did the second charge? Where did it come? Where did that come from?
All right, it is said that you had a number of cards in your possession.
Okay, and I didn't have them in my possession. They were within my car with like 10 other different people, clothes and stuff in it too. As well as I'm trying to figure out like how they 3 of those cars have my name on it, 4 of them was hotel key cards. I'm trying to figure out where did the financial like what's the name of the charge? It's like they're saying I made a I made a transaction with them or something. I'm not understanding.
Okay, it said you gave the officer a driver's license that had the name of Kelvin Blount.
I did not.
Mr. Johnson.
I'm sorry, I apologize. So it is, bro. It's a lot going on. Like it's overwhelming, but like
Mr. Johnson, take a breath, please. Okay, because we can't talk over each other. And I promise you, I'm gonna answer your question and then I'm gonna keep my mouth closed and listen to you. Can you keep your mouth closed and listen to me?
Yes, sir.
Thank you. It said that you had that driver's license in your pocket. You stated it belonged to a friend, but you did not tell the officer how it came into your possession. So that's why you were charged with that. These are allegations, doesn't mean you're guilty. But again, there's an indication that you're on, I think, probation. So I can't set bond at this stage for felony offenses or misdemeanors involving an allegation of violence when a person is on probation or parole. So I've appointed a lawyer to represent you. If this person is someone that you know, this Mr. Blount person, you need to get your lawyer in contact with that person. Okay. Is there anything else?
Yeah, so that's what it's saying. It's saying that he because from what officer told me yesterday, it's something that's in Cobb County. I don't even be in Cobb County, so that's what I'm trying to figure out. Like, what's the it's saying financial, like how is it financial that somebody, if they caught somebody, they found somebody ID in my car?
So again, these are allegations. And what I try to remind people is everybody that went to trial and was acquitted or had their charges dropped, they all went through this process. So this is not a trial. This is not a point for me to determine your guilt or innocence. This is to set bond if I can, give you court dates, and appoint a lawyer. Okay.
Yes, sir. And do you see how many holes do I have? How many, what county do I have holes?
Do I see what county what?
What counties do I have a hole in? How many holes do I have?
So the jail would know the holes. Looks like I'm gonna presume it was out of DeKalb County. You got 8 years probation in 2019. In Clayton County, I don't see a resolution for the possession of cocaine from August of last year. Okay.
All right.
Okay, so you're free to go back.
Lane. Alexander Lane.
Oh, he should have been taken off. He had his first appearance yesterday.
Yes, Your Honor.
Mr. Morrell?
Yes.
Yes, sir.
Mr. Morrell, it looks like you had 2 charges, disorderly conduct and simple assault. It looks like you went before Judge Knights yesterday on a disorderly conduct, but not the simple assault.
Okay.
So you're charged with simple assault, and bond's gonna be set at $4,000. I saw that Judge Knights appointed Lister and Holt to represent you. So I'm just going to write on today's form that you were appointed yesterday. And so you should have been given May 10th as a preliminary hearing date. Is that correct?
Yes, sir.
Okay. Do you have any questions about this?
No, sir.
Okay. You're free to go back.
All right.
Mr. Oliver.
Yes, sir.
Mr. Oliver, sir, you're charged with one count of simple assault. Bond is going to be set at $3,000. You're also charged with one count of reckless conduct. Bond is going to be set at $2,000. So that's a total bond of $5,000. There's going to be a stay away provision on this bond to stay away from a Kajava Winston. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for May 10th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
No, sir.
Okay. You're going to hire your own lawyer?
Yes, sir.
All right. Do you have any questions for me?
No, sir.
Okay. You're free to go back.
All right, thank you.
You're welcome. Mr. Presley.
How you doing, sir?
I'm doing well. Mr. Presley, you're charged with two counts of, well, one count of financial transaction card theft, one count of financial transaction card fraud, one count of forgery in the first degree, and one count of identity fraud. These are all felony offenses, and I cannot set bond at this stage pursuant to Georgia statute 17-10-1. I am going to give you a preliminary hearing date of May 9th at 8:30 in the morning, courtroom 201. I'm going to also give you a bond hearing date of May 13th at 8:30 in the morning, courtroom 201. Now you clicked refuse. Does that mean, or click, you wrote refuse, that mean you're going to hire your own lawyer?
No, sir.
Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay. Are you currently working?
No, sir. I had a job interview today.
Okay. You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Yes, sir. So I was on those 4 charges they said I have. Detective called my phone and said that my name came across, you know, the things that they said I have, but I didn't do it, sir, because I was home that day. Basically, it was not.
Hold on, Mr. Presley.
I'm sorry.
It's better that you tell this to your lawyer, because there's nothing that you can tell me that's gonna assist you. You can only hurt yourself.
Yes.
Okay.
Right.
You have any other questions for me?
No.
Okay, you're free to go back, sir.
Your Honor, we have Mr. Gray present.
Okay. Mr. Gray, sir, you're charged with one count of interference with custody and one count of contributing to the delinquency or deprivation of a minor. Both of these are misdemeanor charges, and I've set the bond at $5,000 for each count for a total bond of $10,000. There's a stay away provision on this bond to stay away from a Chiasis Wellington, CHYASIS. Do you understand that, sir?
Yes, sir.
And if you were to violate this condition, you could be charged with the felony offense of aggravated stalking. Your bond would be revoked and you could remain in jail until your trial. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for May 10th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
So how y'all gonna charge me with a charge already been convicted for?
I'm going to say that that's non-responsive. Do you want a lawyer or not?
Yeah.
And I didn't charge you with anything. I'm just telling you what you're charged with. Are you currently working?
No, sir.
You do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me about this process? All right, you're free to go back. Mr. Sampson.
Yes, sir.
Mr. Sampson, sir, you're charged with 1 count of simple assault. That's a misdemeanor. Bond is set at $3,000. You're charged with 1 count of reckless conduct. Bond is set at $2,000. You're charged with 1 count of terroristic acts or threats. That's a felony. Bond is set, or actually, I dismissed that count. So I dismissed the felony, terroristic threats or acts. So you're just going to have 2 charges, the simple assault and the reckless conduct. There's going to be a stay away provision on this bond to stay away from a Kajava Winston. Do you understand that? Your preliminary hearing date is going to be set for May 10th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Are you going to hire your own lawyer?
No, sir.
You wrote refuse on the form.
Sir?
You wrote refuse on the form.
Right.
This is a form that I use to make the determination as to whether you qualify for a lawyer or not.
Yes, sir.
Are you currently working?
No, sir. Yes.
And you do want me to appoint a lawyer?
No, sir, no.
Okay. You're going to represent yourself? Okay. All right. You're free to go back, sir.
Thank you.
You're welcome. Mr. Shakib?
Shake.
Shake?
Yes, sir.
Sir, you're charged with 1 count of theft by receiving stolen property, being a motor vehicle. I cannot set bond for this offense at this stage pursuant to Georgia statute 17-10-1 because it appears that you're on probation or parole. I'm setting a preliminary hearing date for May 9th at 8:30 in the morning, courtroom 201. I'm also setting a preliminary hearing date for May 13th in courtroom 201.
So
I'm sorry?
So what's the other first, the second court date?
May 13th is a bond hearing date. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay. Okay, I'm going to find that you qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Yes, I thought I was done with that probation, sir. Because I have signed the papers and all that, so I was done. That's why, even the officer yesterday, he pulled my criminal history, and I kept asking. He said, "No, I don't have." He said, "You don't have a probation. You look like you're off the probation." It's not showing on his calendar.
Okay, hold on.
Sure about that, sir. I went to my office of probation. I signed the papers to get off probation.
Okay, it looks like out of Clayton County is showing a sentencing date of December 19th of 2019. You're sentenced to 4 years on a probation of possession of cocaine charge.
Yes, I understand it. And they had called me out of nowhere one time because I was working. So and they told me to come to the office. So when I went to the office, they made me waive it off, sign my papers on saying that I'm done with probation. So and that's why I asked the officer yesterday, because I want to go back to see my daughter last night, trying to see if I can get a bond.
Okay, so I cannot set bond when it's showing that you are still on probation. Now, everything you're telling me may be completely true, but you're going to have to get in contact with your probation officer so that this can come to light, but it's still showing on my end.
That I'm still on?
Yes, sir. Okay, you're free to go back. Mr. Tally?
Yes.
Tailly?
Yes, sir.
Okay, sir. So there's a charge that was obtained yesterday, a warrant for your arrest yesterday afternoon for identity fraud. And it looks like it's connected to this Sam's Club.
Sounds good.
Wait a minute. Hold on. Costco incident. I'm going to deny bond at this charge on this count, the identity fraud count. I'm going to set a preliminary hearing date for May 9th at 8:30 in the morning, courtroom 201. I'm going to set a bond hearing for May 13th at 8:30 in the morning, courtroom 201. Do you want me to see if you qualify for the appointment of a lawyer? Do you already have a lawyer?
No, I don't have a lawyer.
Would you like for me to appoint a lawyer?
Yes, sir.
Are you currently working, sir?
No.
Okay. I'm going to find that you qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
Yes, sir. I got a question because of the first one they say I got to cut to the first. That one is I'm not gonna know the first.
Could you speak up a little bit? I can barely hear you.
Okay, I said the first one I come into the court, they say I go to the court to the first. Next month the first. No, I'm not gonna know more the first.
Deputy, I can't hear him. Can someone, I heard something about court.
Speak up, speak loud and clear, we got understand.
Yeah, I come into court the last time, they say I go to court the first, next month the first. I'm not gonna know more the first.
The 1st of May?
Yeah, they say I have to go to court by court.
It's, okay, so when were you told that?
No, the last time I was in here, the court.
When was the last time you were in here?
It was in the 15th.
Okay, so you still have that date, okay?
Okay.
And it appears that this may be related to that, but this warrant was obtained yesterday. So tell your lawyer about these new charges, and they maybe can get them moved over to that same date.
Okay.
Okay?
All right, thank you, sir.
You're welcome. Mr. Ulmer.
Yes, sir.
All right, sir, you're charged with 1 count of driving on a suspended license. The bond is set at $1,500. This is a misdemeanor offense, so your preliminary hearing date is going to be set for May 10th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir. I was wondering if I really could get a signature bond, sir. And I'm in a very bad bind for cash, sir, and I really need to get out so I can start a new program and job, sir.
All right, so the way that this process works, your criminal history is a little too bad.
That's why I got to start a new program. That's what I'm saying. I was actually going to they asked for a physical for the program that I'm supposed to be starting. That's why I was even out, sir. I was going to get the physical to do and comply with what you guys are saying. That's
okay.
Honest.
Yeah, I can't give you, you have 25 cycles. I can't give you a signature bond. Okay, sir.
All right.
Do you want me to appoint a lawyer to represent you?
Yes, sir.
Are you said you're not currently working?
No. I mean, I was supposed to start the program for you guys. That's what I'm saying. I'm supposed to be reporting everything come today for the program. That's why I was out taking the physicals and everything for the aggravation and the whole program itself. Like I said, I'm a mental health patient and a veteran, so that's why the charges was what it was. So I'm supposed to be appointed to mental health court right now, and I was out taking the physical. So,
Okay. Is that before Judge Mack?
I'm not sure who.
No, I'm sorry, is it Judge Rooks Malone?
I'm not sure who the judge is, sir. They contacted me through my lawyer, sir. That's what I'm saying. Like, this was really a bummer, me trying to do the right thing. That's why I was asking for a signature, sir.
Okay, well, you can't drive with the suspended license.
I really just had, like I said, I went to the store to put the gas back, which was.
I understand. I'm just, when you say you're trying to do the right thing, you got to do the right thing. Okay. So get in contact with your lawyer. Your lawyer may be able to because the solicitor's office can consent to a bond on this and for you to get out. Your lawyer should know the circumstances that you're dealing with, but I can't deal with that at this stage.
All right.
Okay, you're free to go back. Mr. Collier. Mr. Collier, sir, you're charged with 1 count of family violence battery. Bond is going to be set at $5,000. This is a misdemeanor offense. There's going to be a stay away provision on this bond to stay away from a Jessica Chamberlain. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for May 10th at 8:30 in the morning. Courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes.
Are you currently working, Mr. Collier?
Yes.
About how much do you make per hour?
Like $10.
Okay, you do qualify, sir. Going to appoint a lawyer to represent you. Do you have any questions of me?
Yes, sir. You said the bond is $5,000.
Yes, sir.
I just heard somebody with the same charges there was $4,000. Can I ask why is mine higher?
Because I looked at your allegation and looked at the other person's allegation, and they're different.
Okay, no problem.
Okay, you're free to go back. All right, does that complete the calendar?
Yes, sir. Everybody.
Okay.
Bond Court is a free service, but it takes several hours of my time every day. Less than 10% of Bond Court viewers hit the like button, and less than 1% leave a comment. If you want Bond Court to continue to be available on YouTube for free, then please hit the like button and leave a comment on all of my videos.
All right, I'm ready. Good morning, everyone. This is your first appearance hearing before the Magistrate Court of Clayton County. My name is Brad Gardner, and I'm a judge in this court. I'm here to inform you of the charges that have been filed against you, to advise you of certain rights, to set bail on those offenses that I'm authorized to set bail, to schedule a preliminary hearing, and to determine whether you require the assistance of an attorney. You have the right to remain silent and say nothing, but should you give up this right, anything you say during this proceeding may be used against you. So please don't discuss the facts of your case. During this and all of the proceedings, you have the following rights: to the presumption of innocence, to indictment by a grand jury for most felonies or by accusation for misdemeanors, to a speedy and public trial by jury, to see, hear, and question witnesses who are called to testify against you, to compel the attendance of witnesses to testify on your behalf, to testify on your own behalf or offer evidence in your own defense, and to have an attorney represent you. If you cannot afford an attorney, one can be appointed to represent you if you qualify. Some of you will be allowed to post unrestricted bonds for your release from jail. These bonds may be posted by cash, commercial, or property. Some of you will have special conditions on your bond that prohibit you from contacting certain people or going to certain places. You will also be prohibited from contacting the victim while you are in jail. If you violate the court's order, your bond will be revoked and you can remain in jail until your trial. You could also receive additional felony charges. It is important to note that if someone is listed as a victim in your case, that person would not be allowed to post your bond. Some of you are charged with offenses for which this court is not authorized by law to set bail. In this event, a bond hearing will be scheduled before a judge of the Superior Court of Clayton County, and you will be informed of that date. If you are currently on active probation, this court is not authorized to set bond at this time. Where the bond is appropriate in your case will be reconsidered after your probation officer has had an opportunity to consider this new arrest. The purpose of a preliminary hearing is to determine whether there is sufficient evidence to support the allegations against you. The standard at this stage is very low. A judge determining whether a charge goes forward at this stage only has to determine that it is possible that the crime occurred. Everyone has the ability to waive their right to a preliminary hearing. However, you should speak to a lawyer first if you are unsure about whether it is appropriate to waive your preliminary hearing. If you post bond, your preliminary hearing is automatically waived. You will receive notice at the address you give of your next court date. Finally, would everyone please raise your right hand for me, please? Do you swear or affirm that any statements you make during this proceeding shall be the truth, the whole truth, so help you God?
Yes.
Okay, let's begin on the ladies' side with Teresa Cartwright. Ms. Cartwright, you're charged in count 1 with committing the offense of family violence battery. It was written as a felony, but when I checked your criminal history, this is actually a misdemeanor. Your bond is going to be set at $5,000 for this offense. You've also been charged with cruelty to children in the first degree, third degree, I'm sorry. And that is also a misdemeanor. Bond is going to be set at $3,000. You're going to have a total bond set at $8,000. There's going to be a stay away provision on this bond to stay away from a Latasha Cartwright. Do you understand that?
Yes.
Your preliminary hearing date is going to be set for May 10th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
You do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, ma'am, you're free to go back.
Thank you.
Ms. Griffin? Ms. Griffin, ma'am, you're charged with possession of marijuana less than an ounce. This is a misdemeanor offense. Bond is going to be set at $1,500. You're going to have a preliminary hearing date set for May 10th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
That's fine.
About how much do you make per hour?
I'm kind of in between jobs. I work at a temporary agency, so per hour I make. Last job I was making $17.50.
Okay, you do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, ma'am, you're free to go back. Ms. Pert is going to be continued until tomorrow. We have Ms. Pinnock.
Her name again, Judge?
Ms. Pert, P-E-A-R-T.
Okay, thank you.
You're welcome. Are you Ms. Pinnock?
Yes.
Ma'am, you've been charged with 1 count of simple possession of a controlled substance, being ecstasy. This is a felony offense. I'm going to set the bond at $3,000. There's going to be a preliminary hearing date set for May 11th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
Okay, you do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, I do not. Thank you.
Okay, ma'am, you're free to go back. Ms. Presley?
Yes, sir.
Ms. Presley, ma'am, you're charged with 1 count of misdemeanor theft by shoplifting. Bond is going to be set at $2,000. And you're also charged with a misdemeanor count of giving a false name, address, or date of birth. Bond is also going to be set at $2,000. That's a total bond of $4,000. You're going to have a preliminary hearing date set for May 10th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll receive a new court date in the mail.
So it's getting waived over?
I'm sorry, ma'am.
Is it getting waived over? Being waived?
The short answer is no. If you would like to have this waived over, you can. But you're gonna have to sign a form, and we're gonna have to send that form over. Do you have waiver forms over there, Deputy Bush?
Yes, Your Honor.
Okay, so if you want to sign a waiver, ma'am, you can sign a waiver. In this case, will get sent to state court. It also will get sent to state court as soon as you bond out.
I'm saying so I go to court on May 10th.
Okay. I want you to take a moment, ma'am. Stop writing. Right now, you have a preliminary hearing date set for May 10th. Once you, ma'am, I need you to look at me. Because if you ask me this question one more time this will be the third time I'm saying this. You have a preliminary hearing date set for May 10th at 8:30 in the morning. Once you bond out, your case gets sent over to state court.
What if I don't get bonded out?
I was about to get there, ma'am. If you don't believe that you're gonna make bond,
yeah.
Ma'am, do you want to try this again tomorrow?
I mean, because you can't go on if I don't make money, then what?
Okay, ma'am, I'm gonna put you on mute because you apparently don't realize that I'm a judge. I'm not your friend on the street. I'm not somebody that you can just speak to in any kind of way. I'm speaking to you in a respectful manner, and I expect you to speak to me in a respectful manner. If you cannot do that, we can try again tomorrow.
I'm calm.
Thank you. If you do not believe you're going to post bond, you can waive your preliminary hearing right now, and the paperwork will get sent straight to state court. They have, ma'am.
I'm listening.
They have up to 2 years to bring your charges. Okay, so I'm just trying to explain this to you. I didn't make the rules. I'm explaining the rules to you.
Okay.
So what do you want to do?
I ain't gonna waive.
Okay. Would you like for me to appoint a lawyer to represent you, ma'am?
Yes, sir.
You do qualify, ma'am. I'm going to appoint a lawyer to represent you.
All right.
Do you have any other questions for me, ma'am?
No, sir. Thank you very much.
You're welcome. Have a good day.
You too.
Miss, is it Kwaye? Quay, Miss Quay.
Yes.
Ma'am, you're charged with 1 count of criminal damage to property in the 2nd degree. This is a felony offense. Bond is going to be set at $5,000. There's going to be a stay away provision on this bond to stay away from an Antoine Parker. Do you understand that?
Yes, sir.
Your preliminary hearing date will be set for May 11th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, please.
You do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, ma'am, you're free to go back. Ms. Smith? Ma'am, you're charged with, good morning. You're charged with 1 count of simple battery, family violence. Bond is going to be set at $4,000. This is a misdemeanor offense. There's going to be a stay away provision on this bond, stay away from a Rashawn Berry. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for May 10th at 8:30 in the morning, courtroom 201. The date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, thank you.
Okay. Okay, ma'am, you're free to go back. Ms. Walton?
Your Honor.
Good morning, ma'am. You're charged with one count of a window tint violation on the vehicle. That's a misdemeanor offense. Bond is set at $500, and one count of misdemeanor possession of marijuana. Bond is set at $1,500 for a total bond of $2,000. Your preliminary hearing date is going to be set for May 10th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you will receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
I'm going to find that you qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, ma'am, you're free to go back.
Thank you, Your Honor.
Finally, Miss Williams.
Good morning.
Good morning. Ms. Williams, you're charged with one count of battery. This is a misdemeanor offense. Bond is always set at $5,000. There's going to be a stay away provision on this bond to stay away from a Valencia Lipscomb. Do you understand that?
Say that one more time, please.
Valencia Lipscomb.
Okay, to stay away.
Yes, ma'am.
Okay, you said 5,000.
I'm sorry.
You said bond was 5,000.
Yes, ma'am.
Okay.
Your preliminary hearing date is set for May 10th at 8:30 in the morning, courtroom 201. I don't have a court-appointed form for you. Did you want me to see if you qualify for the appointment of a lawyer?
Yes, please.
Are you currently working?
Yes,
About how much do you make per hour?
like $22.
That still qualifies. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, thank you. That'll be all.
Okay. You're free to go back.
Thank you.
All right. That's all I have on the lady side. Did I miss anyone?
No, Your Honor.
Okay. Thank you for your assistance. Let's switch over to the male side. Are you Mr. Asbury?
Yes, Your Honor.
Okay, sir. Do you know what you're charged with?
Yes, I do.
I cannot set bond for these offenses at this stage. I am going to set a preliminary hearing date for May 11th at 8:30 in the morning. And just for the record, I have a person who's writing this down. For the warrant number ending in 1-2, no bond pursuant to 17-6-1. For the warrant ending in 1-3, no bond denied. The warrant ending in 1-4, no bond denied. The warrant ending in 1-5, no bond pursuant to 17-6-1. And the warrant ending in 1-6, no bond denied. Your preliminary hearing date, sir, is going to be set for May 9th at, May 11th at 8:30 in the morning. Your bond hearing is going to be set for May 13th at 8:30 in the morning. Do you want me to see if you qualify? It says refuse. You have hired your own lawyer? Do you plan on hiring a lawyer?
Yeah, I do. Yes, I do.
Okay. Do you have any questions for me, sir? Okay, you're free to go back. Mr. Banks. Mr. Banks. Are you Mr. Banks?
Yes, sir.
Mr. Banks, sir, you're charged with 4 driving-related offenses. The first is driving a vehicle without a valid license. Bond is going to be set at $1,000. The second count or charge is driving a vehicle with no insurance. Bond is also going to be set at $1,000. Driving a vehicle with no license plate. Bond is going to be set at $500. and driving a vehicle with an invalid registration, bond is going to be set at $500. So you're going to have a total bond set at $3,000. Your preliminary hearing date is going to be set for May 10th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer? I'm sorry, sir?
Yes, sir.
You do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, you're free to go back. Mr. Berry. Mr. Berry, sir, you're charged with one count of identity fraud. I've set the bond at $10,000. This is a felony offense. Your preliminary hearing date is going to be set for May 11th at 8:30. I'm sorry, May 9th, because you have a co-defendant, Mr. Talley. And I believe I set his preliminary hearing date for May 9th. So I'm going to place the two of you on the same preliminary hearing date. It's going to be 8:30 in the morning, courtroom 201. He does not have a bond. You have a bond. So if you bond out, your preliminary hearing is going to get waived and you will receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay. How much do you make per hour?
$15.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
I'm just sorry. What was the bond amount again? Please?
$10,000.
Okay.
Anything else, sir?
No, sir. Thank you.
Okay, you're free to go back. Mr. Blair.
Good morning, Your Honor.
Good morning, Mr. Blair, sir. You're charged with 2 drug-related offenses. Possession of Schedule 1 controlled substance and possession of more than an ounce of marijuana. These are 2 felony offenses. I've set the bond at $10,000 apiece for a total bond of $20,000.
All right.
You're going to have a preliminary hearing date set for May 11th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you'll receive a new court date in the mail. Do you plan on hiring your own lawyer or do you want me to see if you qualify for the appointment of a lawyer?
My mom.
Okay. Do you have any questions for me, sir?
That'll be all, sir.
Okay, you're free to go back. Mr. Cook.
Good morning, Your Honor.
Good morning, Mr. Cook. You're charged with a number of driving related offenses. The first is felony fleeing from a police officer. I've set the bond at $10,000 for that charge. Reckless driving, I've set the bond at $3,000. A misdemeanor count of fleeing from a police officer, I've set the bond at $2,000. Driving on a suspended license, bond has been set at $1,500. Operating a vehicle with, says, I think it said without proper registration. It's the warrant number ending in 51821. I've set the bond at $1,000 and a window tint violation. The bond is going to set at $5,000. So you get a total bond of $18,000. Your preliminary hearing date is going to be set for May 11th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, Your Honor.
How much do you make per hour?
$17.75.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, Your Honor.
Okay, you're free to go back. Mr. Crockett.
Good morning, Your Honor.
Good morning, Mr. Crockett. Sir, you're charged with 3 driving related offenses. Improper lane change, bond is going to be set at $500. Driving a vehicle on a suspended license, bond is set at $1,500. And misdemeanor possession of marijuana, bond is also set at $1,500. So that's a total bond of $3,500. Your preliminary hearing date is going to be set for May 10th at 8:30 in the morning. Courtroom 201. That date will get waived upon your bonding out. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, Mr. Crockett. I'm going to appoint a lawyer to represent you. Do you have any questions for me, sir?
No, sir.
Okay, you're free to go back. Mr. Davis. So Davis, sir, you're charged with 1 count of misdemeanor theft by taking. Bond is set at $2,000. You're going to have a preliminary hearing date set for May 10th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Are you currently working?
Not at the moment.
Okay. You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, Mr. Davis, you're free to go back. Mr. Diallo.
Yes, sir.
Mr. Diallo, sir, you're charged with 4 driving related offenses. The first is driving a vehicle on a suspended license. Bond is going to be set at $1,500. The second charge is driving a vehicle with a suspended cancellation or registration. Bond is going to be set at $500. The third charge is driving a vehicle without insurance. Bond is going to be set at $1,000. And failure to maintain insurance. It says policy card. Bond is going to be set at $1,000. So that's a total bond of $4,000. Your preliminary hearing date is going to be set for May 10th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, you do qualify, Mr. Diallo. Going to appoint a lawyer to represent you. Do you have any questions for me?
Yes, sir.
Okay, you're free to go back. Mr. Gilliam.
Morning, Your Honor.
Good morning, Mr. Gilliam. Sir, you're charged with 4 offenses. The first is aggravated assault, which is felony offense. I set the bond at $15,000. The second charge is theft by receiving stolen property. I've dismissed that charge because there's nothing in the warrant about any stolen property. The second or the third charge is possession of marijuana less than an ounce. That's a misdemeanor. Bond is set at $1,500. And finally, there's an open container violation. Bond is set at $500. So you're going to have a total bond set at $17,000. Your preliminary hearing date is going to be set for May 11th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, Your Honor.
You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Your Honor.
Okay, you're free to go back.
Thank you, Your Honor.
You're welcome. Mr. Goddard.
Good morning, Your Honor.
Good morning, Mr. Goddard. You're charged with possession of more than an ounce of marijuana, which is a felony offense. I'm going to set the bond at $10,000 for that charge. You're charged with possession of a weapon during the commission of a crime. I'm going to set the bond at $5,000. You're charged with driving a vehicle with no license. Bond is going to be set at $1,000. And finally, you're charged with driving a vehicle on an expired tag. Bond is going to be set at $500. So your total bond is going to be set at $16,500. Your preliminary hearing date is going to be set for May 11th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like me to see if you qualify for the appointment of a lawyer?
Yes, Your Honor.
All right, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, Your Honor. Just have a great day.
You too. Mr. Grayer.
Good morning, Your Honor.
Good morning, Mr. Grayer. Sir, you're charged with one count of entering an automobile. I'm going to set the bond at $10,000. This is a felony offense. Your preliminary hearing date is going to be set for May 11th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
All right, I'm going to find that you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir. Thanks.
You're welcome. You're free to go back. Mr. Hewitt.
Good morning, Your Honor.
Good morning, Mr. Hewitt. Sir, you're charged with one count of criminal trespass, damage to property. This is being written as a misdemeanor offense. Bond is going to be set at $4,000. You're going to have a preliminary hearing date set for May 10th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, sir. I'm going to appoint a lawyer to represent you. And I neglected to mention that I place a stay away provision on this bond, to stay away from a Chandler Smith. Do you understand that?
Yes, sir.
All right, you're free to go back.
Thank you.
You're welcome. Mr. Ivory. Good morning, Mr. Ivory, sir. You're charged with a number of offenses. Defective equipment, that's a misdemeanor charge. Bond is set at $500. Driving a vehicle with an obstructed windshield, bond is set at $500. Failing to dim the lights is another misdemeanor offense. Bond is set at $500. Failure to change the address on your driver's license, bond is set at $500. Now, you have several drug-related offenses. Possession of THC gummies, that's a felony offense. I'm denying bond at this point on that charge. Possession of marijuana more than an ounce, I'm denying bond. That's another felony offense. I'm denying bond at this point. Possession of MDMA is a felony offense. I'm denying bond on that. And possession of a weapon during the commission of a felony, I'm denying bond on that. You're charged with the misdemeanor offense of use or possession of drug-related objects. I'm setting a $1,500 bond. You're going to have a preliminary hearing date set for May 11th at 8:30 in the morning, courtroom 201. You're also going to have a bond hearing date set for May 13th at 8:30 in the morning, courtroom 211. Did you fill out a form for appointment of counsel?
Yes, I did.
Okay, I don't see it. Do you want me to see if you qualify for the appointment of lawyer?
Yes, sir.
Are you currently working?
No, sir.
All right, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, you're free to go back. Mr. Kelly. Good morning, Mr. Kelly. So you're charged with two driving related offenses, distracted driving, and driving on a suspended license. I'm going to dismiss the distracted driving charge at this point. The driving on a suspended license bond is going to be set at $1,500. You're going to have a preliminary hearing date set for May 10th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if, you refuse? You're going to hire your own lawyer? Okay, do you have any questions for me?
No, sir, thank you.
All right, you're free to go back. Is Mr. Lee OTB?
Yes, Your Honor.
Thank you. Mr. Minor.
Good morning, Your Honor.
Good morning, Mr. Minor. Do you know what you're charged with, sir?
Yes, sir.
I cannot set bond for these offenses at this time. And just for the record, Miss Mary, the warrant ended in 8-7, bond is denied. Warrant ending in 8-8, bond is denied pursuant to 17-6-1. And the warrant ending in 8-9, bond is going to be denied. You're going to have a preliminary hearing date set for May 11th at 8:30 in the morning, courtroom 201. This offense is one that the bond hearing can only be heard before a superior court judge. So your bond hearing date is going to be determined, okay? Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay. You do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir. Thank you very
Okay.
much.
You're welcome. Have a good day.
You have a great day too.
Mr. Myrick.
Good morning, sir.
Good morning, Mr. Myrick. So you're charged with one count of battery. This is a misdemeanor offense. However, I can't set bond for this pursuant to Georgia statute 17-10-1 because there's an indication that you're on probation or parole. Okay. So what's showing to me is that you're on probation. These records sometimes can be wrong, but if I see it and it says that you're on probation, I have to accept that, okay? Does that make sense to you?
Yes, sir.
So if you're not on probation, I'm gonna appoint a lawyer to represent you at the end of this if you want. The first discussion you should have with that lawyer is that the judge denied my bond because the judge said I was on probation, but I'm not on probation. So this is a misdemeanor offense, which normally you would be entitled to a bond. So if this is what's showing is wrong, then you'll get a bond and you'll get out. Okay?
So I have to wait until May though?
No, sir. No, sir. Apparently, if you're not on probation, you have some paperwork that shows that. Because they'll release you from probation and you'll get a piece of paper that says you have been released from probation.
Yes, I'm only out on one bond. That's how I know I'm not on probation, sir.
Okay. Do you want me to look again?
Yes, sir, please.
Okay. All right, so it says November 23rd, 2020, there's this is cycle 17. There's a probation violation out of Troup County. You received first offender. No, wait a minute. So it says on January 15th of this year, you were arrested. It says receive possession or transport firearm by convicted felon or felony first offender. Cycle 2 or charge 2 in that was obstructing or hindering a person making an emergency phone call. You got and that was cycle 18. So you can point your lawyer to the January 15, 2022 arrest. I'm sorry?
What is that, probation? I thought I'm out on bond for that.
The charge says,
yes, I was on first offender before. I've been got off probation. I sealed that going to prison in 2017.
okay. So now you see what I'm looking at. I've directed it to your attention, what I am going on.
Yeah,
I could be 100% wrong, but once I see that, I can't ignore it as if it doesn't exist. Okay?
Yes, sir.
I know you don't like it, but I'm trying to explain.
Yeah, I understand, sir. I understand.
Yeah.
I just wanted a better understanding because I know I'm not on probation. So when I talk to my lawyer, that's when I'll be able to get a bond.
Yes, and I would call my old probation officer, because if they have released you off probation, that's a document that's in that file.
I ain't been on probation since 2017. I don't know who to talk to. That's why I don't know where to start at.
Okay.
Probation.
Well, you got a probation violation in 2020. You wouldn't have a probation violation if you were off probation in 2017.
In 2020, what is that?
From Troup County Sheriff's Department.
I went to jail in Troup County. I never took no probation, nothing.
Okay, the charge is probation violation.
No, that was a
case number 20R0146, Troup County Sheriff's Office. So do you understand how I just can't take your word for it? Because you are the person that, if you were going to be dishonest with me, and I'm not saying you are, this will be the time to be dishonest with me. I'm telling you what I'm looking at, so that if this is wrong, it can be remedied. But I just can't take your word for it when I'm looking at this that tells me something different.
Can I ask you one question, Judge?
Yes, sir.
So well, I know it's a mistake. So how long would I have to wait until they handle it? Like,
you are gonna wait as long as you allow this to linger.
I don't have.
When you say they, so if you left this hearing, if we ended this discussion, you immediately left this hearing, I've armed you with the information you need to be able to get yourself out quickly. We can sit here and we can sit here and go round and round about this. I've given you the information. My decision is not going to change. So I know you don't agree with it, but I've explained what I'm looking at. And if I'm wrong, this can be remedied. It can get fixed today if you had the information.
I don't see where I gotta start at, sir. I don't have anybody I can call, no probation officer, no none of that. I don't know where I started, sir, but you could proceed on and let me know so I can go.
Okay. Cruelty to children in the 3rd degree is a misdemeanor. Bond is going to be set at $3,000. There's going to be a stay away provision on this bond to stay away from a Fabricia Wilder. Do you understand that?
Yeah.
Your preliminary hearing date is going to be set for May 10th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you will get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes.
Okay. You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any other questions for me?
One last question. Say you do find out it's incorrect. How would I know if I had a bond? When would I find out if I have a bond for my other charge?
So, two things. Your probation officer can fax over. You asked me.
I'm around no probation officer. I ain't been on no probation. I'm good though, so I got all the information I need. Thank you. Have a nice day.
You too. Mr. Nay?
Yes, Your Honor.
So you're charged with one count of criminal trespass, being that you were given a criminal trespass warning on April 1st to stay away from the airport and you came back. This is a misdemeanor offense. Your bond is going to be set at $1,500. Your preliminary hearing date is going to be set for May 10th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir, please.
You do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, you're free to go back.
Thank you.
Mr. Is it Oregio?
Good morning, y'all.
Good morning. Mr. Oregio, sir, you have 3 criminal arrest warrants and 3 misdemeanor charges. And these are, you're going to have 2 preliminary hearing dates because the first set of charges are felonies, the second set of charges are misdemeanors, okay? You're charged with theft by deception, bond is going to be denied on that felony offense. You're charged with identity fraud, bond is going to be denied on that offense. You're charged with another count or charge of identity fraud, bond is going to be denied on that. Those are felony offenses. You're going to have a preliminary hearing date set for May 11th and a bond hearing date set for May 13th on those 3 charges. Now, you're charged with giving a false name, address, or date of birth. Bond is going to be set at $2,000. Obstructing an officer, bond is going to be set at $2,000. And misdemeanor possession of marijuana, bond is going to be set at $1,500. So for these misdemeanors, you're going to have a total bond set at $5,500. The preliminary hearing date for the misdemeanors is going to be set for May 10th at 8:30 in the morning.
Okay. I have one question. Why was the bond denied for the felony charges?
Because of your criminal history. You have all kind of fraud and theft by deception and all of that. And there are 3 different victims that I saw in here. So I believe that warrants bond being denied until there can be a preliminary hearing on this.
Okay. All right.
Would you like for me to see if
yes, sir.
you qualify? Okay. You do qualify for the appointment of a lawyer. I'm going to appoint a lawyer to represent you. Do you have any other questions for me?
No, sir.
Okay, you're free to go back. Mr. Perriman, I saw the notice about the juvenile. I'll try to get through these last few adults before we go to the juvenile.
Before you go on to the next person, let me ask you a question real quick.
Yes.
The warrant ended in 2930 and 31 are all no bond felonies, right?
Yes, no bond denied.
Okay.
All right, let's see. Mr. Perryman.
Good afternoon, Your Honor.
Good afternoon, sir. You're charged with 2 Drug-related offenses. Let's see. All right, possession of a Schedule I controlled substance and possession of marijuana more than an ounce. Bond is going to be set at $5,000 for each of these felony offenses.
Yes, sir.
You're going to have a preliminary hearing date set for May 11th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
No, sir.
Okay, I was going to say you make a little bit too much money. Do you have any questions for me?
Have a good day.
You too. You're free to go back. Mr. Pritchett.
How you doing, sir?
I'm doing well. Mr. Pritchett, sir, you're charged with 1 count of possession of firearm during the commission of a crime. Bond is going to be set at $5,000. That's a felony offense. You're also charged with 1 count of violation of Georgia Controlled Substance Act, simple possession of a Schedule II drug. Bond is going to be set at $3,000. You have a 2nd count of simple possession of a Schedule IV drug. Bond is going to be set at $3,000. Charged with possession of less than an ounce of marijuana. Bond is going to be set at $1,500. And you're charged with having a dangerous drug or pills outside a container. That's a misdemeanor offense. Bond is set at $2,000. So you're going to have a total bond set at $14,500. Your preliminary hearing date is going to be set for May 11th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like me to see if you qualify for the appointment of a lawyer?
Yes, sir, I will.
Okay, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir, I do not.
Okay, you're free to go back.
All right, thank you, sir.
Okay, Mr. Redmond.
Yes, sir.
Okay, Mr. Redmond, sir, you have 2 sets of warrants, all involving the same victim. So you're charged in warrant number 2021 CW 55192 with committing terroristic threats or acts, which is a felony offense. I'm going to deny bond on that. And warrant ending 9-3, also terroristic threats. It's a felony. I'm going to deny bond on that. You're charged with simple battery and warrant number ending in 9-4. I'm setting $4,000 bond. That's a misdemeanor offense. And the warrant ending in 9-5, you're also charged with simple battery. That's a misdemeanor offense, and that's a $4,000 bond. Now, the second set of warrants that were just recently taken out, and warrant number 2022 CW 51730, you're charged with kidnapping. That's a felony offense. Bond is going to be denied on that. You're charged with theft by taking, which is a misdemeanor offense. Bond is going to be set at $2,000. And you're charged with family violence battery, which is a misdemeanor offense. Bond is going to be set at $5,000. There's going to be a stay away provision on this bond to stay away from a Diasia or Diasia Newsom. Do you understand that?
Deja Newsom?
Yes.
Sir.
Your preliminary hearing date is going to be set for May 11th at 8:30 in the morning, courtroom 201.
You said what date?
May 11th
Okay.
at 8:30 in the morning, courtroom 201. Now, because kidnapping carries a possible life term, that bond hearing is going to have to be heard before a superior court judge. So you'll get a notice as to that bond hearing date for those last 3 warrants. Would you like me to see if you qualify for the appointment of a lawyer?
Yes.
Okay. You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, you're free to go back. Mr. Sands is going to be done at the end. Mr. Stapleton. I'm doing well. Mr. Stapleton, sir, you're charged with 1 count of disorderly conduct. This is a misdemeanor offense. Bond is going to be set at $1,500. Your preliminary hearing date is going to be set for May 10th at 8:30 in the morning, courtroom 201. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, it says you refuse to fill out the form. Are you currently working?
Not the moment.
Okay, I'm going to find that you qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Yeah, if I get out like OR like from the sign out, do I still go to court on like May 10th?
If you get out of custody, that hearing date is automatically waived, no matter how you get out of custody.
All right. All right, thank you.
Okay, you're welcome. Mr. Alton Stevens.
Yes, sir.
Sir, you're charged with 1 count of failing to register. I'm going to deny your bond at this point. You're going to have a preliminary hearing date set for May 9th at 8:30 in the morning, courtroom 201. I'm going to set, hold on, sir. I'll let you speak. I'm going to set a preliminary hearing date for May 13th. I'm sorry, preliminary hearing date for May 11th, 8:30 in the morning. Bond hearing date for May 13th at 8:30 in the morning. Both going to be in courtroom 201 or by Zoom. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir, I would.
I'm going to appoint a lawyer to represent you. Now, what was your question?
On the failure to register, I was incarcerated at the time. I was in Jackson County Jail. I've been locked up now for 2.5 months. So my birthday was on February the 9th. That was the day I was supposed to register. I was locked up on that day.
Okay. All right. Did you notify anyone?
I didn't even know that this warrant existed until yesterday. They picked me up at Barrow County Jail and transferred me here. And that's when I found out about it. But
okay. But you do understand that you have a duty to register?
Yes, sir, I do.
Okay. So I've appointed a lawyer to represent you. And I don't know if this is going to be a situation where they treat it as impossibility as sort of a defense, or that you are in a place where theoretically, if you were there, you're supposed to register.
No, actually, I've been in this situation before. And if you're incarcerated, you can't register. There's no way. You have to go to the sheriff's department to register. But I'm incarcerated.
Okay. So, Mr. Stevens, you had a very extensive criminal history.
Yes, I have.
And I have set bond on this offense. Because of your extensive criminal history, that's something that I did take into consideration.
I've straightened out a lot of things.
Well,
my license, the kind of charges that I used to catch, I haven't caught those charges. Basically, the only thing I've caught in recent time is the driving offenses. I had a couple of drug cases that I stayed out on bond for like 2 or 3 years. I haven't been in trouble, serious trouble in a while.
So I hear what you're saying. I've appointed a lawyer to represent you. I'm going to let your lawyer deal with that. Okay.
Even though it can be straightened out with a phone call.
Who's going to call?
I can have my family text that I was incarcerated at the time that I was supposed to register.
Who are they going to text that to?
I don't know. I'm incarcerated. I'm looking for help from the judge.
I just appointed your help, which is a lawyer. That's the person you're supposed to be talking to about this, not me.
But based on the fact that I told you that I was incarcerated, and it does make sense, can I at least get a bond and try?
No, sir. No, sir. Listen, lawyers advocate, judges rule. Okay? Does that make sense to you? I'm not your advocate.
Can I say something, Judge? One more thing.
Go ahead.
Quick. I was locked up in Jackson County for a probation violation. I was locked, okay. A few days later, I was supposed to register. So that put me here. I had a court date in Barrow County, a court date that's been pending for like 2 or 3 years. I missed my court date. So because I hadn't committed one crime, I went to Jackson County on a probation violation. I was sent to Barrow County because I missed my court date, and I was sent here because I failed to register. So this is the 3rd county jail I'm in, and I haven't even committed a crime.
Can I make an observation, Mr. Stevens?
Yes, sir.
It sounds like you need to keep yourself out of jail and you won't have these problems.
Yes, sir.
Thank you. You're free to go back.
Thank you.
Mr. Talent.
Hello, Your Honor.
Hello, Mr. Talent, sir. You're charged with 3 driving related offenses, speeding. Looks like they have you as a super speeder. Bond is set at $1,500. Driving a vehicle on a suspended registration, bond is set at $500. And it says no insurance. Bond is set at $1,000. So that's a total bond of $3,000. These are all misdemeanor offenses. So you're going to have a preliminary hearing date set for May 10th at 8:30 in the morning, courtroom 201. The date will get waived upon your bonding out, and you'll get a new court date in the mail. Looks like you intend to hire your own attorney.
Yes, sir.
Okay. Do you have any questions for me, Mr. Talent?
No, sir.
Okay, you're free to go back. Mr. Wallace.
How you doing, Your Honor?
I'm doing well. Mr. Wallace, you have 3 warrants, but only 2 were reflected on the bond order. So I wrote in the last charge, the battery charge, which is warrant number 2021 CW 52145. It didn't make it onto the bond order, but I do have the warrants for that. You're charged with battery in that count. That's a misdemeanor offense. Bond is going to be set at $5,000. You're charged with criminal damage to property in the 2nd degree. That's a felony offense. Bond is going to be set at $5,000. And you're also charged with robbery, which is a felony offense. Bond is going to be set at $5,000. So you're going to have a total bond set at $15,000. There's going to be a stay away provision on this bond, a stay away from Elisa Riley. Do you understand that, sir?
Yes, sir.
Your preliminary hearing date is going to be set for May 11th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
I got a question. If I agree with that, is there anyone I can still hire me a lawyer?
Yes. You would just have to. You would just have to notify the appointed lawyer that you have retained a lawyer, so that appointed lawyer can withdraw.
All right.
I'm going to find that you qualify. I'm going to appoint a lawyer to represent you. Do you have any more questions for me, Mr. Wallace?
And altogether, it's 15,000?
Yes, sir. Mr. Woodford, you're free to go back.
Good morning, Your Honor.
Good morning, Mr. Woodford. Sir, you're charged with 1 count of simple battery. That's a misdemeanor offense. Bond is going to be set at $4,000. There's going to be a stay away provision on this bond, to stay away from a Victoria Thompson. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for May 10th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, you're free to go back. Were we able to bring up Mr. Sanders?
Yes, Your Honor, he's coming up right now.
Okay.
Your Honor, good afternoon, Your Honor.
Good afternoon. Mr. Sanders, sir, you're charged with 1 count of battery, family violence. It's showing that you're on probation or parole, so I cannot set bond for this offense at this hearing. Hold on, sir. Your preliminary hearing date is going to be set for May 10th at 8:30 in the morning. There's going to have to be a bond hearing set for the misdemeanor, which normally will be done on Tuesdays. Do you want me to see if you qualify for the appointment of lawyer?
No, I have a question, sir.
Hold on. Answer my questions and I'll answer yours.
I already have a lawyer.
Okay. Now, what's your question?
I got in trouble before I got on probation, and I was unaware of the warrant or court date. Like, this happened before I even got on probation. Like, the charge that you're saying happened before I even got on probation.
So if at the time you appear for first appearance, you're on probation, 1710-1 applies.
Right.
It applies at the time. So I can't go back and say, well, you were on probation 10 years ago. So I'm gonna deny bond right now. I can't do that.
No, I'm saying I wasn't on probation when I got the battery charge.
You're on probation now.
But I wasn't when I got it. So it's like I'm being held for something that I wasn't on at the time.
Okay. Hold on, Mr. Sanders. Mr. Sanders. I'm gonna say this one more time. It does not matter that you were not on probation at the time that you committed the crime. You're on probation at the time that you're being submitted for bond.
So if I contact my probation officer, could I get a bond?
Yes. If your probation officer doesn't mind and the solicitor says, hey, it's fine with me.
So I can call her and have her come up here so I can get a bond?
I would call my lawyer first. Isn't that why you paid a lawyer?
I mean, but he's waiting for Sife. She's in Atlanta.
Sir, you can do whatever you want to do.
Which way would be the best way?
I can't advise you that. You got a lawyer, talk to your lawyer.
But if I talk to my probation officer and she gives me a bond and...
Your probation officer cannot give you a bond. The Solicitor General can consent to a bond after speaking to your lawyer.
Who is the solicitor?
It's the Solicitor General of Clayton County.
Who is that?
The Solicitor General of Clayton County.
He don't got a name?
He has a name.
Where do I call him? So I know who to ask for.
The Solicitor General of Clayton County. He's not gonna pick up the phone.
I get it. I get it.
Anything else, sir?
How do I, like, what do I do? Like, do I go to court Tuesday?
How about you call your lawyer? You are represented by a lawyer. Talk to your lawyer.
I'm just confused.
Talk to your lawyer. That's why you hired your lawyer. If you're confused and you have paid a lawyer, you are getting fleeced. You are wasting your money. You might as well set that money on fire.
All right.
Okay, free to go back. Let's do Mr. Sands next because we have to turn everything off for the juvenile.
We have to be on standby for that. Deputy Bush is getting him right now, and he'll be signing in on a different computer.
Okay, do you know about how long it's gonna take? Because I was told that they're ready with the juvenile. So I can turn everything off. I guess because I knew you guys had to go. I'm sorry, Miss Mary.
No, I was gonna say, before you do the juvenile, I need to talk to you.
Okay. All right, I'm gonna turn this off. Give me a call, Miss Mary.
Okay.
Bond court is a free service, but it takes several hours of my time every day. Less than 10% of bond court viewers hit the like button, and less than 1% leave a comment. If you want Bond Court to continue to be available on YouTube for free, then please hit the like button and leave a comment on all of my videos.
Okay, good morning, everyone. My name is Brad Gardner. Good morning, everyone. This is your first appearance before the Magistrate Court of Clayton County. My name is Brad Gardner, and I'm a judge in this court. I'm here to inform you of the charges that have been filed against you, to advise you of certain rights, to set bail on those offenses that I'm authorized to set bail, to schedule a preliminary hearing, and to determine whether you require the assistance of an attorney. You have the right to remain silent and say nothing, but should you give up this right, anything you say during this proceeding may be used against you. So please don't discuss the facts of your case. During this and all other proceedings, you have the following rights: to the presumption of innocence, to indictment by a grand jury for most felonies or by accusation for misdemeanors, to a speedy and public trial by jury, to see, hear, and question witnesses who are called to testify against you, to compel the attendance of witnesses to testify on your behalf, to testify on your own behalf or offer evidence in your own defense, and to have an attorney represent you. If you cannot afford an attorney, one can be appointed to represent you if you qualify. Some of you will be allowed to post unrestricted bonds for your release from jail. These bonds may be posted by cash, commercial, or property. Some of you will have special conditions on your bond that prohibit you from contacting certain people or going to certain places. You will also be prohibited from contacting the victim while you are in jail. If you violate the court's order, your bond will be revoked and you could remain in jail until your trial. You could also receive additional felony charges. It is important to note that if someone is listed as a victim in your case, that person will not be allowed to post your bond. Some of you are charged with offenses for which this court is not authorized by law to set bail. In this event, a bond hearing will be scheduled before a judge of the Superior Court of Clayton County, and you will be informed of that date. That's difficult for me to say. If you are currently on active probation, this court is not authorized to set bond at this time. Where the bond is appropriate in your case will be reconsidered after your probation officer has had an opportunity to consider this new arrest. The purpose of a preliminary hearing is to determine whether there is sufficient evidence to support the allegations against you. The standard at this stage is very low. A judge determining whether a charge goes forward at this stage only has to determine that it is possible that the crime occurred. Everyone has the ability to waive their right to a preliminary hearing. However, you should speak to a lawyer first if you are unsure about whether it is appropriate to waive your preliminary hearing. If you post bond, your preliminary hearing is automatically waived. You will receive notice at the address you give of your next court date. Lastly, would everyone please raise your right hand for me, please? Do you swear or affirm any statements you make during this proceeding shall be the truth, the whole truth, so help you God?
I do.
Okay, thank you. Let's start on the ladies' side with Miss Brogdon.
Yes, sir. Yeah, step on up.
Good morning, ma'am. You're charged with one count of obstructing an officer, which is a misdemeanor offense. Bond is going to be set at $2,000. You're also charged with one count of failing to stop or yield at a stop sign. Bond is set at $500. And finally, you're charged with reckless driving. Bond is set at $1,500. So you're going to have a total bond of $4,000. Your preliminary hearing date is going to be set for May 10th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay. Give me 1 second. Okay, ma'am, you do qualify for the appointment of lawyer. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, ma'am, you're free to go back.
Thank you.
You're welcome. Miss Davis?
Morning, Your Honor.
Morning. Ms. Davis, you're charged with 1 count of aggravated assault with a deadly weapon and 1 count of aggravated battery. These are both felony offenses. I've set the bond at $15,000 for each offense for a total bond of $30,000. There's going to be a stay away provision on this bond, to stay away from a Shavanti Hiles. Do you understand that, ma'am?
Yes, sir. Yes, sir.
Your preliminary hearing date is going to be set for May 11th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you will receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, ma'am, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
One more question, sir. Did you
Yes,
say
ma'am.
how much the bond is?
The total bond is $30,000.
Mm-hmm.
Any other questions, ma'am?
No, sir. Thank you.
Okay, okay, ma'am. You're free to go back. Ms. Flynn?
How are you today?
I'm doing well. Ms. Flynn, you're charged with 1 count of simple battery. Bond is going to be set at $4,000. That's a misdemeanor offense. You're also charged with 1 count of criminal damage to property in the 2nd degree. Bond's going to be set at $5,000. That's a felony offense. You're going to have a, I'm sorry?
I'm nothing. So altogether, my bond is what?
9,000.
Okay, thank you, sir. I appreciate the bond.
Oh, okay. Okay, ma'am. There's going to be a stay away provision on the bond to stay away from a Cedric Usher. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for May 11th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir, you can.
You do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, yes, sir. If I could, I guess I'll ask them if I can use the phone to let somebody know that they can come bond me out now.
Yes.
Can I go through a bondsman, right?
I'm sorry, ma'am.
Can I go through a bondsman?
Yes, ma'am.
Okay, that's all. Thank you, sir.
Okay, you're free to go back.
Thank you.
Miss McGee?
Good morning, Your Honor.
Good morning, ma'am. You're charged with 1 count of driving under the influence of alcohol to the extent that you are a less safe driver. And actually it says drugs, but on the front sheet, it says alcohol. The bond's going to, this is a misdemeanor offense. Bond's going to be set at $5,000 for that offense. You're also charged with possession of marijuana less than an ounce. Bond is going to be set at $1,500. And you're finally charged with 1 count of an open container violation. Bond is going to be set at $500. So you're going to have a total bond set at $7,000. These are all misdemeanor offenses. So you're going to have a preliminary hearing date set for May 10th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. You refuse to fill out the form. Does that mean you're going to hire your own lawyer?
I guess I would like to get my own legal counsel.
Okay. Do you have any questions of me, ma'am?
No, sir. No, Your Honor.
Okay. Okay, ma'am, you're free to go back.
Thank you.
You're welcome. Miss Sadler. Miss Sadler, ma'am, you're charged with 1 count of criminal trespass. This is a misdemeanor offense. Bond is going to be set at $1,000. You're charged with actually 2 counts of simple battery on a police officer. Bond is going to be set at $5,000. Where does she go?
Oh, I was like writing it down.
Okay, I'm sorry. I'm sorry. I was looking down and I looked up and I didn't see you anymore. So you can continue writing down what you need to write down. You're charged with 2 counts of simple battery on a police officer. These are also misdemeanor offenses. Bond is going to be set at $5,000 each. And finally, you're charged with 1 count of felony obstruction of a police officer. Bond is going to be set at $5,000. So you're going to have a total bond set at $16,000. Because the final offense is a felony offense, you're going to have a preliminary hearing date set for May 11th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, you said my preliminary is May 11th.
Yes, ma'am.
What will happen during the preliminary?
So the preliminary hearing, another term for it is probable cause hearing. If you're still in custody at that time and you desire to have a hearing, you have a right to call witnesses and for the judge at that hearing to hear from both sides and for that judge to make an independent determination as to whether probable cause exists. But if you bond out, that hearing is automatically waived by operation of law, and the case gets transferred to the Superior Court of Clayton County, and it'll get assigned to a Superior Court judge, and then you will receive notices based upon that judge's calendar.
My bond is $16,000.
Yes, ma'am.
Oh, so I would have to pay $16,000.
Not the total amount. If you go through a bonding company, the bonding company charges you a fee, which is usually a percentage of the bond amount, and that's generally around 10 to 12% of the bond.
Oh.
And so just so you know, ma'am, I looked at your criminal history, and you have some similar incidents in your past, and then fighting with the police is never a good idea.
Oh, yeah,
Okay. Okay, ma'am. You're free to go back. Ms. Smith.
Yes, sir. Good morning.
Good morning, ma'am. You're charged with 1 count of pointing a pistol or gun at another. Bond is going to be set at $5,000 for this offense. This is a misdemeanor offense, but there's going to be a stay away provision on this bond to stay away from a Bostic Lester. Do you understand that?
Yes.
Your preliminary hearing date is going to be set for May 10th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay. You do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir, I don't.
Okay, ma'am. You are free to go back.
Thank you. Have a nice day.
You're welcome.
I have one more.
Okay. Okay, hold on one second. Mr. Is it Edie?
Yes, it'd be Edie.
Who are you representing here today, sir?
Samari Cora.
Okay.
I don't know. I don't know, because I got it wrong. You got it wrong.
Okay, we're going to get to Mr. Cora in a minute. Did you say Samari King?
It's Samir King, Your Honor.
Okay, they have Samir King listed as a male on the WAA.
I'm trans, but I just don't have my bottom.
Okay.
It's legal.
So, is it okay for me to refer to you as Miss King or Mr. King?
Mr. King, please.
Okay, Mr. King, sir, you're charged with 1 count of criminal trespass. This is a misdemeanor offense. Bond is set at $3,000. You're also charged with 1 count of family violence battery. Bond is set at $5,000. You're charged with 1 count of aggravated assault. Bond is going to be set at $10,000. And I dismiss the kidnapping charge.
They didn't tell me I had aggravated assault. They only said I had family violence and simple battery and criminal trespass and kidnapping. That's all they told me. Where did the aggravated assault come in at?
Okay, so the document that I'm looking at has 4 charges on it: criminal trespass, battery, aggravated assault, and kidnapping.
Okay. Criminal trespassing?
Yes, sir.
Trespassing.
And the criminal trespass is the allegation is that you kicked in a door, causing damage to a door frame that was worth approximately. Hold on, sir. Worth approximately $100. The battery charge is based upon the allegation that you punched this person, Danita Sotow, to the right side of her head, causing a large lump on the side of her eye and her ear to bleed. The aggravated assault charge is based upon the allegation that you pulled a knife on her. The kidnapping, it looks like they're saying that they, I guess, alleged the kidnapping is saying that you attempted to drag her out the door, but that's not kidnapping.
All we did was physically fight.
No, sir. Don't, sir. This is being recorded.
Oh, okay. I apologize.
Sir. At least have a chance to speak to your lawyer first before you start making statements about your case.
I apologize, sir.
No, I'm just saying. People say things all the time and get themselves in trouble. The lawyer comes in and the lawyer may have a great defense, but you've now on a recording made statements that works against your defense. So just wait and speak to your lawyer.
Yes, sir. I apologize.
Okay. No problem. So you're going to have a total bond of $18,000. There's going to be a stay away provision on this bond to stay away from a Danita Sotow. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for May 11th at 8:30 in the morning, courtroom 201. The date will get waived upon your bonding out, and you'll receive a new court date in the mail. Now, did you plan on hiring your own lawyer? Did you want me to appoint a lawyer to represent you?
Appoint one.
Are you currently working?
I work at All On Security, sir.
Approximately how much do you make per hour?
I make $15 an hour.
Okay, you do qualify for the appointment of lawyer. I'm going to appoint a lawyer to represent you. Now, is there any other questions you have that do not involve discussing the facts of your case?
No, sir.
Okay. All right, sir. You are free to go back.
Thank you.
Okay, we're gonna yes.
Before you move on, what was that defendant's name?
Last name was King, K-I-N-G. First name Samir, S-A-M-I-R.
Okay, so the warrants didn't print out. Can you give me the warrant numbers and the amount again?
Oh, yeah, I'm sorry. Because I had to do a whole different thing. So the criminal trespass printed out on the bond sheet.
Right, I got that one.
So 939 is battery, family violence.
Okay.
940 is aggravated assault.
Mm-hmm.
And 941 is kidnapping. and that's the one that I dismissed.
You dismiss. And what's the bond for 939?
5,000,
940?
10,000.
Okay. Thank you very much.
You're welcome. And I apologize. I meant, and the 2 times we spoke, I meant to tell you that, and it slipped my mind both times.
That's okay.
Okay, so Ms. Bermudez, are you ready to go? Or are you still in another courtroom?
Good morning, Judge. I'm ready to go.
Okay, let's bring up Mr. Morales. And he is a fugitive from justice. His warrant number is 2022 WA 06921.
Yes, sir. Thank you.
You're welcome. And after Mr. Morales, let's bring up Mr. Cora.
Yes, Your Honor.
Okay. Mr. Morales, sir, can you hear and understand the interpreter?
Señor Morales, ¿puede usted escuchar y entender a la intérprete? Yes.
Mr. Morales, you're here on what's called a fugitive from justice warrant.
Señor Morales, usted está acá en lo que se llama una orden de arresto por ser un fugitivo.
And what that simply means is that there's a warrant for your arrest out of another state, and in this instance, it's Colorado.
Lo que esto significa es que usted tiene una orden de arresto en otro estado y en este caso es el estado de Colorado.
And you're wanted on a failure to appear on an assault charge.
Y usted está siendo buscado por falta de comparecencia en un cargo de agresión corporal.
I'll start by saying that the Clayton County nor the state of Georgia has any interest in your guilt or innocence.
Voy a comenzar diciendo que ni el condado de Clayton ni el estado de Georgia tiene ningún interés en si usted es culpable o es inocente.
We're simply holding you because the state of Colorado has said that they intend to extradite you back to Colorado for this warrant.
Y nosotros solamente lo hemos estado reteniendo porque el estado de Colorado nos ha dicho que ellos lo están buscando con esta orden de arresto.
You have a right to challenge this process.
¿Usted tiene el derecho de desafiar este proceso?
If you want to challenge the process sometime between now and the next 90 days, there will be a hearing to determine whether you are the person named in the warrant and whether the warrant is valid.
Si usted quiere desafiar este proceso entre ahora y los próximos 90 días, va a haber una audiencia para determinar si usted es la persona nombrada en esta orden de arresto.
If at the end of that hearing, the judge determines that you are the person named in the warrant and that the warrant is valid, the judge will sign off on the state of Colorado coming to pick you up.
Si al final de esta audiencia el juez determina que usted es la persona nombrada en esta orden de arresto y que la orden de arresto es válida, entonces el juez firmaría la orden para usted ser enviado al estado de Colorado.
Correctamente.
And that will be perfect.
At that point, the state of Colorado will have 30 days as a minimum to come and pick you up.
Y en ese momento, el estado de Colorado tendría 30 días mínimos para venir a buscarlo.
They can request an additional 60 days, but that is not always guaranteed.
Ellos pueden pedir que le concedan 60 días adicionales, pero esto no siempre es garantizado.
Le voy a decir algo. A mí me dijeron que entre 10 días me iban a extraditar a Colorado.
Let me tell you something. They told me that within 10 days, I was going to be extradited to Colorado.
The statutory period is 30 days.
El tiempo por estatuto son 30 días.
I have not had any contact or communications with Colorado.
Yo no he tenido ningún tipo de contacto o comunicación con Colorado.
I do not know if Colorado has said that they're going to come and get you within 10 days or not.
Yo no sé si el estado de Colorado ha dicho que lo viene a buscar dentro de los próximos 10 días o no.
Tengo una pregunta, dígale que si puedo pagar el bond aquí en Atlanta, Georgia.
I have a question. Can I pay the bond here in Atlanta, Georgia?
No.
No.
Bien que se pueda pagar con dinero no se puede arreglar.
Even if I can pay, I cannot fix that with money.
So again, Clayton County in the state of Georgia has no interest in your case.
Una vez más, el condado de Clayton y el estado de Georgia no tienen ningún tipo de interés en su caso.
I do not know whether Colorado will accept payment or not.
Y yo no sé si Colorado va a aceptar pago o no.
If there is a payment to be made, it will have to be made in Colorado.
Si hay que hacer un pago, entonces este pago tendría que ser hecho en Colorado.
Yo entiendo.
If you were to make that payment and Colorado contacts us to release you, you will be released.
Si usted hiciera este pago y el estado de Colorado se pone en contacto con nosotros y nos dice que lo pongan en libertad, entonces nosotros lo pondríamos en libertad.
Ok, está bien.
Okay, that's fine.
So for today's purposes, do you want to, I'm sorry, strike that. If you believe you are the person named in the warrant and you believe the warrant is valid, you can sign a waiver today.
Okay. Para el propósito del día de hoy, si usted cree que la persona nombrada en la orden de arresto y que la orden de arresto es válida, usted podría firmar el renunciamiento al proceso de extradición en el día de hoy.
If you were to sign the waiver, that 30-day period begins to run today.
Si usted firma el formulario de renunciamiento, los 30 días, el periodo de 30 días comenzarían en el día de hoy.
Ok, dígale que lo leo, firmar.
Okay, then I will sign it.
Okay, you will sign the waiver forms. They will send them to me. I will sign them and the clock will begin to run today.
Okay, entonces usted firmaría el documento de renuncia. Ellos me lo enviarían a mí. Yo lo firmaría y el reloj comenzaría a rodar en el día de hoy.
I encourage you to hire a lawyer in Colorado as soon as possible to address these charges.
Y yo lo exhorto a que usted se contrate un abogado en el estado de Colorado para lidiar con estos cargos.
Ok, está bien.
Okay, that's fine.
Okay, so once he signs the waiver, he will be free to go back.
Tan pronto él firme el documento de renuncia, se puede retirar.
Okay.
Okay.
Thank you, Ms. Bermudez. Have a good day.
You are welcome, Judge. You have a great weekend.
Okay. Let's bring up Mr. Core.
Judge, yes, sure, I see that what his charges are. This would be what a bounder just wanted to let him know, so that way when I do speak to him, I can understand what he has going. Correct?
I'm sorry, say that one more time.
I said I wanted to know, well, based on this, the charges, will it just be an automatic bound over to Superior so I can let him know that, or will we actually be entertaining the bond hearing today?
No, I can't set bond on this charge at first appearance.
I want to be. That's all.
And the reason I was confused is because it's only a bound over if you want to bind it over. You'll have to sign a waiver for it to be bound over.
And I got you.
But he is entitled to a preliminary hearing if that's what he wants.
I don't want to waive nothing. I would just get it over to the preliminary hearing.
Okay. Mr. Cora, you have taken advantage of the opportunity to hire a lawyer. So I'm going to speak about your case with your lawyer. You need to understand that there's nothing that's said here that's privileged or private. So don't say anything you wouldn't want the whole world to know. Do you understand that, sir?
Yes, sir.
Okay, so I assume and it's Edie or Eddie, I'm sorry.
Edie.
Edie. Mr. Edie, I'm going to assume that you've spoken to your client about these charges.
I've spoken with the family. I was just retained right when I received the link.
Okay. So, and the reason I ask is that for some serious charges, I don't need to discuss it if I don't have to.
Yes.
So with these two charges, I cannot set bond on the first charge. So it's going to be denied pursuant to statute 1761. And the second charge, possession of a weapon during the commission of a crime, I'm going to deny bond on that. He is entitled to a bond hearing and preliminary hearing. The preliminary hearing date is going to be set for May 11th at 8:30 in the morning, courtroom 201. The bond hearing date is going to have to be determined because it's going to have to be before one of the elected Superior Court judges. And I don't know which one is going to be presiding at the time.
You said May 11th?
At 8:30 in the morning, and it's most likely it's going to be by Zoom.
Yes.
Make sure
I'm
you
sorry.
file.
Can you give me his name and warrant numbers? It didn't print on my calendar.
Okay, I'm sorry. It's Cora, K-O-R-A.
Okay. So bond denied?
On 5-0, bond is denied pursuant to 1761. And on 5-1, bond is denied. Just no bond denied.
I got it. Thank you.
You're welcome. So, Mr. Edie, do you have any questions of me?
No, I understand everything very clearly. And I'll be getting that information over to my client at the jail as soon as possible.
Okay. Mr. Cora, stay in contact with your lawyer. You're free to go back, sir.
And this
Attorney Edie, can you make sure you submit an entry of appearance so you can get all the notices?
Yes.
And that is very important because it will normally, if there's an entry that hasn't been filed, it will automatically print the public defender's name. And so
what would be the email? Do you just need me to mail it? Or, I mean, the normal way is mail it, but if you need one officially, I can send over one in the email as well.
Send it to me. I'm going to put my email in the chat for you.
No problem.
Judge Garner,
yes.
Before I log off, I have one more name and I just want to make sure that I'm not needed.
Okay.
I have Mr. Garcia, Alvin Garcia.
Does Mr. Garcia need the services of an interpreter?
No.
He says no.
Yes, sir. Thank you.
Okay, have a good weekend. Okay, are you Mr. Brantley?
Yes, yes, sir.
Okay, Mr. Brantley, sir, you are charged with a number of serious felony offenses. You're charged first with committing the offense of burglary, and bond is going to be denied on that charge. You have 6 counts of violation of Georgia Controlled Substance Act and possession of controlled substance. Bond is going to be denied on those offenses. You're charged with 1 count of use or possession of drug-related objects. Bond is going to be set at $1,500. You're also charged with 1 count of possession of or transaction card fraud. Bond is going to be denied on that offense also. You have a preliminary hearing date set for May 11th at 8:30 in the morning, courtroom 201. You have a bond hearing date set for May 13th at 8:30 in the morning, courtroom 201. Would you like me to see if you qualify for the appointment of a lawyer?
Yes.
Are you currently working, sir?
No, sir.
You do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, you're free to go back. Mr. Brown. Mr. Brown, sir, you're charged with one count of obstructing or hindering an emergency vehicle. Bond is going to be set at $3,500 for that. You're also charged with one count of disorderly conduct. Bond is going to be set at $1,500 for a total bond of $5,000. You're going to have a preliminary hearing date set for May 10th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
No, sir.
Okay. You're going to hire your own lawyer?
More likely, sir.
Okay. Do you have any questions of me?
No, sir.
Okay. You're free to go back, Mr. Brown.
Thanks, sir.
You're welcome. Mr. Carter, Terrence Carter. Terrence Scott Carter, sorry.
Morning, Your Honor.
Good morning. You're Terrence Scott Carter?
Yes, Your Honor.
Okay, you're charged with one count of family violence battery. Bond is going to be set at $5,000. This is a misdemeanor offense. There's a stay away provision on this bond to stay away from a Sharon Carter. Do you understand that?
Yes, Your Honor.
Your preliminary hearing date is going to be set for May 10th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, Your Honor.
Are you currently working?
Yes, Your Honor.
How much do you make per hour?
$8.50, Your Honor.
Okay, you do qualify for the appointment of a lawyer. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, Your Honor.
Okay, you're free to go back.
Thank you.
Mr. Terrence Martell Carter.
The same exact name. Good morning.
Good morning, Mr. Terrence Martell Carter. Sir, you're charged with one count of aggravated assault with a deadly weapon. Bond is going to be set at $20,000. You're charged with one count of battery. Bond is going to be set at $5,000. And you're charged with one count of criminal trespass. Bond is going to be set at $3,000. So that's a total bond of $28,000. There's going to be a stay away provision on this bond to stay away from an Ernest Robinson. Do you understand that?
I do.
Your preliminary hearing date is going to be set for May 11th at 8:30 in the morning, courtroom 201. That date will get waived upon your ability to bond out. You didn't fill out, hold on, you didn't fill out the form. Does that mean you're going to hire your own lawyer?
Man, you can, I'm pretty much gonna have my own attorney, but you could sign me up for that though.
Okay. Let's walk back. Let's walk back through this. Do you want me to appoint you a lawyer? Yes or no?
I'm good. I just gotta get out and get a lawyer. I'm all right.
Okay. So, Mr. Carter, I'm gonna tell you, I've been a lawyer for 20 some years, and you get trained, and when you ask a question, you want an answer. And so when it's a yes, no answer, I'm good is not an answer.
No.
So yes or no?
No.
Okay. Do you understand the stay away provision?
Yes.
Do you have any questions of me?
No. Oh yeah, it was my bills a total, what, 28?
$28,000, yes, sir.
Thank you.
Okay, you're free to go back.
Okay.
Mr. Christian. Mr. Christian, sir, you're charged with looks like several misdemeanor offenses. The first is possession of less than an ounce of marijuana. Bond is going to be set at $1,500. The second charge is driving a vehicle without a license. Bond is set at $1,000. The third charge is driving a vehicle with defective headlights. Bond is set at $500. The fourth count is or charge is violation of seatbelt law. Bond is set at $500. Fifth count is driving on the wrong side of the road. Bond is also set at $500. Failing to dim headlights, bond is set at $500, and failing to obey officer, bond is set at $500. So let's see. Total bond of $5,000. Because these are all misdemeanors, your preliminary hearing date is set for May 10th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, you do qualify, Mr. Christian. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, you're free to go back. Mr. Coleman. Mr. Coleman, sir, you're charged with also a mix of driving and felony offenses. So driving a vehicle with no insurance, bond is set at $1,000. Driving on a suspended license, bond is set at $1,500. Says driving on a suspended registration, bond is set at $500. Obstructing an officer, bond is set at $2,000. You have 2 drug-related offenses ending in 9-2 and 9-3. Bond is going to be set at $10,000 for each offense. You're charged with 1 count of use or possession of drug-related objects. Bond is going to be set at $1,500. And finally, you have another drug offense ending in warrant number 9-5. Bond is going to be set at $10,000. So your total bond is going to be, let's see, $36,500. Because of the felony offenses, bond, your preliminary hearing date is going to be set for May 11th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. It looks like you intend to hire your own lawyer.
Yes.
Do you have any questions for me, Mr. Coleman?
No, sir.
Okay, you're free to go back. Mr. Coulter.
I'm
doing well. Mr. Coulter, sir, you're charged with 1 count of driving a vehicle on an expired registration. This is a misdemeanor offense. Bond is set at $500. 1 count of driving a vehicle without a license. Bond is set at $1,000. 1 count of possession of marijuana less than an ounce. This is a misdemeanor. Bond is set at $1,500. And use or possession of drug-related objects, bond is also set at $1,500. So you're going to have a total bond of $4,500. Your preliminary hearing date is going to be set for May 10th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, yes.
How much do you make per hour?
I think 11 right now.
Okay. You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Yeah, so listen, right, I take care of my mom, right? So would I be able to get like OR or something like that so I can get back home, OR?
No, sir.
All right, thank you. I appreciate you, sir.
Okay, you're free to go back. Mr. Brian Davis.
Morning.
Good morning, sir. You're charged with 1 count of following too closely. It's a misdemeanor, bond set at $500. 1 count of improper turn or improper signal. Bond is set at $500. That's also a misdemeanor. Driving under the influence of alcohol. This bond has been automatically set at $2,000, and reckless driving bond is set at $1,500. So your total bond is going to be set at $4,500. You're going to have a preliminary hearing date set for May 10th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify? Well, it says refuse. So you plan on hiring your own lawyer?
Correct.
I'm sorry?
That's correct.
Okay. Do you have any questions for me, Mr. Davis?
No.
Okay, sir, you're free to go back. Mr. Garcia?
Yes.
Sir, you're charged with 1 count of criminal trespass. I have dismissed that charge. You're charged with 1 count of family violence battery. Bond is going to be set at $5,000 for that charge. There's going to be a stay away provision on this bond to stay away from a Roseanne Peterson. Do you understand that, sir?
Yes, sir.
Your preliminary hearing date is going to be set for May 10th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. You also refuse to fill out the form. Does that mean you're going to hire your own lawyer?
Yes.
Okay. Do you have any questions for me, Mr. Garcia?
No, sir.
Okay, you're free to go back. Mr. Hillman?
Yes, sir.
Mr. Hillman, you're charged with 1 count of battery. This is a misdemeanor offense. Bond is going to be set at $5,000. 1 count of aggravated assault by strangulation. Bond is going to be set at $10,000. 1 count of cruelty to children in the 3rd degree. Bond is going to be set at $3,000. So you have a total bond of $18,000. There's going to be a stay away provision on this bond to stay away from an Alexis Clintoria Hillman. Do you understand that?
Yes, can I ask you a question?
At the end. Your preliminary hearing date is going to be set for May 11th at 8:30 in the morning, courtroom 201, because the aggravated assault by strangulation is a felony offense. Do you want me to see if you qualify for the appointment of a lawyer?
Yes.
If you do qualify, sir, I'm going to appoint a lawyer to represent you. Now, I cut you off. What was going to be your question?
You said I got to stay away.
I'm sorry.
You said I have a stay away?
Yes, you have to stay away from Miss Hillman.
All right.
Do you understand that?
Yes, sir.
Okay. Do you have any other questions?
No, sir.
Okay, you're free to go back. Mr. Jackson?
Jackson not here. Jackson not here. You're not here. Jackson not here.
Kevin Jackson?
Not here. You're not here, man. Sir.
He's on the he's
walked
on the
out.
I'm sorry.
He walked out.
Can someone come on the camera, please?
No, you need.
Sir, Your Honor, Jackson just walked out.
Mr. Jackson just walked out.
Yes, sir. I guess he refused to.
We'll go to Mr. Jules next, Your Honor.
Okay. Okay. He's going to have to appear because there's a stay away provision on his bond, so he's going to have to be told that directly. If he wants to sit in jail, he can sit in jail, I guess.
Yeah, you also. He also said move on to the next person right here.
Mr. Jules.
Jackson. Jackson. There you go. Jackson. Jackson right here. Move on. Take a seat.
Tell me your name, sir.
Mr. Jules, Bradley Jules.
Okay, Mr. Jules, sir, you're charged with 1 count of aggravated assault. That's a felony offense. Bond is going to be denied pursuant to 1761. You're charged with possession of a firearm during the commission of a crime. Bond is going to be denied on that charge. You're charged with possession of a firearm by a convicted felon. Bond is going to be denied on that charge. There's going to be a stay away provision on this bond to stay away from a Donovan Houseworth. Do you understand that?
Understand.
Okay. Your preliminary hearing date is going to be set for May 11th at 8:30 in the morning, courtroom 201.
So
You're going to have a bond hearing date set for May 13th at 8:30 in the morning, courtroom 201. You refuse to fill out the form. Does that mean you're going to hire your own lawyer?
yes, sir.
Do you have any questions of me?
No, sir.
Okay, you're free to go back.
Say May 13, bond hearing.
Yes, sir.
Thank you.
You're welcome.
Your Honor, Mr. Jackson's coming up.
This is Mr. Jackson.
Yes, Your Honor.
Mr. Jackson, sir, you're charged with 1 count of criminal trespass, damage to property. This is a misdemeanor offense. Bond is going to be set at $3,000. There's going to be a stay away provision on this bond to stay away from Lakedria Jackson. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for May 10th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, you're free to go back. Let's see. We did Mr. Core. Mr. McClendon.
Let's see.
Yes, sir.
Sir, you're charged with 3 counts of violation of Georgia Controlled Substance Act. The first count ending in 8-0, bond is going to be set at $10,000. The second charge ending in warrant number 8-1, bond is going to be set at $5,000. And finally, the third charge with bond ending in 8-2, bond is going to be set at $5,000. So you're going to have a total bond of $20,000. There's going to be a preliminary hearing date set for May 11th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
No, sir. I'm on.
Okay. Do you have any questions of me?
Can you tell my court date again?
May 11th, 8:30 in the morning, courtroom 201, but it most likely will be by Zoom. That date will get waived upon your bonding out, and your case will get transferred to Superior Court, and you will receive a notice in the mail. You're welcome. Let's see, Mr. McLemore. Good morning, Mr. McLemore. Sir, you're charged with 1 count of battery. Bond is going to be set at $5,000. You're also, that's a misdemeanor offense. You're also charged with 1 count of criminal trespass, also a misdemeanor. Bond is going to be set at $3,000. There's going to be a stay away provision on this bond, to stay away from a Brittany map. Do you understand that? I need to hear you, sir.
Yes, sir.
Your preliminary hearing date is going to be set for May 10th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like me to see if you qualify for the appointment of a lawyer?
Yeah.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, you're free to go back.
Oh, yes, I do. I got one question.
Yes, sir.
I'm on VOP too, right?
I see that there's an indication that you do have warrants for your arrest. So if you don't clear those up, once you bond out, you'll be sent to whatever jurisdiction has the warrants.
All right.
Okay, sir, you're free to go back. Mr. Is it Mong?
It's Mohe, Your Honor.
Monghe, sir, you're charged with 1 count of aggravated assault. Bond is going to be denied at this stage. There's going to be a stay away provision on this bond to stay away from a Tyrone Morris. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for May 11th at 8:30 in the morning, courtroom 201. You're going to also have a bond hearing date set for May 13th at 8:30 in the morning, courtroom 201. Do you want me to see if you qualify for the appointment of a lawyer?
Oh, yes, sir.
You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, you're free to go back. Mr. Reese.
How you doing, Your Honor? Good
I'm
morning.
doing well. Mr. Reese, sir, you're charged with 1 count of battery.
Yes, sir.
Bond is going to be set at $5,000.
Why is the bond so high, sir?
I've said every bond at $5,000.
Oh, okay.
I believe that adults have the ability to control where they place their hands.
I mean, I believe.
I don't talk about the facts of your case because this is being recorded.
I'm saying I'm innocent until proven guilty, so I know.
Yes.
So you're believing that adults should have a place to their hands. I agree too.
So the bond is placed upon whether the person did it or didn't do it, right? Because if I believed you did it, I'd be sentencing you right now. I wouldn't be giving you a bond to get out. I wouldn't be giving you a lawyer to defend you.
I'm grateful, Your Honor. Thank you so much.
Okay. So there's going to be a stay away provision on this bond to stay away from a Najla Kimball. Do you understand that?
Sir, yes, sir.
Your preliminary hearing date is going to be set for May 10th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you'll receive a new court date.
Sir, pardon me.
May 10th, 8:30 in the morning, courtroom 201.
Okay. Do I have any warrants, anything? Because then you know if I bond out, man, no warrants.
Were you told that you had warrants?
No, sir, I shouldn't have no warrants or no holes and nothing.
So why are you asking me that?
Because I was asking, sir. Because I mean, in another county, Atlanta.
Okay, Mr. Reese, the only reason you would ask me that is if you had a good faith belief that
I mean, because it just, I know I work and there'd be a lot of stuff going on, and this was the first time I had a warrant. See, they had to come pick me up because I didn't know I have a warrant for this one. So.
Okay, hold on. I may be able to tell you.
I know up front they told me I didn't have no holes. And so, no holes and warrants, 2 different things.
So this is the only warrant that I see.
Thank you. God bless.
So, Mr. Reese, I'm just conveying information. I appreciate you thanking me, but I literally did not do anything.
You did a lot, little do you know. Thank you. Thank you.
Okay. So, Mr. Reese, there is a stay away provision on this bond to stay away from a Najla Kimball. Do you understand that?
Sir, yes, sir.
Your preliminary hearing date is set for May 10th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Sir, yes, sir.
You do qualify, Mr. Reese. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir. Thank you for all your help.
Okay. You're welcome, sir. You're free to go back.
All right.
Mr. Rivers? Yes.
Never mind.
Mr. Rivers.
It sounds going on.
Mr. Rivers, sir, you're charged with 1 count of identity fraud. I've set bond at $20,000. This is a felony offense. You're going to have a preliminary hearing date set for May 11th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir, you can.
Okay, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
Yes, sir. Like, could you read like the grounds on charging me with this charge?
Okay, I will. Give me 1 second. Okay, it says that on May 1st, 2021 at 9151 Tower Boulevard Road, that's the jail, you committed the offense of identity fraud when using or possessing identifying information concerning a person against the state of Georgia, and that said defendant did knowingly, willfully, and lawfully, without authority or permission of the victim, Donta McCallan, use or possess a driver's license with intent to fraudulently use identifying information concerning said victim. Said accused did get arrested using the victim's information during their arrest, case number 21031813. So that's the basis. It says you got arrested and you used this name of Donta McAllen and got booked in under Donta McAllen, knowing that you were not Donta McAllen.
I don't recall telling anyone that information, so I was wondering, is there any way that you can lower my bond a little bit so I can at least make bond and try and handle this situation, please, sir?
Well, based upon this, I normally would not set the bond this high, but based upon the allegation contained in here, if this is true, you've now messed up this person's credit, their life. They could have, stop it. They could get stopped if there's a warrant in that person's name, and you're the person that's doing it.
Yes,
so
yes, sir.
I take that very seriously.
Yes, Your Honor, you should, you really should, but at the same time, I already have an ankle monitor on, Your Honor.
Well,
like, is it anything you can do just to help me to resolve this situation?
The one thing I can say is that if you get arrested again, use your name. Don't bring somebody else into.
I didn't use anyone's name.
Your mess. Okay, well, that's the allegation against you, and that's why I set the bond the way that I set it.
But Your Honor, I'm just asking, can you have a little any kind of leniency towards that, please?
No.
I don't want to sit in here for 30, 90 days waiting for a bond reduction.
Think about Mr. McAllen.
But Your Honor, it sounds like you're kind of biased because you already said that I'm guilty without even.
No. I set you a bond. Again, if I thought you were guilty, I'd be sentencing you right now. The bond is set on the alleged conduct. So I'll give you an example. People come here all the time from the West Coast with 20 pounds, 30 pounds of marijuana, and it's the first time that they got arrested. Statute says I can't set bond on anything over 10 pounds. And they sit there and beg, and I got a daughter, I take care of my sick mother, and can you do something? No, I can't, because the law says I can't do that. And in this particular instance, see, you are innocent until presumed guilty. The bond amount is based upon my calculation of what I think it is necessary for you to show back up in court at this stage.
Yes, sir.
And the fact that the allegation is that you use somebody else's identification upon being arrested, that causes me concern, which means I want to hear in a hearing everything so that I've appointed you a lawyer. Your lawyer can question the officer. Your lawyer can get the documentation. Your lawyer can show, as what you're saying, that, hey, I didn't do that, but I guarantee before this warrant was issued, they got the information, and that name sounds familiar to me. So you may have appeared before me under this name. So I'm not going to reduce this, Mr. Rivers.
But yeah, Your Honor, I'm asking you to just take into consideration when those charges was brought up upon me. You said May 1st. I was already incarcerated.
It was June 1st.
June 1st. Okay, well, I was already incarcerated. I think I did 10 months here last time I was here. And when I got out, one of the stipulations was that I had to get an ankle monitor. So I'm kind of out of money right now. I did everything I possibly can to get this situation how can I say it, straightened out the last time I was here, but nobody wanted to hear what I had to say, and I just had to find out.
Mr. Rivers, you have 14 cycles. Do you know what that means?
No, sir.
That means that you have interacted with the police 14 times. When you're here on June 1st, you're charged with hit and run and resulting serious injury or death, theft by receiving stolen property. And so the hit and run is that there's an accident and you left the scene.
Yes, sir. And all of those charges is why I have an ankle monitor. So you won't have to worry about me not coming to court. I'm just you can see how much I paid already. I'm just kind of strapped for cash, and I still have a family to take care of and everything. So I'm just asking you to I don't mind paying the bond because I do need, I want to take it to trial and court and go through the processes and everything, but I'm just like out of cash right now, sir.
So, Mr. Rivers, we can continue having this conversation, but I've told you I'm not going to reduce this bond.
Lee, can you say 5,000, 10,000, sir? Like you're looking at my case right now. You see how much I paid. You see, I got this ankle monitor on already. Like, just please, sir.
Mr. Rivers, there's an easy way for you to not have those situations. To just do the right thing.
You're absolutely right. You're absolutely right. But the word is not perfect, sir. Like we do things, and some like you might be more fortunate than me to be in a better mental state. I'm not saying that what I did was right or wrong, or I did it or I didn't do it, but I totally wanted to address the situation, and like I just spent 10 months in here. I paid over $17,000 to get out the last time. I'm just kind of scrapped, and I'm right back in here for the same thing. So
it's actually not the same thing. It's based upon the same incident, but it's actually the same charge.
I'm sorry, same incident. I'm sorry.
So why didn't you have your lawyer just combine all of this stuff and deal with it at the same time?
I was speaking with him about that. He was saying that it wasn't really nothing he can do, because when we looked it up on the jail website, it was saying my name, so I was thinking everything was cool.
Well, I've given you my answer.
Please, Sean.
Mr. Rivers, I mean, you can sing me a song, but it's not going to change my mind. I see. This is a thing. When people's back is up against the wall, that's when they start wanting to pray to God.
No.
That's what you're doing right now.
No, it is not.
That's what you're doing. You said you were in here for what, 10 months?
Yes, sir.
Okay. When you went before the judge and you entered your guilty plea, you didn't say, hey, judge, look, this has been wearing on my heart. When I came in here, I used the name Dante McAllen, and that wasn't right, judge. And I just want to make certain that, judge, we deal with that right here and now, because that's the kind of person I am.
Well,
or did you believe that, well, hey, like you said, everything's cool, so I ain't got to worry about it?
But when I spoke to my attorney about it, we went to the Clayton County website and they had my name listed under it.
Well, the judge, you're on probation right now.
I'm on probation.
Okay, you can still go back for that judge and
No,
deal with this.
No, I'm asking you, you saying that I am on probation?
Yes.
Through who?
You said you have an ankle monitor on.
No,
what's the ankle monitor for?
That was for my bond. That was for my bond conditions.
So you haven't resolved the other case yet?
No, sir. That's what I'm saying.
So this still can get combined with that case.
Okay, and I just bonded out. I just bonded out from here like 2 months ago. That's what I'm trying to tell you. Like all of this is like really one incident.
So let me advise you of what you may want to try to do. Speak to your lawyer about having this charge brought before the judge that you're now facing. Have that judge set a bond on this charge, and then you'll get out.
Yeah, that'll be
Mr. Rivers, this is not supposed to be easy for you.
I understand, right? I understand, Your Honor. I understand, but just put yourself in my shoes. Like I know that's a bad statement to make, but like I just paid over $17,000 to get out of jail, cash. Like not a percentage of that. I paid $17,000 plus the ankle monitor and all of this, and now I'm facing another couple $1,000s that I don't have, and I don't want to like sit here for another 10 months. Like
I just told you what to do.
Please, y'all, any way you can drop it down, 5 or 10,000, please. Your biggest concern is that I'm coming to court.
No. My biggest concern is that I've looked at your criminal history. I've looked at the allegations contained in this warrant, and I believe that as long as you can skate by, you're gonna skate by.
No, sir. No, sir. No, sir.
Well, then prove me wrong.
If you can look
Go
at
talk to your lawyer. Go talk to your lawyer. Get this case transferred to the judge that's hearing the case, and get that judge to set you a bond.
How long do you think that'll take?
It could be today. It could be Monday. It depending on what the lawyer is doing. But this is the thing that I want you to understand, Mr. Rivers, is that from when I look at your criminal history, the only thing that's going to stop you from going down the path that I think you're going down is that it has to be made difficult for you.
No, sir. If you can look at my record before 21, it was absolutely none of these, no charges even close to that.
So how you get 12 cycles from 21 to 22? So you're telling me you had 12 interactions with the police in 1 year?
Yes, sir. Yes, sir. I lost my dad, my grandmother, my cousin, my child, and another one of my brothers, all in 1 year.
So what happened in 2017 when you were arrested in DeKalb County on a probation violation?
I wasn't on probation. If you look at it, it was non-process.
Okay, what is this? 2017 in Cobb County.
Yes, they charged me with possession of a firearm by convicted felon. I wasn't a convicted felon, and all those charges got dropped as well.
And possession of marijuana.
Yeah, I pleaded guilty to that.
Okay.
But
so you have been getting into trouble before 2021.
But it's nothing serious like this matter right here. I mean, possession of marijuana, Your Honor.
Which is why I said you're gonna skate by. Whenever someone says that a crime is really not that bad, that person is gonna skate by.
No, sir. And what I'm trying to get you to understand, I was charged with the possession of a firearm by convicted felon. And how did it go?
And possession of marijuana, less than an ounce.
Yeah, by convicted felon. So how did it go from that to
possession of marijuana less than an ounce is not connected to a convicted felon.
Okay, but the firearm was. But I'm just trying to get you to understand, like it's not like just reading it on paper. Of course, it's bad, but it's not that. Everybody makes mistakes, Your Honor. I'm just asking you to have a little leniency on me. It's not like
you when you make mistakes, you got to pay for it.
It's not like I'm making the same mistakes over and over, Your Honor. It would just I need some help.
All right, let's put Mr. Rivers to the side. We're gonna deal with Mr. Russell because Mr. Russell has to get out of here, Mr. Rivers. And I keep telling you I'm not gonna change your mind, but I'm gonna entertain you as long as you want to be entertained.
Excuse me, Your Honor. As soon as we're done with Mr. Russell, I had to escort him back to the infirmary.
Oh, okay. So, Mr. Rivers, you are free to go back. I'm not going to change my mind. And I told you to contact your lawyer, get this case transferred to the judge that's ultimately hearing your other matters, and that judge will be in the best position to set a bond. Okay? All right, Mr. Rivers can be released. All right, thank you. Okay, Mr. Rivers, sir, you're charged with, I'm sorry, Mr. Russell, sir, you're charged with 1 count of theft by taking as a misdemeanor offense. Bond is going to be set at $2,000. 1 count of driving a vehicle after you change your address, or not change your license, your address on your license after being at a location for more than 30 days. Bond is set at $500. And hit and run accident bond set at $1,500. You're going to have a total bond set at $4,000. These are all misdemeanor offenses, so you're going to have a preliminary hearing date set for May 10th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Are you currently working, Mr. Russell?
No, I just got out of school.
Okay. I'm going to find that you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me? Okay, you're free to go back. Now I understand Miss Kurt is ready.
Yes, Your Honor. Let me message Bush.
So, yeah, that's fine.
Do I take this off now?
No, yeah, it don't matter.
Good morning, Your Honor.
Good morning, ma'am. We actually just got into the afternoon.
Yes, sir. Good afternoon.
Okay, I need her camera to be on.
Hold on, let me try it.
Okay.
Camera's on, but still black. Oh, let me refresh
What's
the
the
page.
name of this person?
I'm sorry.
The name?
Peart. She's the person that was continued from yesterday.
Okay.
Okay, ma'am, this is your first appearance hearing before the Magistrate Court of Clayton County. My name is Brad Gardner. I'm a Magistrate Court Judge here. I am here just to tell you what you're charged with, to give you court dates, and to appoint a lawyer to represent you if that's what you want.
No, sir, I would want to appease the court and represent myself. I'm a certified paralegal. And I
Okay.
also have an attorney on retainer in New York City, Michael H. Aspinall.
Okay, so if you're a certified paralegal, you understand you have the right to the presumption of innocence, the right to,
Yes, sir.
in this case, accusation for misdemeanors, right to a speedy and public trial by jury.
And I would like to ask for a speedy trial as well.
Okay, you have the right to see, hear, and question witnesses who are called against you. You have the right to compel the attendance of witnesses to testify on your behalf. You also have the right to testify on your own behalf. And in this instance, you've said that you want to represent yourself, which of course is your right. You're charged with one count of family violence, simple battery. Bond is going to be set at $4,000. There's going to be, hold on, ma'am. I'm going to let you ask me whatever questions you want to ask me at the end. There's going to be a stay away provision on this bond to stay away from a Jalen Blackman. Do you understand that? Your preliminary hearing date is going to be set for May 10th at 8:30 in the morning. We say courtroom 201, but most likely it'll be by Zoom. Now, once you bond out, your case will get automatically transferred to the state court, to whatever judge will be assigned to hear your case. And so that May 10th date will get waived once you bond out, and you'll receive a new court date in the mail. Now, what was your question, ma'am?
What my question was, sir, Your Honor, is that Jalen is my husband. We're legally married, but we didn't tell our family because they want a big celebration for us. We're both the last child. This family violence incident happened because my landlord I know, sir.
Now, Miss Pert, and the reason that we try to stop people from
I understand what you're saying. I won't say anything. What I was saying is that.
No, ma'am, let me finish. This is being recorded. And so I know you want to represent yourself, and you haven't seen the evidence that the state may present against you. So if you're making statements, you may kind of box yourself in a corner before you even have an opportunity to see the evidence against you.
So I plead the fifth.
Okay.
Okay. What I was gonna say is I do have a follow-up on the April 29th pertaining to that case with Mr. Blackman. So if my court date was the next court date, May 10th would be waived, I was gonna say I prefer to just stay here till then, because I'm already gonna go into prenatal care after I prove I'm in my first trimester, and I really prefer, I feel like this is a safer place than outside right now, to be honest with you.
Okay.
And
that choice is yours to make, man.
Yeah, so you don't have to put a bond on my amount, but I will call my attorney while I'm in here to get the best advice, legal advice from him as well.
Well, because this is a misdemeanor offense, you're entitled to bond by law. So I
Yep.
would actually be violating the law if I don't put a bond on this.
I understand completely, Mr. Your Honor.
Okay. Is there anything else, ma'am?
No, but I was gonna ask, since I do have to bond out, what is the bond amount, including the tax, state and federal taxes? So I can get that to my attorney, because I'm gonna need the whole amount. So should you send me $6,000 to bond out?
Okay, ma'am, I can't answer your question if you start talking every time I start trying to answer the question. So the sheriff's department is required to add fees to this bond amount, and I don't have the fee schedule, so they will be able to tell you the final number.
Got it. So I will bond out, sir, and I do request a speedy trial.
Okay. Is there anything else, ma'am?
No, sir, thank you very much, and you have a great day, Your Honor.
You're welcome. You're free to go back. Okay, I think that ends the calendar for today.
Yes, Your Honor.
Okay. All right, thank you.
Bond court is a free service, but it takes several hours of my time every day. Less than 10% of Bond Court viewers hit the like button, and less than 1% leave a comment. If you want Bond Court to continue to be available on YouTube for free, then please hit the like button and leave a comment on all of my videos.
Your Honor,
Hi, good afternoon. Can you state your name and date of birth?
my name is Faris Abdul Jabbar, date of birth August 4th, 1959.
You're here for an out-of-county warrant from Orange County, the writ of bodily attachment for child support. You do have a purge of $1,000, okay?
Yes, I have.
Thank you very, I'm gonna point you to the Office of the Public Defender.
Okay.
That will bring us to our next person, who is Joshua Brannon, pardon.
He is in the hospital, Your Honor, and is not present.
All right, we'll reset this. That brings us to Justin Kozinski.
He is present and approaching, Your Honor.
Hi, can you state your name and date of birth?
Justin Kaczynski, 8/11/88.
Thank you very much. You have a out-of-county warrant from Lake County, a writ for child support with a cash purge in the amount of $928, okay? I'm gonna appoint you to the Office of the Public Defender. Next case I have is Sarah McLeod.
She is present and approaching, Your Honor.
How you doing? Can you state your name and date of birth?
Sarah McLeod, August 25th, 1988.
Thank you. You have an out-of-county warrant from Seminole County. At this time, it's for failure to appear for an arraignment reference, use of possession of drug paraphernalia. You did get a bond, and that's for $2,500. I'll put you to the Office of the Public Defender. The next person is Robert Baldwin.
He is present and approaching, Your Honor.
Hey, Mr. Baldwin, how are you doing today? You do have two cases with us today. First is a bench warrant, and that bench warrant is from Judge Nix Walker, and it's for the amount of failure to appear on a written promise for $0. Second case is for a bench warrant for failure to appear on a written promise. And that's from Judge Morencis, and that's $0 as well. Good luck, sir. I'll point you to the Office of the Public Defender. Do you want to be appointed today, or do you have an attorney?
I'd rather be appointed to the public defender's office. Do I have a date for my next court date?
Let me see. Good question. Madam Clerk?
For the 22 CF 672, next court date is May 3rd.
May 3rd.
Okay, thank you.
Thank you very much. Good luck. That brings us to Nathan Allen Spear.
Present and approaching, Your Honor.
Thank you. Good afternoon, Mr. Spear. How you doing?
All right.
Can you state your true name and date of birth?
Yes, Nathan Allen Spear, 11/4/87.
You are here on an amended violation of probation, on that violation of probation for community control or probation, and that's set at a $0 bond at this time. And I'm going to point you to the Office of the Public Defender unless you have an attorney of your own. Mr. Spear, would you like to be appointed to the Office of the Public Defender today?
Sure, that'd be fine.
Thank you very much. Good luck. Next case I have is Jorge Efren Vasquez, Jr. afternoon, sir. How are you doing? Can you state your name and date of birth?
Jorge Vasquez, 9398.
Thank you very much. You were here as you were have an amended violation of probation. At this time, sorry, this is a little different. Doesn't look like a bond is being issued at this time.
It's a VOP,
Yeah, I don't see one. So at this time, there's no violation of, pardon me, based on the violation of probation, there's zero bond at this, there it is. There's zero bond at this time. And I will provisionally appoint you to the Office of the Public Defender, unless you have an attorney of your own.
No, I got an attorney.
Okay, thank you. Latrevious Lachar Lunette,
He is coming from the back, but he is present and approaching, Your Honor.
thank you. Do you know if Yamil Eduardo Ortiz Galares is available today? That was a reset.
One moment, Your Honor. Yamil Ortiz Galarza, Your Honor?
No, that's the one, the Spanish interpreter. He's here though. Thank you. Never mind. Latrevious, can you state your name and date of birth? I got it.
Latrevious Lunette, February 13th, 2002.
Good afternoon, sir. You were here as you were charged in a violation of probation for battery on a law enforcement officer and battery, pardon me, an order violation of condition number 5 and violation of condition number 5, which is being arrested for a new criminal offense. There's a no bond from Judge Karsten. Good luck.
Your Honor,
Can I provisionally appoint, I think he's already appointed to the Office of the Public Defender.
he is, Your Honor, and he has also informed me that he was pretty sure that he was on initial appearance on this when he was transported here from Polk County.
Like, I got transferred March 31st, and I had been signed the warrant, and I got transferred March 31st. I got a hearing May 3rd already with my
Okay.
judge.
You can just always address that with the judge. So I don't worry, if that's accurate information, then they'll make sure that they address that. I do see here that you were arrested in Polk County and booked in Polk County, so that could definitely be true, okay?
Yes, Your Honor, thank you.
I'm gonna appoint you to the Office of the Public Defender. William Enrique Ortiz Ceballos,
He is present and approaching, Your Honor.
thank you.
Good afternoon, Your Honor.
Good afternoon, can you state your name and date of birth for me, please?
William Ortiz Ceballos, 1483.
Thank you. You were here as you were charged with the violation of probation and violation specifically of condition number 5 of living without failing any new law. And that happened twice. At this time, there is a no bond issued by Judge Nix Walker. And you're already appointed to the Office of the Public Defender, okay?
Okay, ma'am.
Thank you very much.
Thank you.
That brings me to Tyler Clement.
He is present and approaching, Your Honor.
Thank you very much. Name and date of birth for me, please, sir.
Tyler Clement.
Mr. Clement.
50994.
05 May.
Yes, ma'am.
Thank you very much. You were here as you were charged with burglary and an occupied structure unarmed and grand theft. After reviewing the charge and affidavit, I do find there's probable cause for both of those charges. Do you request to be with a public defender, or would you like to have an attorney represent you of your own?
A public defender, please.
At this time, I'm going to provisionally appoint you to the Office of the Public Defender, and at this time, defense, would you like to be heard on any issues?
Your Honor, just that Mr. Clement is eligible for direct PTR, so we would ask that he be placed on direct PTR at this time.
Thank you, State. Would you like to be heard on any issues?
Well, Your Honor, the state would just object to PTR based on the nature of the charge. The state would ask that a reasonable bond be set at this time.
And I'm going to give him PTR, just to decide whether it would be a PTR with the bond, a PTR, and the direct order. Pre-trial release, I do see that he's eligible for direct PTR. Can you give me some history?
Yes, Your Honor. In 2020, September 2020, he was found guilty for
carrying concealed weapon, marijuana possession, weapon offense, drug possession, driving without a valid driver's license. In 2021, he was found guilty for an FTA, a VOP. He also had a petty theft, which
That's what I need to hear. You said an FTA, a failure to appear?
Yes, ma'am.
All right, you can continue.
And the possession of a controlled substance in 2021 as well.
All right, thank you very much. Based on that failure to appear, I'm going to go ahead and issue PTR with a bond. The bond will be as follows. Burglary of a two-occupied structure unarmed at $1,500. Grand theft, $75, less than $5,000 at $500. Special conditions in the release, don't go to the Dunkin' Donuts, it looks like it was. And I don't see the address of the said Dunkin' Donuts, I'm so sorry. Let me see here. You see it?
Yes, Your Honor, 7551 Osceola Pope Line Road.
Perfect. Don't, you know, you know that Dunkin' Donuts, sir. Don't go to that Dunkin' Donuts, all right? All right. My, Mitchell Feaster. Good afternoon, sir. Can you state your name and date of birth for me, please?
Mitchell Feaster, 47280.
All right, Mr. Feaster, you were here as you were charged with a trespass. I did find probable cause of the trespass after reviewing the charging affidavit. Do you want to be appointed to the Office of the Public Defender? State, defense, pardon me. With that being said, defense, would you like to be heard on any issues?
Just, Your Honor, that he is eligible for direct PTR. We would ask that he be placed on direct PTR at this time.
All right. State, would you like to be heard on any issues?
No, Your Honor.
All right, this time, based on the initial appearance information sheet, officer, it does look like he qualifies for the direct PTR. Is that accurate?
Correct, Your Honor.
This time, Mr. Feaster, I'm going to, based on the circumstances and the nature of this trespass, I'm going to give you direct PTR with no monetary bond. Please don't return. Let me just say this again, because I don't know. Maybe you don't. You cannot go to the Wawa located at 3140 Vineland Road, Kissimmee, Florida, 34746. Do you understand that? It seems like every time you go there, there's problems. So if you go again, you already know what's going to happen, right? Heard. Have a great rest of your day. Nikhil Harper.
Yes, President approaching, Your Honor.
Oh, wow. Is this all Nikhil? Oh, no. Hey, Mr. Harper, how are you doing today? Can you state your true name and date of birth?
Nikhil Harper, November 1599.
Okay, it looks like you were charged with written threats to kill or bodily injury, domestic violence related. I did find that there was probable cause based on reading the Osceola County Uniform Charging Affidavit. Defense, I can appoint you to the Office of the Public Defender if you would like.
Yep, public defender.
Or public defenders, okay?
Public defender.
Okay, so that's a yes. So at this time, defense, would you like to be heard on any issues?
Just, Your Honor, that the nature of what is in here seems pretty circumstantial, given that.
I wanted to know if you wanted to do a probable cause challenge. I mean, you can do that. I've done that plenty of times.
Yes, Your Honor. I do think that there may be a probable cause challenge here, just based on the arrest affidavit. The officer stated that the number where the text came from was not the number that he had on his phone. He did not have any communications with her on his phone from April 7th. And though he had an app that allowed him to do free text, there wasn't anything in there that showed that he had been using it. We would ask for ROR at this time in this matter.
Thank you. And given the fact that she recanted on some of those things. State, I'm going to read the actual, I mean, I think they could have charged us different, but I'm going to read the actual charge as well on the record. Do you have any response?
1 second, Your Honor.
No worries. And they charge this, they mean, the police officer charges as written threats to kill or bodily injury. I'm going to read that statute in just one moment. I should be able to just spit this out. Just had this. My laptop.
So, Your Honor, the defendant sent a message to the girlfriend saying, something happened, you dead ass killed my baby, I'm finna be on the way now.
The issue though, so the way they charged this is that based on the statute, you have to, do you find or do you see where that text message actually came from the defendant's phone? That's the,
I see what you're saying.
that's the only, the way they not your fault, the way it was written on this specific Florida statute. And I am sorry, everybody, I'm using the old school way because I didn't bring my laptop in. Give me one moment, I can just pull it up. It's statute 836.10.
So the defendant used a application that's text-free, which allows him to use a different number. I believe that with additional evidence such as probably a subpoena from that app, and we could figure out that it was the defendant who in fact sent the messages to the victim.
All right.
Your Honor, defense would counter that with, because, you know, if the state would needed additional information to be able to find probable cause that he was the actual one who sent these text messages and they were actually from his phone, whether it be an app or whatever, then there's no probable cause within the four corners of the charging affidavit to charge him with this.
So I'm going to read from the statute, thank you, 86.10, as used in this section, the term electronic record means any record created, modified, archived, received, or distributed electronically, which contains any combination of text, graphics, video, audio, or pictorial representation in digital form. It does not include a telephone call. It's unlawful for a person to send, post, or transmit, or procure the sending, posting, or transmission of a writing or other record, including electronic record, in any manner which may be viewed by another person when such writing the person makes a threat to kill or do bodily harm to another person, or conduct a mass shooting or an act of terrorism. And so at this time, I don't find from the four corners that there is probable cause. However, I will give the state an opportunity to do so within their 24-hour period.
Thank you.
All right, so at this time, I will release them on an ROR and give the state 24 hours.
Thank you, Your Honor.
Thank you. Good luck, sir. Kevin Gray, and if I haven't already, provisionally appoint you to the Office of the Public Defender. Sir, come on back up here for a minute. Now, Mr. Harper, I can't order you not to have any contact with this person, Diamond Rojas. However, it would probably be smart not to have any contact with her at all. Use your own judgment to do so, but just because I found an ROR, no probable cause here, doesn't mean like the police can't do other things if called. So I probably would not contact her or stay around her at this time during this small period of window. But do whatever you want. Good luck, your life. Kevin Gray, 20.
He has posted bonds.
Oh, perfect. Thank you.
You're welcome, Your Honor.
There's 4 of them right there. Kevin Gray again. Jose Navarro Rivera.
He is present, and Your Honor, he will require the services of a Spanish interpreter.
Those are the 2. Ron Royal.
He has posted bond, Your Honor.
Coraline Vanderlewis.
She is present and approaching, Your Honor.
I'm always so impressed by how the clerks just know names so well, and it's very impressive, actually. Good afternoon, ma'am. How are you doing today? Can you state your name and date of birth for me? Thank you. You were here as you were charged with resisting without violence and also for driving while license revoked as a habitual offender. Sorry, a failure to appear on that charge. Did someone give you, did they order $5,000 for the failure to appear? For the driving while license revoked? Is that what this says? Okay. So I'm gonna give you a bond on mine. However, this is initial appearances.
What case is this, Judge?
Yeah, it's 21 CF 2123. It looks like that's why I had to look at it twice. Is this a violent offender? Okay. So ma'am, it looks like you didn't appear at a court date. And the judge, Judge Karsten? Judge Karsten set you a bond at $5,000 for failing to appear at your status hearing. Okay? But you got a bond on that one. Then you're here for resisting an officer without violence. I did find that there was a probable cause after reviewing. Do you have any PC concerns?
One moment, Your Honor. Your Honor, I would defer to the court's judgment as to whether or not there are PC concerns here.
It says that both persons advised that Corlin was not inside the residence. And I want to go through that statute again, 84.02, 84.3.02. And of course, I'm going to have state you have an opportunity to argue. And I'm going to redefine the resisting an officer without violence, whoever shall resist, obstruct, or oppose any officer. And then they define officer. Resist, obstruct, or oppose. I'm not sure here where they were definitely concerned that she ignored the announcement. Since it says here that she's heard it, she was scared, and then she came out.
Yes, Your Honor.
She believed somebody else to be her mom's boyfriend coming to harm, and then as soon as she realized it was them, she came out. So, state?
So, Your Honor, this defendant has a capias that was issued from March 4th, and the officer was going to effectuate the felony warrant he was in, which shows that he had a legal duty to be where he was at. He gave a legal command for the defendant to come out from the residence. She did not, and her statement says that when she was inside the vehicle, she spontaneously uttered that she could hear us, but advised she was scared to come out. So by the defendant's statement that she heard...
Read the next line, though. She advised she believed she was the mom's boyfriend coming to the house to cause harm. She didn't understand that it was the cops.
Yeah, yes, Your Honor, but I would say that that statement could be subject to cross-examination, and if Your Honor believed the defendant, then I guess no PC could be found, but at the state...
I do. I believe the defendant. At this time, I'm going to state that there was no probable cause within the four corners of this document based on 84.3.02, specifically that the resisting of the officer had to come by a obstruction or opposing any officer. She was inside the house. She came out of the house. And then she told them spontaneously that she did hear them. She was scared. She told them the reason why that she was scared. Prior to that, there was no information. They knocked a couple of times and they yielded negative results, but ultimately she didn't resist coming out. She came out. And so I'm going to go ahead and find there was no PC for that specific charge. However, you do have a failure to appear from Judge Karsten for $5,000. Good luck, ma'am.
And
Is there another case? It says open legal constraint. PTR?
That's the FTA.
Heard. State, I'm sorry.
You know, there's one case that I wanted to recall. Give me 1 second.
Of course. The written threat one?
Yes. So
wait,
on that one, you gave a 24-hour reset, but the defendant was released. So then technically the 24-hour reset wouldn't really apply because he's already released at this point.
You're right. Directly ROR then. No PC. Sorry. We might, give me a moment. Heard on you for, I understand what you're saying now. So at the end, he has some arguments about that. So at the end, we'll just recall that case, okay? Let me just hit these other, we only got 2 left. Let me hit the other 2 and then we can go back over that. Fair? Edward Zibley.
He is present and approaching, Your Honor.
Hello, can you state your true name and date of birth?
Edward Raymond Zebley, January 2nd, 1967.
All right, you were here as you were charged with a trespass after a warning. After reading the Osceola affidavit, the Osceola uniform charging affidavit, pardon me, I did find probable cause. Do you want to be requested to go to the Office of the Public Defender? Do you have your own attorney?
No, I'll take public attorney.
All right, at
I
this
mean,
time.
not public,
She's from the, so you can't just take her. She's from the Office of the Public Defender.
Yeah, Office of the Defender.
All right, that sounds good to me. And so I'm going to provisionally appoint the attorney who's standing next to you to the Office of the Public Defender's Office of Defense. Would you like to be heard on any issues?
And just, Your Honor, that at this time, Mr. Zebley is transient. Even with the lowest possible monetary bond, it would be out of his means to be able to bond. We'd ask for ROR.
Being transient ROR means I don't know if he's gonna come back.
Oh, yeah, I live here now.
I'm not gonna be able to give you a court date. Madam Clerk, is there any court dates I can give him right now? So you're gonna come back to what?
Yeah. Well,
But-
it ain't for nothing but trespass.
But the date that I would give you would come in the mail. So that's my problem with that. Just give me 1 moment. State?
Your Honor, the state would object to ROR just because we've already placed on the record defendant is transient. The purpose of a bond is to assure that the defendant will return to court and protect the integrity of the judicial system. So the state, based on the defendant's status, and I do not have his criminal history right now, but the state does not believe the defendant's a good candidate for ROR.
Agree with the state. PTR, can I have some history, please?
Yes, Your Honor. He has a combined history of 85 prior arrests, dating back to 2004, most of which are involved trespassing and county ordinances.
Any failure to appears?
He has, let's see. No, Your Honor.
No failure to
He
appears.
does have a active warrant though, out of Baker County.
Out of what county? I'm so sorry.
Baker County?
Georgia?
Yes, ma'am.
Okay, so I won't be able to do anything with the Baker County, Georgia.
Yeah.
Open active warrant. However, I am gonna give a bond. I'm gonna give a bond of $250 for the trespass after warning. I'm gonna have you not, special conditions of any release. Please do not return to the scene. And that is on, can you say it on the record, please, Madam Clerk?
Town Coral Shopping Plaza at 1332 North John Yan Parkway. You can see me further.
All right, don't return there, okay, Mr. Zibley?
Huh?
Don't return there.
Where's that?
I'm gonna say it again for you.
This is on.
John Young Parkway?
Coral, specifically, is a shopping plaza, and that's Town Coral Shopping Plaza.
Oh, okay.
All right?
Yeah, I know what's that.
All right, sounds good to me. Thank you very much. Good luck. Eduardo Ortiz Galares. I gave you a $250 bond. Eduardo Ortiz Galares.
Your Honor, he's detoxing. He's not here at the moment.
All right, so he has two cases. Let me see, make sure that's the same person. Okay, he was reset, so he'll be reset again. All right, can I get the two people that need a Spanish interpreter, please?
It would only be George Navarro Rivera.
Yes.
That's the only one.
Hola, ¿cómo estás? Un momentito.
Good afternoon, Your Honor. This is Laura Bretaña, Spanish interpreter, previously sworn.
Afternoon, we're on 22 CT 1222. His name is Jorge Navarro Rivera. We are in IAs today, so you're going to be in an open microphone.
Okay.
Can you state your name and date of birth?
Señor, por favor, diga su nombre y su fecha de nacimiento.
Jorge Luis Navarro Rivera, 1 de abril de 79.
Jorge Luis Navarro Rivera, April 1st, 1979.
Thank you. You were here as you were charged with driving while license suspended or revoked.
Usted se encuentra aquí, señor, porque se le acusa de conducir con la licencia suspendida o revocada.
At this time, I'm going to appoint you to the office of the public defender. Do you want that attorney, or would you like to have your own private attorney?
Señor, yo le voy a designar el abogado de oficio para que les represente. ¿Usted desea ese abogado o acaso prefiere contratar uno privado?
Sí, prefiero el public defender.
Yes, I prefer the public defender.
Okay, thank you. At this time, I did find probable cause after reviewing the charging affidavit. And based upon that, I'm going to provisionally appoint you to the office of the public defender. And thus, would like to be heard on any issues, defense?
Señor, determinó que existen indicios de criminalidad. Se le designa provisionalmente el abogado de oficio para que les represente. Ahora le pregunto a la defensa, ¿desean ustedes expresarse en cuanto a algún asunto? No, su señoría. No.
Okay. At this time, I'm going to, PTR, would you like to be heard on any issues?
Ahora le pregunto al programa de libertad provisional, ¿ustedes desean expresarse en cuanto a algún asunto?
Yes, Your Honor. He's currently out on bond in the same offense in 22 CT 1123, which he bonded out, looks like the 21st of this month. He was originally charged on the 18th.
Sí, su señoría, él ahora mismo se encuentra libre bajo fianza ante una acusación, la misma acusación en el caso 2022 CT 1123. Él se le concedió fianza en este caso y salió ayer. La acusación original se remonta al 18.
I apologize, the 20th.
Le pido disculpas a su señor, él fue puesto en libertad el 20.
Thank you. At this time, State, would you like to be heard on any issues?
Muchas gracias. Entonces ahora me dirijo a la fiscalía. ¿Ustedes desean expresarse en cuanto a algún asunto?
Your Honor, based on the information that was just provided, the state would ask that you find probable cause for the new arrest and hold defendant at a no bond status in his prior case pursuant to Parker v. State. Looks like this defendant was arrested for duelist the day before, who posted bond, and he has a second case where he was arrested right after.
Su señoría, según esta información que acabamos de recibir, estamos de acuerdo en que existen indicios de criminalidad. Ahora le estamos solicitando que se le imponga prisión preventiva. Esto según el caso Parker en contra del Estado. Este acusado fue puesto bajo arresto por conducir con la licencia suspendida el día anterior, fue puesto en libertad y luego inmediatamente arrestado por el mismo ilícito.
Your Honor, for the court's record as well, he has 2 prior FTAs in 2021, one in August and one in December. He also has the same offense in July of last year.
The same offense of driving with license suspended and revoked?
No motorcycle endorsement.
Or-
Su señoría, también quiero dejarle saber que tiene 2 faltas de comparecencias anteriores en el 2021, una en el mes de agosto, la otra en el mes de diciembre por el mismo ilícito. También fue arrestado en julio de este año por conducir con la licencia suspendida, por conducir una motocicleta sin tener la debida autorización.
Defense, would you like to be heard on any issues based on what you just heard?
Ahora le pregunto a la defensa, ¿desean ustedes expresarse acerca de algún asunto según lo que acaba de escuchar?
Defense would ask that you take no action on the open case, Your Honor.
La defensa le solicita a su señoría que no tome acción en cuanto al caso que está pendiente.
State?
Yes, Your Honor, I just want to briefly clarify some things for the record. So, this defendant, in 22 CT 754, he was arrested on March 9th, 2022 for driving while license suspended. In case number 22 CT 1123, he was arrested on April 18th, 2022 for driving while license suspended.
Give her a minute to translate that.
Sí, su señoría, yo quiero clarificar algunas cosas para las actas. Este acusado, en el caso 2022-CT-754, fue acusado de conducir con la licencia suspendida el 9 de marzo del 2022. En cuanto al caso 2022-CT-1123 del 18 de abril del 2022, también se le acusa de conducir con la licencia suspendida.
And finally, the case that is before Your Honor today, 22 CT 1222, the defendant was arrested again for the same offense, driving while license suspended. So based on the defendant's inability to follow the law and probable cause being found on this offense, Your Honor, the state would ask that you revoke his bond in 22 CT 1123 and 22 CT 754.
Entonces, su señoría, el caso del día de hoy es el 2022-CT-1222. El acusado nuevamente fue arrestado por conducir con la licencia suspendida y debido a la incapacidad del acusado de cumplir con la ley y de haberse encontrado que existen indicios de criminalidad para su arresto. Ante este caso, nosotros le solicitamos a su señoría que revoque la fianza que se le concedió en los casos 2022-CT-1123 y 2022-CT-754.
This time I'm going to find on 22 CT 1123, no bond. Revoke any previous bond, enter no bond on the 22 CT 1123. Driving while license is revoked. Sir, you can't drive without a license.
Bueno, entonces en cuanto al caso 2022-CT-1123, se revoca la fianza, se impone prisión preventiva ante la acusación de conducir con la licencia revocada. Señor, usted le queda prohibido conducir sin licencia.
In addition to that, the failure to appear that the pretrial release officer has given me is also indicated for me to issue a no bond on that case as well, and the determination of what bond amount I'm going to make in this current case, pardon.
Bueno, entonces también la información de las faltas de comparecencia que me ha provisto el oficial del régimen de libertad provisional han hecho que yo tome la decisión de revocar la fianza y de la cantidad de la fianza que impondré en el caso del día de hoy.
And for the bond for the current case is $500.
En cuanto al caso de hoy, la fianza son $500.
Doesn't sound like you've been following the rules, but don't drive without a valid driver's license. It's a special condition of your release.
Señor, por favor, no parece ser que usted vaya a cumplir con las leyes, pero por favor, no conduzca con la licencia suspendida. Esa es la condición de la fianza del caso actual.
Good luck, sir.
Buena suerte.
I don't know if I said it, but I'm going to provisionally appoint him to the Office of the Public Defender.
No sé si lo había mencionado anteriormente, pero se designa provisionalmente la oficina del abogado de oficio.
Thank you very much. Have a good rest of your day.
Enjoy your weekend, Your Honor.
You too. No, Rico, wait. State wants to recall Harper Nikel, 22 CF 1155. Thank you very much, officer in Osceola County Jail, or corporal. Thank you very much for keeping me safe today. All right, let's see here. So they want, I'll let state.
Your Honor, I just would like to clarify. So on this case, no PC was found, ROR was granted. However, the court did provide the state with a 24-hour reset for additional evidence. The state at this point would just ask to strike the 24-hour reset for additional evidence since the defendant was granted on ROR.
Thank you. Good luck, sir. Wait, can I hear some, before I make that decision, can I hear some history?
1 second.
So, Mr. Harper, they know about this text messaging thing, so I don't know if what you're doing with this text messaging app, but obviously it's like Snapchat. You think it delete, but it don't.
All right.
You don't have to make any, please don't make any comments.
Your Honor, in 2018, he was charged with a carjacking. He's currently set for a comp hearing on 5/18 in front of Tom Young, sorry. He had a battery in 2018, which was dropped as well, and a simple assault in 2019, which was dropped. That's all.
Good luck, sir. Yes.
And Your Honor, if there's no PC, the history is.
Well, I just want to know for myself.
Okay.
Before making these determinations, because I'll be the person on the news.
Oh.
Sorry. All right, sir. Mr. Harper, make sure you have no contact. No contact means no contact, all right? I can't order that for you, but it would probably be the best interest for you. Have a good day. Have a good day, guys. Good to see everybody. Great job, state. Great job, defense. Have a great weekend.
Thank you. You too, Your Honor.